to go ahead and get started. Sorry for the delay. I was just trying to give more people have a chance to get in this morning. So, and I hope everyone got a chance to enjoy that wonderful breakfast that's out there. Not your typical seminar breakfast. So it's actually pretty good. I'm Tamara Brooks. I am co-chair of the residential real estate seminar committee. Also, we're part of the executive committee, of course. So we put this on every year. This is my second year doing it. And then my other co-chair, Kirsten, will be up here this afternoon, helping on the afternoon speaker with the afternoon speakers. So just a little housekeeping. We are Zooming this. So if you know anybody that couldn't make it but they just want to listen in, they can. We've also decided we're going to record. So if anything you missed or whatever you want to see it again, it's going to be available later on as well. We didn't have that set up, but there was a lot of requests for it based on the topics. So we wanted to make sure that anyone that wanted to rewatch it or anyone that couldn't be here today, that at least they could have an opportunity to see it and feel like they're participating. So we'll go ahead and get started with our first speaker. Many of you probably already know her. She's a powerhouse in the industry, been in the industry for 20 years. It's like, so I'm going to introducing Catherine Oates, and she is a partner at Wiseman, where she's been there for about 3.5 years. She oversees operations of the firm's residential closing practice, which includes professional development, support and growth of brokerage relationships, and development and implementation of systems to maximize efficiencies and customer service. She is also a member of the executive committee with me, and she serves as the chair of the ethics subcommittee. She also serves on the board of directors of the Georgia Real Estate Closing Attorneys Association, where she is vice president. They do have a table out here as well. So for Greca, if you have any questions or you're interested in membership, Catherine would be a great resource for you. They have meetings 6 times a year, quarterly, and yeah, every other month. And it's at Maggiano's, so definitely come. It's a great meal and great networking with like-minded folks. She has also served on boards of multiple other industry-related organizations and nonprofit organizations. And she is also the co-author of Done Deal, a real estate agent's guide to mastering negotiations, and working on an updated Red Book. So without further ado, I'm introducing Catherine Oates.
Thank you, and thank you for not reading that all verbatim. Well, good morning, everyone. As she mentioned, I'm Catherine Oates with Weissman, and I presume by this time, any of you who actually do residential closings have probably already taken one, if not more classes, and even taught classes on the 2025 changes. When I teach attorneys, I do it a little bit differently than when I teach real estate agents, of course. And one of the things I like to bring to you all, because I know a lot of you do teach, is I want to make sure I'm addressing the questions we get from agents all the time. And the questions we're getting through the GAR legal hotline, things of that nature. That's where a lot of the changes come from. So if there's new legislation, if a court case comes down, questions coming through the legal hotline, those all lead to changes that are brought to the GAR Forms Committee. Then anybody who has a suggestion or a question can also reach out to the GAR Forms Committee, and it will go on the agenda. And sometimes they say, no, we're not going to make that change. Sometimes they do make the change, lots of subcommittees, but everyone is allowed to go to the Forms Committee as a guest. And what I will tell you is those individuals work so very hard. And, there's the main meetings and then subcommittee meetings. And so we see a lot of people who sometimes get frustrated that there's so many changes. But I think with every little change we make, something new comes up that we also need to update or change. And we'll talk about some of those things because that's already started happening. So to begin, we'll talk about some of the universal changes. Starting with the mid-year changes, 2024, you saw the transition from commission to compensation. I think we've found all of the instances of the word commission. But if not, and you find one, reach out to me or reach out to GAR and they can get that updated. The idea was really started by NAR based on the NAR settlement, and compensation obviously suggests that it is um, money being given in exchange for services, not simply, just getting a percentage or something of that nature, though compensation typically is a percentage. But the idea is it is, something in exchange for a thing of value and you're being compensated for it. And so that's why that transition has begun. You're going to also see there is a transition from sales price to purchase price. Now, right now, that transition is only taking place in the brokerage engagement agreements and the compensation agreements. We may see that transition through the remainder of the forms, but right now, the purchase and sale agreement says that those two terms are interchangeable. And I don't think there's necessarily a reason why they've chosen one term over the other beyond just trying to standardize things. And you'll see this year, there are also a lot of other instances of where they're really trying to standardize things throughout the forms. Statute of limitations has gone down from 2 years to 1 year for any claims against brokers. And then we have this new box, and you can see it there, and it's highlighted in orange. That is a box that has now been added above all of the signature lines in all of the GAR forms. And the people in this room will probably appreciate this language more than any other change. And I know a lot of us at Weissman do. And that is that it is instructing agents, hey, when you are signing as an entity, when your clients are signing as an entity, or your customers are, they have to sign with their actual capacity. We see so many times where people sign ABC LLC, and then you have to go through the whole, do you even have a contract at this point? Excuse me. And so just a little bit of encouragement to folks on how to sign. Now, one thing we are seeing, however, is again, with every change, there is sort of a repercussion to it. And that is that some of the agents have started signing in their LLC names and putting their title based on how they earn their compensation. And what we have to continuously remind the agents of is that you have to sign exactly as you hold your real estate license. You can't sign, Catherine Oates Homes. I can't sign Catherine Oates as manager of Catherine Oates Homes because that's not how I hold my license, right? I would have to sign exactly as we have it. When we teach that, what some people come back and say, oh, well, I go by Kate. I don't go by Catherine. And I always sign Kate. Well, how do you hold your license? If you hold it as Catherine, you must sign as Catherine and not as Kate. So that is something agents routinely do incorrectly. And so it's always a great reminder when you all are out there teaching to remind agents of that. And if y'all have questions as we go through, please just pop your hands up and I am happy to answer any of them. The definition of broker was modified, and it's just a slight change. And it's just talking about if there is a separate definition of broker somewhere, then that would obviously control. And there's really only one form where that matters, and that's the pre-showing compensation agreement. And we'll talk about that in a few minutes. The GAR forms language was also revised this year, and it was pretty much all revised to really clarify how the forms must be used, the license, and also to say, hey, the form may not work for your particular purpose. We don't know how a judge is going to interpret every single provision in the GAR forms. So use at your own risk, get your own attorneys to look at them, etc. Special stipulations. Now, this one has been causing a little bit of confusion. So I want to remind folks, this is a special stipulation that can be added to the amendment to address concerns. It is not part of the amendment to address concerns. It is not a new stipulation. This stipulation was simply changed this year because what we saw was that the previous version said, hey, if you don't accept my amendment to address concerns, then upon the expiration of due diligence, this serves as our notice to terminate. Well, once the amendment to it, or once due diligence expires, buyer no longer has the right to terminate. So they had to modify the stipulation to close that little loophole, even though I think everyone knew what it meant, knew what the intent was. They transferred it to say, if seller doesn't accept the amendment to address concerns within 2 minutes of the expiration of due diligence, then this serves as notice effective 1 minute prior to the expiration of due diligence. Now, if you are using this stipulation, the question comes up, what happens if the seller counters? Is that an automatic termination because now they have not accepted it? And arguably it could be, but I think if a buyer actually signs the counter offer to that amendment to address concerns, I don't think a court would overturn that and say you don't have a contract. But it might be a good idea. And one of the things we, try to tell agents to avoid disputes down the road when things get hairy is, if you're going to do something like that, it might be a good idea for a buyer to say that the notice is withdrawn, or that they agree to reinstate, or something of that nature, just so that there is no argument down the road. Consumer brochures. There is a new brochure this year, and this is about the new bill that talks about non-resident aliens, which are defined as agents of foreign adversaries. So if there is a foreign adversary of the United States and the person is an agent for that government, they cannot own agricultural land or land within 10 miles of a military base, installation, or airport. This provision is important for realtors because the bill says that the realtors must explain the restrictions and all the information about this bill. Now, they're not attorneys. We don't want them practicing law, yet this bill puts that on them when they start having to interpret the bill for other people. So what the Forms Committee decided to do is create this pamphlet that the broker can give to a client who may be subject to this bill, and that will take care of it. Now, this language is also in the lot purchase and sale agreement, the land purchase and sale agreement, brokerage engagement agreements. And basically it says, if you are an agent, a non-resident alien, meaning agent of the foreign adversary, you cannot have a possessory interest in the property. Now, the bill only requires real estate agents to talk to purchasers and sellers, but it is, questionable based on what a possessory interest is as defined in the code. That would technically be people renting as well. Now, do you really see a lot of renting of agricultural land? Well, you might if they're mineral rights and things like that. Some people are asking, well, doesn't this create a fair housing issue? The bill says plainly on its face that it does not, but we all know just because the bill says it doesn't mean that's how the Supreme Court would interpret it. There is a similar bill in Florida that I know is being challenged. I'm not sure how that one came out. So we'll have to see how this plays out over time. What we're telling agents is the best bet is never ask someone, hey, where are you from? Let's not go down that road. Instead, just say, if you are buying the property that is subject to the bill, provide them with the disclosure and be done with it. You don't have to ask them where they're from. You don't have to ask them if they're an agent of a foreign adversary. Just provide the details to them based on the property versus based on the person, and then you won't get into trouble. The bill does not apply to residential property. So if the land is being purchased for somebody to live in it, then that's okay. And it's not subject to the bill. Where it gets a little confusing though is, and we really haven't seen this play out yet in court, is, okay, you've got 150 acres and on 1 acre there is a house, but the rest of it is truly agricultural. Maybe it's timberland and it's being used for commercial purposes. So does it fall within the bill or does it not? Are there multiple tracts that have been put together? Are they separate? What portion of it applies to the bill? What portion doesn't? So those are all the types of questions that we'll have to see how courts interpret that. What will be interesting as well is that anyone who has a current possessory interest has to get rid of it by 2027 if they are subject to this restriction. So, and anyone who intentionally violates it, that uh, whole transaction can be reversed. So that could also create a title insurance issue at some point. So we don't know how these things will be interpreted down the road, but that's where we are right now. And that's why GAR has made this change. In 2024 mid-year changes, they did start adding this language. And to the places where that language already existed in the forms, they have added, and you can see there I highlighted it on the bottom on the left, where it says agricultural and land within 10 miles, because people were interpreting it just as land within 10 miles of a military base, but it's all agricultural land and land within 10 miles of a military base, installation, airport. Purchase and sale agreement. So the first change was one made at the 11th hour. And it's actually one I asked for. And what the language said before was that earnest money should be delivered in the method acceptable to holder of immediately available funds. Well, those are two very different things, because I might accept an ACH, but that's not immediately available funds. ACHs can be reversed for a very long time. And what we saw happening is, a lot of attorneys have ACH earnest money portals, and buyers will breach the contract after a month, and they will lie to their bank and say they never initiated the transfer, and the bank will reverse it, and the money put through those ACH portals is gone. So that creates a problem. So what we tell agents is, if you don't want somebody to write a check or send an ACH, you need to use a stipulation saying that earnest money will be delivered via wire transfer. That is the only way to get immediately available funds. We all know the good funds law. That's why we required cash to close to be a wire, of course. They also added this language about leases. And this is causing confusion because people think all of the lease language here is new, and it's not. What it has always said is that the seller must deliver good and marketable title subject to various things, one of which is any lease specified in the contract. Now, how exactly do you specify a lease in the contract? Does that mean just have a passing reference to a leased HVAC system in a seller's disclosure? Is that sufficient? Do you have to actually attach it as an exhibit? It doesn't really go into that sort of detail, but if it is specified, and I usually tell agents to stipulate it and even attach it as an exhibit, then it does not terminate. And obviously, we all know in this room how leases work. And just because you sell the property, the tenant still has rights. And so it's important for agents to realize that as well. The proration section, simple change here. This is just clarity. The way prorations work has not changed at all. This is just going into greater detail for people who are struggling to understand the paragraph. You will find that there are a lot of places in the GAR forms where there's a lot of extra detail that seems extra wordy, but it's again based on questions we get through the legal hotline, things that we see people struggling with into the industry. When we have to go back and correct prorations after a closing, sometimes people don't understand. They don't understand that language. They don't understand the language, on the, attorney's forms. So just a little more clarity of exactly what that means. This one is kind of an interesting change, and we'll have to see how this plays out. This is about the 8-day unilateral extension of the closing date. And so this is really the only place I know of in the GAR forms where timing stops at a given hour that is not 11:59 p.m. What this says is that if a party wants to unilaterally extend the closing date for 8 days, they must do so prior to 8 p.m., meaning they must do it by 7:59 p.m. on the day of closing. Now, historically, when I've taught agents, I have always said, hey, remember, if let's say a buyer can't close, lender doesn't have cash clear to close on the day of closing, and at 7 o'clock, seller terminates. Well, that's a premature termination. Buyer could have unilaterally extended the contract up till 11:59 p.m. And so the buyer has not breached the contract at 7, so you have to wait until 11:59. We know that performance has become an impossibility if the lender wasn't ready, closing attorney's office is closed, what have you, but buyer still had that right to unilaterally extend. So this change begs the question, okay, well, does this mean that in that scenario, and of course, a seller can unilaterally extend as well, but in this scenario, I just was using as an example where the buyer can't close, they don't unilaterally extend by 7:59. Does that mean at 8 o'clock or anytime thereafter, the seller can now terminate and it won't be premature? I could really argue that either way. That's what we all do as attorneys. You give us a position and we will argue it the best we can. I think it would be very fact dependent and depending on the situation. Obviously, if we have a closing, for example, and we've closed an escrow and for some reason the closing attorney doesn't have an escrow agreement signed at the table, buyer doesn't unilaterally extend, you could still get a call from that closing attorney at 10 o'clock saying, hey, we fund it. So again, it would be very fact specific, but what we're telling agents is, hey, you know what? You're not going to get any extra traction here. There's no real benefit that you're going to gain in the couple hours before 11:59. So just err on the side of caution, wait until midnight and then terminate. Don't jump the gun, just go ahead and continue waiting. So why this change was made? I think the change was made with the intent that, they wanted people to know early on about the closing date, but I don't know that this goes far enough. So we might see some changes to this. I don't know. It hasn't come up yet in the 2025 Forms Committee, but we may see changes to this at some point. But it is a bit of a gotcha. So we want to make sure parties know. Holder of the earnest money, this is kind of an aspirational change. And that is, it says that if a bank charges the holder fees and for earnest money check bouncing or anything of that nature, then the holder of the earnest money can charge the buyer for that. Lots of luck. Any of you who have had a buyer who never delivers earnest money and that, ACH is rejected for insufficient funds or a check bounces, we're never getting that money. So the buyer's responsibility, it used to say buyer's duty to inspect the neighborhood. Now it is buyer's responsibility to inspect the neighborhood, I think for obvious reasons. But they also added this change that neither the seller nor seller's broker shall have a duty to disclose information about sex offenders in the neighborhood. Obviously, they give the GBI website there where a buyer can check. Buyer beware is the law in Georgia. In the next section in B8D, we have buyer agrees to hold seller, and now it says, and all brokers harmless from all claims from injuries on the property. And also if buyer causes damage to the property, buyer of course has to fix that damage. But one of the reasons all brokers was added in here, and there were actually several changes that have been made over the last year or two because of this case. And if you all heard me speak last year, I told you about this case. And what happened was a buyer was already under contract. We're bringing mom to see the house, mom and dad, and there was a step down into a sunken living room at the end of a hall. The agents, or the agent, buyer's agent, the buyer, the father, whoever else was with them, all stepped down into the sunken living room. Unfortunately, mom missed the step, mom fell, mom hit her head. They took her to the hospital and she died at the hospital from her injuries. So what happened was the estate sued the brokers and they sued the seller. Well, the seller's homeowners insurance company settled the case out, sellers out of it. This had, they held 4 in the case, they held for the brokers and said, no fault here. You know, we have Beretta, we have all of these great bills that protect real estate agents from any kind of liability of this nature. We have a lot of disclaimer language in the purchase and sale agreement. However, what they tried to argue was that it was premises liability. So it didn't fall under the brokerage statute. It fell under premises liability because the listing agent, by having this as a listing, they are an occupier of the property and therefore have a duty to make it safe. And that was the argument that was made. And the court said no. Plaintiff went and they appealed it. Court of Appeals gave a very scary holding. They denied it, the appeal. However, what they said is, we are only denying this under these very narrow set of facts. We can't say this would be the same outcome with a different set of facts, but we don't think it was an inherently dangerous condition. A step down in a perfectly lit area, there was no water on the ground. There was no reason for someone to suspect there was a danger. So the broker doesn't have liability for that reason. But we're not saying if you brought us a different fact pattern, we might hold a different way, which is kind of scary. And so this one may be going up to the Supreme Court. We're going to see how it plays out, but it's still going on, which is why we continue to see a lot of changes adding more indemnification for brokers, statute of limitations going down to 1 year, this change. Last year, there were several changes as well. Scary case. This was a 2024 mid-year change, and I bring it up only because it is, I think, a very interesting change. The remedies provisions and the purchase and sale agreement talk about broker remedies and buyer and seller remedies all separately. And buyer, it said you can terminate and get back your earnest money, or you can sue for specific performance. But what would happen to a buyer who, say, has spent, thousands of dollars on inspections and appraisals and surveys and soil tests and all sorts of things like that? Maybe they have loss. So can they sue for those damages? And again, there was a court case about this. And they even had people testifying based on what was the intent of the GAR Forms Committee when they wrote the language. Did they intend for a buyer to be able to also sue for damages? So this language was added to clarify that, yes, you can sue for any other remedy available at law. Other provisions in the condemnation paragraph. This is a standard paragraph that's been there for a while. Now, instead of just having to disclose that there is a pending condemnation or anything of that nature, seller also has to give any documentation regarding that to the buyer. Delays caused by emergencies. So we got to test this one out this week. And what this says is that if the governor of Georgia declares a state of emergency for the county where the property lies, then all deadlines in the contract will automatically extend for the number of days that the state of emergency existed. So as we all know, Kemp declared a state of emergency on the 9th. It just expired yesterday. So you have, 9, 10, 11, 12, 13, 14, 6-day extension. Well, okay, that says automatically extends. Why is it automatic? That's the first question we started getting. Well, it's automatic because, let's face it, if there's a state of emergency, say when Helene came through, maybe there is a tree down and you have no power and you're stuck and there's nothing you can do. You can't communicate, your cell phone's dead, there's a tree on your car, and so you can't get in and charge it in your car. You may not have the ability to communicate. So that is why it is an automatic extension. And this is for all deadlines. So it's due diligence, it's closing date, any contingency automatically extends. Now the parties can agree otherwise, and that is perfectly fine. But what has come up this week is, okay, so we had from the 9th to the 14th a state of emergency. What if we went binding on the 10th? Does that mean our deadlines extend, or do they not extend, since we already knew about the state of emergency when we signed the agreement? Now, again, as an attorney, I could probably argue that one either way. Where I think I land on it would be that I would argue, because it says the parties can agree otherwise in writing, that if you are signing a contract after the state of emergency has been declared, then you are agreeing otherwise in writing. And I would say that the deadlines are firm based on what you agree to in the contract. However, to be safe, and because other people may interpret this differently, we are encouraging folks, if this occurs, write a stipulation that says, hey, they are not, the deadlines are what we have said they are. They're not going to extend pursuant to C4C. But if there is another future state of emergency, they would extend them, but not for this particular one that we already know about. So interesting when we get to test out a provision right away. No, it's all dates expire for the number of days of the state of emergency. So it would extend 6 days. So it's not that all dates that would have come due during the state of emergency come due like end right at the end. No, it's you extend for that number of days. It is missing the word day. Yep, it is. Well, I believe they have fixed it since we made the slides, but that was the first version. But I believe they have fixed that at this point. It's just when we created this slide in the beginning of December, they had not yet fixed it. Yeah, so and it may not have been fixed, but GAR is aware. And actually there are numerous errors in the forms this time. Typically what happens is in November, we have a final GAR forms meeting where there's everyone who is actually on the committee and then general counsel. We read through everything and then we make sure that we've caught as many of the typos as possible. That meeting didn't happen this year for a couple of different reasons. But we are seeing the repercussions of that because some of these major ones were not caught the way they normally would have been. But you are right, the word day is missing. It's closing the 12th of March now, unless the parties agree otherwise with an amendment. Mm-hmm. People don't realize this changes there because not everyone takes forms classes. So I would encourage you all, if you have contracts that are on the 2025 forms that are going to be impacted by this particular state of emergency, make sure the agents know because this is so new. They're not used to this issue. Right, if it is on a 2025 form. If it went binding in 2024, you don't have to worry about it. It is a lot, but, and you know, so the GAR Forms Committee really debated this and they said, okay, what, you know, they weighed the pros and cons because there are obviously going to be people who take advantage of this provision. A buyer right now may say, hey, there's no problem at all with this property. There was no problem with me. I went ahead and got my inspection, but I want to extend my due diligence period 6 days. Well, that is somebody who might be taking advantage of it because, you know, the 2 inches of snow we got, I know it was more in some places, probably really didn't impact anybody as far as their real estate closings, unless their closing was on Friday and it got bumped because it was Friday. However, the benefit is, okay, when we have things such as, you know, Helene coming through, and now we can't even issue insurance, get insurance on for any of our closings, things like that. It does make a difference then, because we have buyers who are losing earnest money because, you know, maybe they had already unilaterally extended once. Now they can't unilaterally extend and they can't get insurance, so they can't close their loan, something completely outside of their control. So it was decided that the benefit of this outweighed you know, the frustration that would come with it. And again, nobody expected it to get tested quite so quickly. The entire agreement modification, this section, just checking our time here, So what this is saying is that the actions of the parties can't be interpreted as a mutual departure from the terms of the agreement. The best example I give people when I teach this, or that I've come up with when I teach this, is the time is of the essence clause. So that means that we are going to hold firm on our deadlines, but let's say, you know, buyer doesn't deliver the earnest money and seller says, don't worry about it. And then buyer eventually does it. Buyer doesn't terminate at the end of due diligence, and the next day sends an amendment to address concerns. Seller says, I know it's past due diligence, but I'm still going to go down this road with you. And we're going to amend the contract using a different form, not the amendment to address concerns now, because due diligence is technically over, which agents don't know. Read the form. People don't read that part of the form, that it can only be used during due diligence. Anyway, rabbit hole. So, and then maybe there is a financing contingency and seller said, don't worry about it. And then buyer doesn't close on the closing date and seller terminates. Well, buyer could come back and argue, hey, you haven't held firm on any of the deadlines. We have, by our actions, mutually departed from the time is of the essence clause. It's not enforceable. This language is saying, no, that's not how it works. Your actions can't be held as a mutual departure. We see that with like notice and things like that, where notice is given incorrectly as well. No recording of the agreement. This is one where, again, it's kind of aspirational. As I'm sure a lot of the title underwriters in the room have experienced and the closing attorneys in the room have experienced, we have seen where people are recording memorandums of contract, or they are recording copies of the contract, and then the contract doesn't close. Seller goes on to buyer number 2, and we run our title exam and we find this cloud on the title. We say, hey, seller, we need to get a release for this. And buyer number 1 says, sure, no problem, I'll release it. It'll cost you $10,000. So we didn't want them doing that using GAR forms. Now, I'm not sure this language would go far enough for the title underwriters in the room. I think it needs to go a little bit further, and use some of the MV Realty language where it says it's if you do this, it is void on its face. But at the end of the day, most of the investors who do this aren't using GAR forms in the first place. So I don't know that this really is going to help anything, but the GAR forms committee can only control GAR forms. They can't control these other things. So they're doing the best they can with what they've got. Property delivered in clean condition. This is probably the saddest change that has been made to the GAR forms in the 20 years I've been doing forms committee. And it says that now, in addition to removing all your personal property from the property seller when you deliver it, you also have to remove your pets. Because we have seen a number of sellers, especially in the last year, leaving pets in the property. So now I don't think this is going to change what they do. And technically, when you close, the contract provisions, unless are a provision that survives, this doesn't survive closing. So I'm not sure it really helps anything, but it is now there at least as a reminder, hey, seller, don't leave Elphaba, the pit bull. Thank you, Tamara. She is adopting a lovely pit bull named Elphaba. So don't leave Elphaba in the house when you sell it. Rules for interpreting the contract. This language, there's some errors here. There are 2 errors in this section that need to be fixed. We're working on that. But the key thing I want to point out here is in the mid-year changes, when the dreadful broker compensation agreement language was written, and I promise you we tried to change it, but it was too late because everything happened in such a condensed amount of time, from the time of the NAR settlement to when the forms changes had to be drafted to then be able to get them to the vendors for July 1st. It was so fast. The actual time to actually change everything was probably 2 weeks to then get it to the forms committee meeting to vote. And we tried to make changes because it was pretty clear almost instantly, hey, made some errors on this form that didn't get fixed. So One of the errors was the way the language was written on the form at the time made it sound like a broker had to sign the broker compensation agreement for it to be enforceable, which is true. However, by signing the contract with the properly incorporated broker compensation agreement, you have signed the broker compensation agreement. The reason that language was added in the first place is because the purchase and sale agreement is binding on the parties, even if the broker doesn't sign it. So this language, what it says is, hey, if the broker compensation agreement is there and the broker impacted has not signed either the contract or the 259, which is the buyer broker compensation agreement, then the contract is not binding. And that was an important change because we have buyers who, you know, a seller's broker who's supposed to be sharing their compensation with buyer's broker doesn't sign the broker compensation agreement. And now buyer is stuck with a binding contract where they didn't want to buy the house unless their compensation, or couldn't buy the house unless their compensation obligation was covered. And so now they were stuck with a binding contract, and the agents didn't really know enough to think about this up front. And they would get to the closing table and seller's broker says, I don't have to pay you. I never signed it. And buyer says, well, yes, you do, because it was incorporated in the contract. And we had several disputes like that. So this language was added to make it clear, and the offending language on the broker compensation agreement was removed. Speaking of broker compensation, so when the NAR settlement happened, there was a lot of confusion and a lot of different interpretations going on. And NAR was starting their FAQs, and they were new at that time, and there were only a handful of them. And so everyone did the best they could with their interpretation of it. As NAR continued to put out more FAQs and their attorneys continued to answer more questions, they started taking a more conservative approach. And so we've seen a lot of changes with the interpretation of the NAR settlement. Seth Weissman and Christina Chow from GAR have had many conferences now with the NAR attorneys to make sure we are doing things the way they want them done. So one of the changes that was made is the language says that compensation is negotiable, not set by law. The old language said, however, an individual broker or an individual agent is not required to negotiate their own commission, which is true. I, as an agent, can set my compensation. I can set my value, and I don't have to change that. It is negotiable and not set by law, but I can hold firm in my negotiating position. But NAR didn't like that language, so it was removed. The other thing that we did here is now sellers have three options. They can say, hey, I'm open to paying compensation, but I want to see the offer first. They can agree to amount of compensation either to be paid directly by seller or cooperatively through the seller's broker. And I think, especially in Metro Atlanta, we are really seeing decoupling, and we're seeing the sharing go away. And I think we will see in another year, hopefully cooperative compensation is really just gone. It doesn't hold as much value when you can't advertise it in an MLS. Not that it really did anyway, because that's not what we actually do in real life. And then no compensation being offered at all. Now, what's important to remember is this section is about what the seller's broker can advertise or communicate to a buyer and buyer's broker. This is not, excuse me, this is not about what the ultimate agreement about compensation might be. So whatever a seller signs in the purchase and sale agreement, for example, if it is different than what the seller said they would do here, that's okay. That's going to control. You don't have to go back and amend this, because this is just about what the broker is authorized to communicate to people, which is a requirement of the NAR settlement. Protected period language. I'll skip over this. Mostly it was just a clarification of how it worked. It doesn't work any differently now than it did before. So the things we now know about the NAR settlement: buyer must be on the hook for the entire amount of compensation buyer's broker is allowed to receive from anybody. So you cannot say, for example, that buyer has to pay X, but buyer's broker is allowed to receive X plus Y from seller or seller's broker. You can't do that. Buyer has to be on the hook for X plus Y. In addition, NAR has said that any compensation paid by seller or seller's broker must automatically reduce the amount of compensation buyer pays. So we have removed that those check boxes from the form. And in addition, they have said that when you are, you can't really have a bonus because buyer has to be on the hook for it. And then the question comes up, okay, well, can you amend the brokerage engagement agreement to change the amount of buyer broker compensation? Well, it's kind of questionable. We don't really know for sure. We know you can amend the amount of compensation down, but what the NAR attorneys very clearly said was, sure, you can amend compensation up, but you better be performing some additional brokerage service or you might get sued. You're opening yourself up for liability. There's not really anything about this in the settlement itself, but it is the guidance being given by NAR, since there are still a lot of people out there filing lawsuits and things. So, be very, very careful. If you are going to amend compensation up, make sure you're performing an extra service. And it should be a brokerage service. So you're not becoming an electrician all of a sudden, you're actually performing brokerage services. So, new construction is where we really see the bonuses happen. And I think most of the big builders now get it and are removing that and offering buyer incentives instead of extra compensation to drive traffic. So NAR pretty clearly said, if it's just to if the bonus is being offered just to drive traffic, that's not okay. However, let's say you have a buyer brokerage engagement agreement and it was a 30-day agreement. Buyer was looking at resales and now all of a sudden buyer wants new construction and the house isn't going to be done for a year. And so instead of paying, delivering 30 days of brokerage services, now it's going to be a year. Well, that might be a reason to amend compensation up because now there are additional brokerage services, 11 months of them being offered that weren't contemplated in the original agreement. So people start saying, well, can I stipulate around that? No, don't do that. Can I stipulate that buyer, I'll reduce the compensation if seller doesn't pay it all? Well, you can, but it wouldn't be very smart. What we're telling people is these rules might seem painful, but this actually now is closer to what we had before the mid-year changes. So I think most brokers are getting used to it, but it is, it is a change that everyone's having to contend with. The F-116 is the buyer customer form. That was just changed to mimic the buyer brokerage engagement agreement. No other real changes there. And then we have this new form, and this is seller's broker's notice, and you can't really see the top of it because of the, someone clicks OK, you'll be able to see the top of it. But this is a new form that was created, and this is to be used by a seller's broker who is representing the seller and being paid compensation by the seller. But because they are working with the buyer as a customer automatically, since they don't have an agreement with them, historically what we've done is we've taught agents, hey, make sure you get the buyer customer form signed. But now that there's compensation in the buyer customer form and all of this other language that has been added to it, it was decided that that really was no longer the appropriate form to be used in that context. So now what this form does is it says, okay, seller's broker, you're just telling buyer's broker or buyer, I don't represent you. Here's the ABCs of agency, go figure it out. I can only do ministerial acts for you. And that's it. And so it's really a disclosure. It's a notice. Buyer doesn't have to sign off on it. Now there are boxes so that the broker can check the box on how they delivered that to the buyer. But it is just a unilateral notice form to cover all of the GREC rules and ethics rules. F-118, there is a showing agreement now. This was another hotly debated. Any of you who attend forms committee meetings got to sit through 3 hours of debate over this form. And it's really kind of a bad idea, but there was such demand to have a showing form. So this is sort of the GAR equivalent to the Zillow showing form, except for it's got extra language added in about fair housing, and hazardous conditions on the property, et cetera. What buyers, brokers have to understand, you can use this form saying your services are worth zero and you're opening the door for free, because obviously with the NAR settlement, you have to have an agreement about compensation prior to touring a property. And while that is all fine and good, if you are using this form and you show them the property and then they say, oh, great, now I know seller's broker isn't paying compensation, or seller isn't, so I am going to just go straight to them and buy the house directly to them. Well, buyer's agent, you're not going to have a procuring cause claim anymore, because now you've said your services were worth zero. But for the things you did, introducing the property to the buyer, touring it with them for the first time, that was worth nothing. And you're also going on record saying that there is no value to that service, which is probably just a bad idea in general in the new compensation climate. So our agreements related to compensation, the instructions to closing attorney, this was all streamlined so that the check boxes are like they are on the brokerage agreements, trying to make, again, everything as consistent as possible across the various forms. Works the same way. The language, however, about mandatory arbitration was added back in. It had been removed. It was added back into the form by popular demand. The other thing, though, that was added is on page 2, it now has a buyer signature box. Now, in the mid-year changes, they added the seller signature box, where if the seller was paying buyer's broker directly, not cooperatively through their agent, but directly paying the buyer's broker, then seller had to sign this. Well, now it's got a box that says, if buyer is paying buyer's broker directly, then buyer should sign it. It's unnecessary for that to happen. There was a different reason why seller had to do it, because there was no, there could be another pre-showing agreement or something like that. Closing attorneys need to know there was that agreement. With the buyer side, it's just a different thing. They already have their brokerage engagement agreement. We can see that if we need it, what have you. But they're by popular demand, they wanted this. We'll see how it plays out. 258 was changed. This was another hotly debated change. And this change, what it basically says is that the agent, or if it is a person who's licensed as a broker, whoever the authorized representative of the broker is, who signs the 258, which is the pre-showing compensation agreement, whoever signs that has to also be the same individual who signs the purchase and sale agreement. And the reason this change had to be made, despite the numerous objections, was that if you have a situation where, let's say that I am buying a house and I am working with broker A from ABC Brokerage, and we create an agreement with the seller saying the seller is going to pay X. And then another agent, agent B, who works with that same ABC brokerage, has a buyer and they make an agreement because they're trying to be competitive and they only ask for Y, which is less than X. Now, seller accepts my offer where I've got my compensation agreement was for more compensation. They agreed to the lower compensation later. The agreement was with the broker. And so now I get to closing and the seller only has to pay the lesser amount they agreed to with my broker, even if not my agent. And I had no notice of it. I had no way of knowing that was the case. And that created a problem. So we had to fix that problem. So now that's why it says the representative of broker who signs this agreement, this pre-showing form, must also be the one who signs the purchase and sale offer for it to be applicable. The commission is still paid to the broker, but that is the condition under which compensation will be paid. Buyer broker compensation agreement. So this is the broker compensation agreement. And you will see they have removed seller's broker compensation from the form. It was decided that there was no reason to bring up seller's broker's compensation again. If the house doesn't appraise or amendment to address concerns, all of those things, let's not have to renegotiate that. Let's just focus on buyer's broker compensation. There are already agreements in place regarding what seller is going to pay seller's broker. Similarly, there's already a buyer brokerage engagement agreement, so we don't need to put what buyer is paying buyer's broker on this. All that needs to really be negotiated in the purchase and sale agreement is what seller is going to pay or seller's broker is going to pay. The language that was confusing in the old form was all removed, and they did add language just saying that this survives closing, and that if there is no closing, there's no obligation to pay the broker. One broker doesn't have an obligation to share compensation with the other broker. Financing contingencies, they made a couple of changes, and we're running a little short on time. I think I've only have like 5 minutes left. But big change here is that it's now just a lender is defined as defined to include a broker. And the reason the change was made is because they wanted to make sure that if a buyer puts a broker in there as the approved lender, and then the actual loan denial letter comes from the lender selected by the broker, then that will count. And there's language on page 2 of the financing contingencies that says that. It says, hey, if you've listed a broker, any lender selected by the broker or the broker themselves can write the loan denial letter. Now, it doesn't work the opposite way. If you list, Truist Bank as the approved lender, you can't then have the broker sign the loan denial letter because we don't know about that. When they list a broker, we know that broker is going to be shopping the loan to various lenders. So it could make it a little difficult for those of us who are holders of earnest money to determine, hey, there was a broker listed. Is this someone they selected? And we may need to get a little clarification on that, but at least closes that loophole because it was kind of a gotcha for agents or for buyers. Condominium language was added. Basically, I'm sure everyone in the room who does real estate closings has probably experienced this once in the last year and a half where a loan is denied because the condominium is not approved, say because the insurance deductible is too high. And buyer can't close. It's the 11th hour. Buyer loses their earnest money because they have passed all of their contingencies. So this language was added. This contingency goes all the way through closing. It goes all the way through closing because a lot of times those condo associations or associations that have master insurance policies, they're not getting that information to lenders in a timely fashion. And also some lenders wait until the appraisal has come in to actually pay for the condo letter because it is so expensive. So that is why this runs through closing. Parties can always stipulate around it if they don't like it. This change I've already talked about. Right to request proof of a buyer's ability to close. I hate this paragraph. This paragraph is so hard to enforce in the first place because it's such a narrow window of time it can be used between the expiration of financing and closing, but not within 7 days of closing. And then buyer has 3 opportunities to cure. So it's a very hard provision and it's misleading because you all know as well as I do, you can get all the confirmation you want from a lender 3 days before closing. But if you don't get the clear to close on the day of closing because they do that final, check. They check the credit or whatever it might be. It's a false sense of security in the first place. However, they did add language saying any evidence of buyer's ability to close should be liberally interpreted in favor of the buyer. And it's nice with a room of attorneys. I don't have to explain what that means. Appraisal contingency language was just clarified. And then the agreement to seek amendment to sales price. This was the old further agreement pertaining to a mandatory clause. Remember at the beginning, I said there's been this push to that's like the fifth time I've done that, to standardize forms. Well, if you've ever read all the appraisal contingencies, you know that every single one of them had different timeframes, different rules, different requirements. There wasn't a single one that was the same. So there is now a push to standardize that to the extent possible. FHA is still unique, the most unique one. However, this language now, the timing, so buyer has to seek a reduction in the sales price prior to terminating, and the timeframes now mirror what they are in conventional. And USDA was similarly changed so that the timeframes are all the same, where you have 3 days from getting the low appraisal to seek the price reduction. Seller has 3 days to respond. If seller says no, then buyer has 3 days to terminate, or they lose that right. And buyer can't terminate within 1 day of closing. Seller can't reject within 2 days of closing. So all the timeframes are the same. So if you understand the conventional appraisal contingency, now this just makes FHA and VA more similar to that in a timing position. Last thing I want to talk about is lead-based paint. So as Tamara mentioned, I'm helping to write the next volume or edition rather of the Red Book. And I just finished, actually before the changes came out, writing the lead-based paint chapter. And so I have done extensive research on this, and this causes a lot of confusion and a lot of frustration. The EPA changed the lead-based paint form to say that a buyer's agent has to sign. Now, this has always been the rule. It is, if you go back to 1996 and you read all the laws and the interpretation, that has always been what the rule was, but it was misinterpreted because there was only one box that said agent must initial. And people always really kind of decided that that meant just the seller's agent. And it really always meant both. So if the buyer's broker is being paid compensation solely by the buyer, so not by the seller, not by seller's broker, then buyer's broker does not have to initial. But if buyer's broker is being paid either directly or cooperatively, and you'll see we will hopefully clarify that this year. It hasn't come up for forms yet, but it will, I promise. If buyer's broker is being paid cooperatively or directly by seller or seller's broker, they must initial this. Now, people have said, okay, isn't it redundant? If I already have a fully completed lead-based paint disclosure, there is a seller's broker who I know has clearly given the notices they're required to give. Why do I need to do it again? Well, if for no other reason than that the law says that a real estate agent who has given the required disclosure is indemnified if the seller has not disclosed truthfully. So even if you're not worried about the very high fines for not, as a broker, for not filling out the form completely, you are protected in the event the seller is not truthful or does not fully disclose and somebody is harmed by lead-based paint and they bring a lawsuit. As long as you can show you gave the required disclosures, you're indemnified by the law. So for that reason alone, we are telling buyers, brokers, unless buyer is paying your compensation, all of your compensation, then you need to be initialing this. Now, the second question we get is, okay, so how does a buyer's broker give this notice? Well, there's a form for that. And this is buyer's broker's notice to seller, a seller's obligations under the lead-based paint laws. There are 4 things that the law requires the brokers or agents, as the law defines them, to tell a seller about what seller's required disclosures are. This is a unilateral notice. It can be given to seller's broker. So if seller is represented, even back then, They knew that, agents didn't want to be communicating with the seller. Georgia law only restricts negotiating with a represented seller, not giving them a disclosure. So you can still give that disclosure directly to them from a license law perspective. Code of ethics rules, maybe a little more shaky on that. But it is perfectly fine under license law, ethics rules, EPA rules to give that notice to the broker representing the seller. That is fine. If you are a seller using a GAR brokerage engagement agreement, these 4 disclosure items have been added into the GAR forms, but there are some brokerages that use GAR forms that don't use GAR brokerage engagement agreements. So there is also a similar version for sellers notice to seller or sellers brokers notice to seller. And so that is there as well for those people, or if there is a FSBO. And I think that's it. There's 2 minor changes to the seller's property disclosure about spray foam insulation in the property. I think we're going to get a lot of false yeses on this one, but the reason this was added, if you are asked, is because termite companies will not issue a bond, or most termite companies will not issue a bond if there's spray foam insulation touching the ground. So, most houses built in the last 20 years have some form of spray foam insulation around doors and windows. So again, I think we're going to get a lot of false positives on this one. So good idea to dig deeper if you get a yes on this. And then it talks about underground pipelines that cross the property that don't serve the property. So that is it. Are there any questions? Well, here's the problem. Compensation survives closing. So if you disperse and you get it wrong, then yeah, you're probably going to have some liability, because maybe you've got something in the contract that says do it, pay X, but you put Y on the settlement statement, and the brokers don't sign the settlement statement, buyer and seller do. So you have to get something in writing from the broker agreeing to the compensation. So that would be the problem with that. There are a couple new forms, just sign-in sheets for new construction, things like that, and then some forms that were moved from the forms library. But that is it. If y'all have any questions, you can let us know. Are you asking me or are you asking staff? So you'll get a more realistic time frame then. Hopefully by next spring, not this spring, but hopefully by next spring, we are doing a full overhaul on it. And it's going to be a lot of the stuff that is sort of not really related to actual contracts is being removed, and really focusing on actual use of the forms. And so it's a pretty major overhaul. So it's going to take a minute. Yep. All right. Well, thank you guys so much. My contact information is up there if you need anything, and it will be in your materials as well.
Great information there. Okay, so we are going to continue on a couple of things I didn't mention earlier. So we have Greca here, and we also have SLTA, Southeast Land Title Association here. These are 2 great organizations we're all a part of. And love for you to go talk with them, get more information. Very, very helpful, great networking. Also, I wanted to mention that the Real Property Institute is going to be May 8th through 10th at Amelia Island. There is going to be a reception on the 7th. So if you want to come out a day early. And what I failed to mention earlier is we are going to be raffling off 1 admission for RPLI today. Now that's only admission to the sessions. Now I'm not paying your hotel, not paying transportation. So y'all got to get there, but I've got raffle tickets in the back. So if you're interested and want to be entered for that, just come see me and I'll get you a ticket for that. Trying to decide if you must be present to win. keep you guys in your seats. I'll get back to that. But we have our next speaker, and it's Kenny Stroud. He's the Vice President of Southeast Regional Council for CADIC, where he oversees underwriting for all Southeast states. Kenny received his BBA from Kennesaw State University with a concentration in economics and finance. And worked several years in the insurance and risk analysis field before enrolling in the University of Georgia School of Law, where he attained his JD. Prior to joining CADIC, Kenny maintained a successful practice in Metro Atlanta, focusing on real estate and real estate litigation, estate planning, bankruptcy, creditors' rights, as well as serving as Southeast Underwriting Counsel for a regional underwriter. Kenny is a frequent speaker and instructor for CE and CLE events and industry conferences. He is a member of the State Bar of Georgia Real Property Law Section, GRECA, SLTA, TNLTA, PLTA, and FLTA. So without further ado, here's Kenny Stroud.
Real quick, by a show of hands, how many of you are familiar with the Corporate Transparency Act and the new real estate reporting rule? No. Okay, so general familiarity. How many of you have been following along with what's going on with the Corporate Transparency Act here lately? Two hands. So if you've been following along, you know that the Corporate Transparency Act, or really the enforcement of it, is kind of being passed around like a bit of a hot potato lately. There's a lot of litigation going on, and we'll cover some of that towards the end of the first part of the presentation. So what I want to say is this, you know, the old saying is the only thing that stays the same is everything changes. I could walk out of the doors of this room right now and everything that I tell you about the Corporate Transparency Act could be bad. You know, it could no longer be good, valid information. That's just the kind of environment or situation we're in right now in terms of challenges, constitutional challenges to the law, its enforcement, and et cetera. So just want a big disclaimer and a big caveat there. But we're going to learn about it. My goal is to teach you about or give you some information about the who, what, when, where, and how of both the Corporate Transparency Act, that is the beneficial ownership information filing requirement, as well as the new real estate reporting rule, which will go into effect later this year, December of 2025. All right, so diving right into the Corporate Transparency Act. What is the history and purpose? It was enacted in 2021, but didn't really take effect. The new beneficial owner information form filing requirements didn't take effect until January 1st of 2024. Now, if an entity was in existence prior to January 1st, 2024, it had a different filing deadline than entities that were formed on or after January 1st, 2024. We'll talk more about that in just a moment. The purpose behind Congress enacting this legislation was to curb illicit financial activity, fraud, money laundering, and things of that nature. Here's a quote from Janet Yellen, the Secretary of the Treasury. It's, "Corporate anonymity enables money laundering, drug trafficking, terrorism, and corruption. It harms American citizens and puts law-abiding small businesses at a disadvantage. Having a centralized database of beneficial ownership information will eliminate critical vulnerabilities in our financial system and allow us to tackle the scourge of illicit finance enabled by opaque corporate structures." So there you have it, straight from the Secretary of the Treasury. That's the purpose for the Corporate Transparency Act. So we're going to talk about the who, what, when, and where. So the who, well, who is required to report under the beneficial owner information requirement? And the answer to that is it's reporting companies. Well, what is a reporting company? The Act breaks it down into two categories of companies, domestic and foreign companies. So domestic companies are corporations, limited liability companies, any other entities really that are created by the filing of a document with the Secretary of State or any similar office within the United States. Foreign reporting companies are entities, including corporations and limited liability companies and partnerships formed under the law of a foreign country that have registered to do business in the United States by filing a document with the Secretary of State or any similar office. So you can see the refrain here is it has to be formed or created by filing a document with the Secretary of State's office in order to be considered a reporting company, whether domestic or foreign. Here's a nice little flow chart that is included in on FinCEN's website under the FAQs This kind of just helps break down to determining whether or not a company is required to report. So under what law was the company created, US or foreign? Is it domestic or foreign? If it's US, is the company a corporation? If the answer to that is no, then the default is it a limited liability company? If it's no, then you have to ask, was the company created by the filing of a document with the Secretary of State or any other similar office under the law of a state or an Indian tribe? So right off the bat, we know corporations and LLCs are formed by filing the articles of incorporation or the articles of organization with the Secretary of State. So we know that they are reporting entities. But it gets a little bit more nebulous when you start talking about partnerships. Do you have to register or create a partnership by filing a document with the Secretary of State, or do you file it in the clerk's office in the county where the partnership is registered? It becomes a little bit more nebulous there. And you'll see the constant refrain, and I think where a lot of the litigation is coming from is this presents some significant compliance challenges, especially when you're dealing with corporations, or not corporations, but entities that have a very complicated ownership structure. Or a foreign corporation, it's a little bit different. Or a foreign entity, it's a little bit different. Basically, if it has registered to do business by filing either a certificate of registration of a foreign company, if it's filed it with the Secretary of State here, it's considered a reporting company and must report under the law. So what about trusts? Well, generally speaking, your typical run-of-the-mill, family revocable living trust that's done for estate planning purposes, that's not created by filing a document with the Secretary of State. They often do hold and sell real property as part of the investments that are held in the trust. But since they're not created or formed by filing a document with the Secretary of State, they're excluded from the reporting requirements. They're outside the definition of a reporting entity. But some trusts could be. For example, Delaware statutory trusts. I'm sure some of you have run across those in your closing practice. Land trusts that are created by statute that require forming that trust by filing with the Secretary of State. Those could be reporting entities. So we can't say all trusts are excluded. We can only say those that are formed by not having to file a document with the Secretary of State. So for example, would be a joint revocable living trust for estate planning purposes. Now, there are exemptions. As a matter of fact, there's 23 listed exemptions of the types of companies that are exempt from the reporting requirement. The vast majority of the buyers and the sellers that we deal with are probably not going to be exempt, right? So these exemptions mostly deal with publicly traded companies, banks, credit unions, things like that, securities brokers and dealers, and large organizations. So the likelihood of one of those 23 exemptions applying in a particular transaction or to a company, let's say that you're representing and advising on their obligations under the CTA. The large operating company, it has to have more than 20 full-time employees, a physical office in the United States, and filed tax returns for the previous year showing more than 5 million in gross receipts from US sales. So it's a pretty narrow exemption there. I think it's really only going to apply to a lot of the larger companies, not your typical smaller business LLC that's buying and selling properties. Quick note on inactive entities. The inactive entity must have completely ceased doing business and formally or officially dissolved. That is, it cannot be reinstated prior to January 1, 2024 in order to be considered exempt from the reporting requirement. So if you had an LLC that, let's say, it was still doing business, but it had been administratively dissolved late in 2023. Well, because you can reinstate an administratively dissolved entity and it was still doing business even after January 1, that entity, even though it's been administratively dissolved, would still be required to report and file the BOI form. It's only if the entity completely ceased doing business prior to January 1, 2024, and it can't be reinstated. So a formal dissolution, or it was administratively dissolved some time ago and the time for reinstatement has passed. Just to keep that in mind. So now we know who is required to report, both domestic and foreign reporting companies under the definition. What are they required to report on the forms? Well, if you've ever seen the form, it's an electronic form. There's three basic types of information or categories of information. There's information on the company itself. There's information about the company applicant, and then there's information about the beneficial owners of those companies. We'll talk just a bit about each one of those to get some more understanding. So what company information must be reported? Well, the legal name of the company itself, any DBAs or trade names that it's doing business under, the current address of the principal place of business for the company, the jurisdiction of the formation or registration of the business if it's a foreign entity, and then the taxpayer ID number. So just some pretty basic general information that you should have in your file or be able to get pretty quickly. Now, this is where it gets a little more unclear, is who is a beneficial owner, right? You're required to report the names and some other information about the beneficial owners. But it gets a little unclear on who it qualifies as a beneficial owner. Well, the definition provided by FinCEN is any individual who directly or indirectly owns or controls at least 25% of the ownership interests or exercises substantial control over the reporting company. So we'll talk more about this substantial control, but what I want to highlight for you is it's not just owning an interest in the company. You could actually not own any interest in the company and still be considered a beneficial owner if you're exercising substantial control over the entity. But assuming you qualify as a beneficial owner, what information does the company need to report about you as a beneficial owner? Well, your name, your date of birth, your residential address, the identifying number from an acceptable form of ID, which they state is a driver's license or a passport, including an image of the ID document. All of this information is specified under the statute. So a lot of the plaintiffs who have sued to challenge the CTA as being unconstitutional have privacy concerns, right? They have privacy concerns of revealing non-public personal information, such as their residential address where they reside, as well as copies of their driver's license. When this first came out, there was some considerable discussion about the potential reach and what kind of information they're requiring to be reported. Now, the substantial control test, right? So you either have to have at least 25% ownership interest. And now if you have more than 25% ownership interest, you're automatically deemed a beneficial owner. But if you don't have at least 25% ownership interest, you could be deemed a beneficial owner if you exercise substantial control over the company. Now, here's the chart that FinCEN has published in its FAQs to kind of highlight or give examples of what substantial control could be. So for example, a senior officer, any individual holding the position or exercising the authority of the president, the CFO, the general counsel, the CEO, or the COO. They may not actually own any interest in the entity at all. They may have no ownership interest, but they're considered a beneficial owner by virtue of their senior officer status. Any individual who exercises authority and control to be able to appoint or remove one of the senior officers is considered to have substantial control over the entity and would be a beneficial owner. Anyone who makes important decisions about the company or on behalf of the company with respect to nature and scope of business that's being done, termination of contracts or selection of contracts, sale, lease, mortgage of property or assets of the business, and then reorganization, structure, even hiring and firing decisions. So you can see that what one would think is a beneficial owner, you would have to require some ownership, but it's much, much broader than that, okay? And the one thing I want to point out is this little green catch-all down here that basically says any other form of substantial control over the reporting company. Control exercised in new and unique ways can still be substantial. For example, flexible corporate structures may have different indication of control than the indications included herein. So honestly, that I interpret that as a catch-all that basically says if FinCEN and the Treasury decide that this person, in their opinion, is a beneficial owner and you didn't report, you're not in compliance with the statute. But to me, it looks like it gives them the final decision on whether somebody is a BOI, is a beneficial owner or not. Couple of examples. So this is direct versus indirect ownership and own versus control. So Emily and Liz form a small LLC to run a photography business. Because Emily contributed most of the initial capital to start the LLC and buy the equipment, 80% of the membership interests are in Emily's name, 20% in Liz. However, Liz is named the sole manager, runs the day-to-day operations and photo shoots, and is in charge of bookings, equipment purchases, and production. Emily sometimes helps with bookkeeping and preparing tax returns. Who's the beneficial owner in this situation? The answer is both. Both are considered beneficial owners. One, Emily, because she owns at least 25% ownership in the entity. And then Liz, because Liz controls the day-to-day operations. She's in charge of bookings and production. She exercises substantial control over the business. So even though Liz doesn't have 25% ownership interest, she only has 20, she exercises substantial control and is therefore deemed a beneficial owner. Another example, John is an attorney in private practice, so he has his own firm, but essentially serves as de facto general counsel for a roofing company, for a large roofing company. John calls and presides over all the business meetings, makes hiring and firing decisions, handles separations and benefits, negotiates business financing, and is responsible for all legal matters for the company, including collection and litigation. John has no ownership interest in the company. And again, he has his own firm. He doesn't work out of their offices or anything like that. Nor is he compensated based on profit made by the company. Is John a beneficial owner? Well, under the definition of the flow chart that Vincent has provided, he exercises substantial control. He makes important decisions, and especially under the catch-all, I think he could be deemed a beneficial owner. This highlights the difficulty of determining, who exactly is a beneficial owner. And honestly, if you're on the fence or it's not clear, the safest course of action is to report them as a beneficial owner. But again, this highlights the compliance challenges with CTA. Now, a company applicant. This is somebody, so the definition, first of all, is this required, right? So for any entities that were created before January 1st or were in existence before January 1st, 2024, you don't have to report this information, which I was thankful for because I helped clients form LLCs and corporations a lot when I was in private practice several years ago. And although I'm no longer listed as the registered agent, folks were calling me saying, hey, do I have to report for this? Or what do I need to do? And if I had formed those entities after January 1, 2024, I would be considered a company applicant, right? Because a company applicant under the definition is person who files the document that creates the reporting company. So the attorney who's filing the articles on the Secretary of State's website, or the person primarily responsible for directing or controlling the filing. And so the question here is, could this be the attorney? Yes, absolutely, it could be. So what you want you to understand is only companies formed on or after January 1, 2024 are required to report the company applicant information. But for those that are required to report the company applicant information, the information that's required is the name, date of birth. This just says address for them. It doesn't say residential address. So I'm guessing you can just report, although it's not clear, I'm guessing you just report the business address, so the law firm address. And identifying number from an acceptable form of ID, driver's license or passport, and a copy of that. So for companies who were formed on or after January 1st, 2024, they may be calling their attorney who formed that company for them and say, hey, we need a copy of your ID, which I don't know that I would be so, eager to provide a copy of my ID, but that's what's required under the statute. So and again, it's a little bit difficult to determine who is the company applicant, right? Let's say the attorney says, yeah, we'll file it, the law firm, but they hand everything off to a paralegal. And the paralegal gathers the information, meets with the owners, the registered agent, whatever the case may be, gathers that information, the filing fee, and files it. Well, is the paralegal now a company applicant? Yes, because they exercise primary responsibility for directing and controlling the filing. but so is the attorney because they were doing it under the supervision of the attorney. So every company can have up to two company applicants, right? So there can be one or two, but no more than two. And in that scenario, it could be the attorney and the paralegal are deemed to be company applicants. Any questions about that? Clear as mud, right? All right, now on to the when. So when must the reporting company file the BOI form? Well, before the litigation in the district court in Texas, what the statute said was companies formed on or before January 1, 2024 had until December 31st, 2024 to file the BOI form. So they had an entire year basically when the statute took effect, if you were already in existence when the statute took effect. Companies formed on or after January 1st, but before December 31st had 90 days to file it from the date they were formed. So 90 days from the date of formation, if it was formed anytime during 2024. Now, going forward, companies formed on or after January 1, 2025 must file the report within 30 days of formation. So again, deadlines based on when the company was formed. Prior to 2024, you had until the end of 2024. If created during 2024, you had 90 days. Now, created in 2025 or beyond, you have 30 days to file. So where and how do you file this? Well, you're going to be filing it on the FinCEN's website, and I've included a link there as an e-filing form. And it's not required to hire an attorney or a CPA to file this form, although it's advisable if you want to make sure that your company or your client's companies are in compliance. And I know that there are some firms out there who are specializing in this. I've received several solicitations that for businesses I've had in the past from law firms saying, hey, we can help you with this BOI filing requirement. We understand what all the rules and the fine print, and we can counsel you on that. I would advise anybody who's looking into this for their clients or for their own businesses to use the FinCEN FAQs and the Small Entity Compliance Guide. They do have a lot of information in there. They have scenarios or examples that help shed some light on that, might determine whether somebody is a beneficial owner and that sort of thing. There's a lot of great information there. I've included links there as well. So now here's what you all really want to know is what happens if you don't comply, right? What are the penalties? Well, the statute provides for civil penalties of up to $500 per day adjusted for inflation, which as of April 18th, 2024, the per day fine was $591 per day. Criminal penalties include up to 2 years imprisonment and a fine of up to $10,000. Statute does require a willful violation, right? So, but here's the question, what is willful, right? Is ignorance of the law an acceptable justification for noncompliance? No, they state very clearly in the guidance that they issue that simply not being aware of your reporting requirements is not a sufficient justification. That's not considered an unwillful or not being willful. So, be warned, if you've got a compliance obligation to file the form, you need to do so or you face pretty stiff penalties. You do have a 90-day period to correct false or incorrect information without penalty after filing. And I want to address something that's not on the slides, but whenever someone is filing, let's say an attorney is assisting a client who owns a company with filing this BOI report. So what is the standard that the attorney is held to in terms of filing accurate information? Well, basically what FinCEN has said is that the attorney or the CPA, whoever's filing the form for the company, is entitled to rely on the accuracy of the information provided to them, except if they have independent information that calls into question the accuracy of the information that was provided to them, right? So if they're being told by the owner of the company one thing, but they can very plainly see that it's not that, it's something else, the attorney who helps file the form could face potential liability for filing false information because they had information that calls into question the accuracy of the information that was being certified to them by the owner or the beneficial owner. So be careful. But there is a safe harbor provision there for attorneys. If you don't have any other information and you're helping somebody, you're entitled to rely on the accuracy of that information. I would highly, highly suggest that you get it in writing and have them certify under oath or under penalty of perjury that the information is accurate, and correct, so that you've got something to hang your hat on if FinCEN ever comes knocking. So what are some of the compliance challenges with this? Well, we've highlighted a few of them. So one, gathering the necessary information, right? You're going to be, let's say you have a small business, but there are 10 other owners. And, maybe you're having to report information about 5 of those 10 owners because they are considered beneficial owners. These folks may not want to provide that information, right? It's personal information, the residential address, the copy of the ID. They may balk at that. They may push back. Some may just ignore your request because they don't feel like, they don't understand the importance and the potential civil penalties. Also, understanding complicated ownership structures, right? So I know you've all seen this. You get a closing in and your closing is an entity, call it an LLC or something. You ask, okay, well, can you give me the organizational documents? Well, after some pushback and they finally provide it to you, you find out that the owner of the LLC is yet another owner, another LLC. And then you get the docs for that LLC and you find out that the owner of that LLC is yet another LLC or a corporation or some sort of statutory trust. So obviously, you have to keep pushing and tracking through that to find out who the individual is that has authority to sign on behalf of those companies. Similar principles here. If you're trying to figure out, well, who are the beneficial owners and you've got multiple layered corporations or entities, you have to track it all the way down to the individual. And that can take time and it can be very, very complicated as well. And then you also get into if a portion of the ownership is through an exempt entity, is the subsidiary exempt? The answer is really no. That exempt entity doesn't have to file, but they're considered a beneficial owner of a non-exempt entity, so they do have to report that information. Again, determining who is a beneficial owner, we went through those couple of hypotheticals there. And then also determining who is the company applicant. We went through a couple of hypotheticals there. So it's not very clear cut, unfortunately. It's just is what it is. And those are going to lead to some compliance challenges. And they have been challenged, right? So the Corporate Transparency Act, a suit was filed in Alabama, and the court held for the plaintiffs. They found that the statute it wasn't a final ruling on the merits of the constitutionality, but they said that the plaintiffs who were asking for an injunction of enforcement of the Corporate Transparency Act, the court found that it was likely going to be a violation of their constitutional rights, right? That the Congress had exceeded its authority under the Commerce Clause and the Necessary and Proper Clause when imposing or enacting the legislation. And so they issued an injunction, but that injunction only applied to the named plaintiffs, which was a couple of businesses, individuals, and then the National Small Business, which had like 200 members. That was in Alabama. That case has been appealed. It's currently on appeal before the 11th Circuit. And I think they've had oral arguments on that at this point, and I think they're just waiting the ruling. But while all that was going on, there was a similar litigation in Texas, in the Eastern District of Texas. It's the Texas Top Cop Shop, Inc. versus Garland case. And in this case, the court agreed with its brethren in Alabama and found that it was likely a violation of constitutional law, that Congress had exceeded its authority. Except this time, it imposed a nationwide injunction. Okay, so this was earlier in December, and it imposed a nationwide injunction. And in response to that, FinCEN posted on its website, in light of a recent federal court order, reporting companies are not currently required to file beneficial ownership information with FinCEN and are not subject to liability if they fail to do so while the order remains in force. However, reporting companies may continue to voluntarily submit beneficial ownership information reports. So basically, no requirement to file, but you're still, if you want to do it voluntarily, you can, right? But wait, there's more to that story. So the DOJ appealed, right? And it went before a motions panel in the Fifth Circuit. And the motions panel said, okay, we're vacating that stay. We're going to reimpose the requirements to file, and we're going to adjust the deadlines based on the time that it was actually stayed, right? So they bumped the deadlines out a little bit, and the new extended deadlines, basically it was January 13th for all entities except those who were required to file on or after December 3rd or December 23rd. Won't go into the details because it doesn't matter now. And the reason it doesn't matter is December 26th, 3 days later, the Fifth Circuit merits panel, which is actually the panel that's going to hear the merits of the case and the merits of the injunction, reinstated the stay. They said, sorry, motions panel, you got it wrong. We're going to reinstate that stay. And so the justification for their decision was to preserve the constitutional status quo while the merits panel considers the parties' weighty substantive arguments. Much has been written and said about that last phrase there, the weighty substantive arguments. A lot of scholars, constitutional scholars, are saying that this could potentially have some legs, right? The arguments that the plaintiffs are making about the unconstitutionality of it could potentially have some merit. So again, the Fifth Circuit reimposed the stay and also imposed expedited briefing schedule. So briefs are due January and February, and oral arguments are scheduled to be held March 25th. So that's where it currently stands in the Fifth Circuit. Now, I would be remiss if I didn't point out that there are a couple of other district courts who have agreed with the DOJ and said, no, it's constitutional. You know, there's no problem with this. So there is currently a split of authority amongst the district courts. Now we're at the appellate court level in the 11th Circuit, 5th Circuit. But wait, there's more. And that is after the Fifth Circuit reinstated the stay or the injunction, the Department of Justice filed an emergency appeal with the United States Supreme Court, asking the United States Supreme Court to reinstate the stay of the injunction. So that is, you know, make it undo the injunction so that the filing requirements resume, the obligation to file resumes, while the appeals are being heard, or in the alternative, take away the nationwide scope of the injunction and only apply it to the plaintiffs involved in that case, right? And that was done on December 31st. The case was assigned to Justice Samuel Alito. He has requested a reply to be filed by January 10th, which it was filed on January 10th. There's also been 13 other amicus briefs filed in that case as well by other organizations. So a lot of folks are paying attention to this. I think a lot of businesses have a vested interest in seeing how this plays out. If you ask me how it's going to play out, I have no clue whatsoever. I'm not a constitutional law scholar, so I can't tell you. I just know that it's interesting, and I check it almost daily to see if there's been any news from the United States Supreme Court. And as of 20 minutes ago or 30 minutes ago, nothing. So here, what's the current status? What's the future? Well, there's no current requirement as we stand here today. Could change when I walk out the door. There's no current requirement to file a beneficial owner information form, and there's no penalty for failing to do so while the injunction remains in effect. They can, however, voluntarily submit if they want to. Again, this could change if the Fifth Circuit reverses its own decision and reimposes the stay of the injunction or vacates the injunction, or if the Supreme Court says we're going to stay the injunction and allow the reporting to continue while these appeals play out. So what does the future look like? Well, again, they've appealed, and the 11th Circuit is hearing the case. My guess is there's going to be a split of authority amongst the circuits that's going to have to be addressed and resolved at the Supreme Court level before this is all over. Question is, do you have to file in the interim? And the answer to that is right now, no. But stay tuned, things change often. Any? Sure, yeah, I'm happy to do that. I typically don't post on listserv because I've obligated myself now, right? Yeah, and obviously, but my information I think is on the packet, and I'm happy to speak with anybody if they have any questions offline as well. Any other questions before we move on? Yes. It's a one-time filing unless the company's ownership structure changes, and then you have to file a supplemental or amended filing. But if the That's what we're going to talk about next, which is the real estate reporting rule, a different rule that we all have to comply with. But no, the Corporate Transparency Act is just for, it's a one-time filing by the company. The company is the responsible reporting entity, and it's based on their ownership information. They don't have to refile that annually if their ownership structure does not change. If it changes, then they have to file the amended or supplemental report whenever the ownership structure changes. Mhm. Correct. They will likely just extend the filing deadline by the number of days that the injunction was in force. That's what they did on the first time when the Fifth Circuit said, nope, we're reversing, we're vacating the injunction. We're going to give you an additional 13 days because that was the time period that the injunction was in from the time that the court issued its order until the Fifth Circuit reversed it. So my guess is they'll just push it out, however corresponding number of days. Good question. Yes. Mhm. So the question, and that's a good question. The hypothetical is, let's say you have an entity, call it an LLC, and let's say there's three individual owners, and the fourth owner is like a family trust. And the question is, when you're filing the information on the beneficial owner information report, is the trust the one that you list the information about, or is it the grantor or the settlors of the trust, basically the ones that were responsible? It's really going to be both, by virtue of their ownership of that interest through the trust. I'm assuming for the sake of argument, they have 25%, right? They're a 1/4 owner, so they qualify as a beneficial owner. But assuming that is the case, you would want to disclose that information. You're going to have to disclose the information about the individuals, regardless, because that's that direct versus indirect ownership. So even though the trust owns that, the trust is controlled by the grantor, who's likely the trustee during their lifetime, if it's like a, typical family revocable living trust. So I hope that answers your question. Yes. I knew that question was going to happen today. First of all, not an expert. Two, it certainly calls into question whether they want to expend the incoming administration would want to expend time and resources pursuing an appeal of this. I will say this, what I have been able to read about it is they think there's a better than 50-50 chance that they will abandon the appeal. Now, don't hold me to that. I don't make the statements here. But that's just what, the scuttlebutt, so to speak, of what I've heard. Yes. There was somebody over here, right? Oh, okay, sorry. Oh, sorry. You're talking about the beneficiaries of the trust? Um, that's a good question. Um, yeah, yeah. Yeah, they have no control. They have no control over the entity, the reporting entity, because they're just an owner of it. And they're just a beneficiary under the trust. So I would say no, they don't qualify as a beneficial owner under the substantial control test. That's just one element of it. I think the trust itself, if it owns more than 25% of the entity, then the trust, as a beneficial owner, you must disclose and report information about the trust, including the grantor settlors of that trust. What I will say, though, is probably want to look at the small entity compliance guide and the FAQs to determine if that particular scenario would require reporting information about the beneficiaries, the named beneficiaries of the trust. I honestly don't know off the top of my head. So that's a good question. Any other questions? Yes. It doesn't say. My estimation, it would be per person, right? Because they're going to seek enforcement against every individual owner. That's yet to be determined. There's not a limit. You'll see in the reporting, under the reporting rule, there is a limit, but I didn't find a limit for the CTA. Hence the constitutional challenges that are going on. All right, moving on to a different rule now, but under the same umbrella. It is not the Corporate Transparency Act. It's the new real estate reporting rule. Now, this is not a separate piece of legislation like the Corporate Transparency Act is. This is a reporting rule that FinCEN has adopted under the Bank Secrecy Act, the BSA. So the final rule was promulgated in August of this year, with reporting requirements becoming effective December 1st, 2025. Again, same purpose underlying the CTA, purpose is to deter money laundering and funding of terrorism and illicit financial activity. How it's different, so the justification is persons involved in real estate closings and settlements, including settlement agents, are considered financial institutions under the definitions of the Bank Secrecy Act, right? So traditionally, enforcement of transfer reporting, like let's say under the GTOs or things like that, has traditionally been borne by the banks. That is the lender who is under an ASMR reporting requirement, and mortgage lenders or other financial institutions. What this does, and it's significant, is it broadens the scope of the transfers that are reportable, number one, and it shifts the burden of reporting primarily to settlement agents. That's right, closing attorneys now get an additional thing on their plate to do. So we're going to talk, same thing, we're going to do the who, what, when, where, and how, and then we're going to wrap it up with a little bit of potential compliance challenges. Right. So first of all, what are these different than GTOs or, and the CTA? How are they different? So the real estate reporting rule requires settlement agents to file a report for each qualifying non-financed residential property transaction within roughly 30 to 60 days from the transaction. Okay, that's our working definition, and we'll talk in more detail about what is non-financed, what is residential, all that stuff. GTOs, geographic targeting orders, have been around for a while. They also require the reporting of similar information, transactional information, but they differ from the new real estate reporting rule in the following ways. So GTOs have a $300,000 reporting threshold. Real estate reporting rule does not. It does not have a minimum amount to qualify as a reported transfer or reportable transfer. GTOs are targeted, that is, they're limited to certain jurisdictions and certain counties within jurisdictions, whereas the real estate reporting rule applies all across the US. It doesn't differentiate. GTOs did not include transfers to trusts. The real estate reporting rule does, with an exception for estate planning trust, which we'll talk about in just a moment. And then here's the biggest thing. The primary responsibility for reporting will fall on the settlement agent, not the banks or the lenders. It now falls on you under the reporting cascade. Again, Corporate Transparency Act only requires one report, that is the beneficial owner information form, to be filed per company, not per transaction. The real estate reporting rule requires a report to be filed for every transaction. CTA is just one report based on the company ownership structure. Again, the CTA doesn't require transaction-specific information. It's not tied to a particular transaction. And the reporting responsibility under the CTA is on the company itself, not the closing attorney who's handling the transaction. That's just how they're kind of different But they all kind of weave together to kind of have this layer of compliance that you have to be mindful of. All right, so the who. Well, who is required to report? Well, the real estate reporting rule establishes a reporting cascade. And that reporting cascade is that 1 through 7 that are listed there. As you can see in bold, the persons listed as the settlement agent on the closing statement are considered to have the highest primary responsibility of reporting. So in your typical transaction, you're the closing attorney, you're the settlement agent, you're dispersing the funds, you're the number one primarily responsible for reporting this information on each transaction. Now it goes down from there. If there isn't a settlement agent on the closing statement or whatever the case may be, there's a lower priority that it cascades down. I will point out that you can designate reporting responsibility to another in the reporting cascade. So this is negotiable, right? You can say, well, I'm not going to report this information. We're going to agree in writing that so-and-so is going to be the designated reporting agent, and they're going to report this information for the transaction. Right. Correct. Yes. Well, so you can designate to someone else who's within that reporting cascade. I highly, highly suggest you have that designation agreement for that responsibility in writing, if you choose to do that. But the basically the FinCEN in publishing the rule, they call this the flexibility aspect, that it gives the settlement agent or the parties involved in the transaction flexibility as to who is going to be designated with responsibility to report. Practically speaking, I don't see that it's going to be anybody other than the closing attorney and the settlement agent. So I think everybody is going to say, well, you're the highest priority under the statute. You do it. I don't want to touch it. I don't want to be responsible for it. So unfortunately, I think it's all going to fall on the closing attorney's plate, despite the ability to delegate or designate someone else to do that reporting for you. All right. So again, the main takeaway here is the reporting burden now shifts to the closing attorney. Again, prior to this, it was the lender, your big banks, your big mortgage lenders and things like that are subject to anti-money laundering reporting structures, and they have reporting processes and procedures in place to report transactions. They were the ones reporting on this. Now, under this rule, it shifts, right? Another thing is many closing attorneys, if I were still in private practice, I'd be one of them, may not be prepared in terms of processes and procedures to gather the necessary information to be able to report. It's not part of the closing process that you've trained your staff on and how to do it. The other thing is a lot of the closing software vendors, and I don't know what status there is, they don't have the ability to sort of bake this into your closing software where you can just have that information in there, electronically file the report using your closing software. So there's a lot that remains to be seen about, again, including whether this will actually come into play on December 1st, 2025 under the new administration. So, but again, some compliance challenges. I had a hand up in the middle. Yes, ma'am. I'm not aware of anything that would prohibit that. If there is a service, I know there's some companies out there that will do like a 1099 service for you. Yeah. 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 I'm not aware of anything that prohibits that. I do think you would still ultimately be responsible for it, even though you've designated that filing authority or responsibility to someone else. So I would be careful just who you choose to, do designate under that. That's a good question. And there was one in the back. Yes, ma'am. That's a good question. Well, so what's important to know is this is not in effect yet. It goes into effect December 1st. Yeah, I do fully expect that there's going to be some similar litigation that is filed. I don't know who that would be. You got a different group of plaintiffs here, though, right? Who are your plaintiffs? Plaintiffs are likely your sellers, your buyers, or the closing attorneys, right? So, there's differing interests involved in this litigation versus or this enforcement of this rule than there is for the CTA. So, it could be, again, I'm not prognosticating or saying one way or the other. It could be that the new administration comes in and says, we don't like this rule. We don't want to enforce it as written, and they may make some changes to it, or they may say, we're not going to enforce it at all. Who knows? So. I'll pick up the phone and call him. Yeah. Yes. Yes. You. No, I have not. Yeah. So the answer is we're going to cover that in just a minute. The where and the how. FinCEN hasn't published the actual form yet or created the portal. So we don't know exactly where and how, but we're going to get to the information. Good questions though. All right. So now what? We know who is required to report. That is the closing attorney bears the primary responsibility. Well, what are they required to report? Well, a real estate report must be filed on any reportable transfer, which is defined in the final rule as a non-finance transfer to a transferee entity or transferee trust of an ownership interest in residential real property, and an exemption doesn't apply. So that's really a 4-part test. It's got to be non-financed to an entity, a transfer entity, or a trust of an ownership interest in real property, and an exemption doesn't apply. Correct. It's only to entities and trusts. Correct. Yeah. So we're going to take each element of that and we're going to break it down. So what is considered a non-finance transfer? Well, under the definition, under the final rule, a non-finance transfer is a transfer that does not involve an extension of credit to all transferees. All transferees. That's important. That is both 1, secured by the transferred property, and 2, extended by a financial institution subject to an anti-money laundering program requirements and SAR or suspicious activity report obligations, right? So your typical loan with from a Truist or something like that, like a bank that is subject to anti-money laundering and SAR reporting, that would consider to be a non-finance, or that would be considered to be a financed transaction, right? Because the bank is extending credit to, if they are extending credit to all individuals, that is on title. That's a big distinction here. So transfers that are financed by a lender without an obligation to maintain the AML or the CFT program and a requirement to file the SARS report are treated under the final rule as non-finance transfers that must be reported. Okay. So basically what you can think of is if you're dealing with a typical purchase money lender who is a national mortgage lender, a bank or something like that, that has an AML or a SAR reporting requirement obligation, and they're satisfying that, that is considered to be a financed transaction and is outside the scope of this rule, right? So it's not reportable in that sense. It's when you're dealing with private lenders, hard money lenders, investors who are lending money on it. Cash deals, things like that. Those are considered to be non-finance transfers under the rule. What's that? Owner financing. Exactly. Yeah. So a couple of takeaways. One, all owners must be borrowers on the loan or it's considered to be non-financed. Okay. So if you have a situation where the person is taking title in an LLC, and let's say there's 2 owners of that LLC, and only one of those owners is qualifying for and obtaining the financing. And let's say they're the manager, majority holder of the LLC. If they are taking, or excuse me, let me back up. I misspoke. Let's say that you're taking title in 2 LLCs. Okay. One, you've got ABC LLC and XYZ LLC. Both are on title, each own 50%. Well, if only ABC LLC is being a borrower on the loan that's being obtained and not XYZ LLC, And that removes it from the being considered a finance transaction and moves it into the category of being a non-finance transaction, because not all owners on the property are borrowers under the loan. Does that make sense? Yes, ma'am. I still think that would be a non-finance transfer because they're not a primary borrower. They're not pledging their interest in the property as collateral. Good question. Yes, sir. Well, it's one of the requirements is it's got to be secured by the transferred property. Yes. If the spouse is on title. Yeah. Well, so again, we're only talking, and this is the next element that we're going to talk about is it's only if the transferee is an entity or a transferee trust. Yeah. Yeah. So if it's an individual, husband and wife, it's not going to apply. Good questions. Oh, sorry. Back up. Again, I'm sorry, what? I think it's only for a transfer. That's the way I interpret the rule, that it would not apply to a refinance transaction. Again, loan must be secured by the real estate in question, and the lender must be subject to AML or SAR reporting obligations to take it outside the scope of this rule. So in other words, if the bank is already filing these reports or this information through the AML and the SAR reports, then it becomes a transaction that is not considered reportable under this rule by the closing attorney. Okay, examples of non-finance transactions: all cash sales to a transfer entity or a transfer trusts, transfers to multiple transfer entities or transfer trusts where not all of the transferees are borrowers on the loan, and then private financing or hard money lenders, or as she pointed out, owner financing. Those are all considered non-finance transfers under the rule that are potentially reportable. All right, so what is a transfer entity? A transfer entity is defined as any person other than a transferee trust or an individual. That's a pretty broad definition, right? For example, a transfer entity may be a corporation, partnership, state, association, or limited liability company. Again, it's very broad. It applies to both domestic and foreign entities. So basically, if you're not a natural person or a transferee trust, then it is deemed to be a transferee entity unless one of the 16 exemptions apply. Again, the exemptions they're limited to banks, credit unions, insurance companies, securities dealers and brokers, or other highly regulated large corporations. So not going to apply to 95% of the transactions. Again, you would want to refer to the real estate reporting rule FAQ page, which is also on the FinCEN's. You can just Google it. It pops up. A lot of good information here, a lot of hypotheticals that they spell out. It gives you information. All right, what is a transfer trust? Well, a transferee trust is any legal agreement or arrangement created when a grantor or settlor places assets under the control of a trustee for the benefit of one or more of the beneficiaries of a specified purpose, and includes most trusts and similar foreign legal arrangements. A transferee trust is a transferee trust regardless of whether the residential real property is titled in the name of the trust itself or in the name of the trustee. So for example, statutory trusts such as Delaware Statutory Trust and Land Trusts are included within this definition, and it applies to both domestic and foreign trusts. Now, here's the big question everybody asks: what about self-settled trust? Well, technically under the rule, and FinCEN's FAQs say this, is the trust itself is still considered a transferee trust, even though it is a self-settled estate planning trust. However, they do go back and provide for an exemption for transfers to a self-settled trust if the transfer is for no consideration and it's made by an individual, either alone or with their spouse, to a trust of which that individual and or their spouse both are settlors and grantors, right? So it's very limited. It's limited to that estate planning scenario where property is in husband's name and wife's name, and they're transferring to themselves as trustees of a family revocable living trust. That's considered not to be a reportable transfer, even though the trust is technically still considered a transferee trust. They're just saying, we're going to carve out those transfers and make them non-reportable. All right, what is residential real property? Well, under the definition, real property located in the United States containing a structure designed principally for occupancy by 1 to 4 families, land located in the United States on which the transferee intends to build a structure designed principally for occupancy by 1 to 4 families, a unit designed principally for occupancy by 1 to 4 families within a structure on land located in the United States, or any shares in a cooperative housing corporation for which the underlying property is located in the United States. Okay. So again, pretty broad definition. I'm going to point out some of the key points. One, this applies to both existing single family as well as vacant land that is zoned as residential or upon which they intend to build a residential structure. It also would apply to mixed use where let's say you have property designated as residential that's located above commercial or retail office space. Because it's residential, it still applies. Also, it applies to ownership interests in a cooperative, even though you're not transferring the actual title to the property, that remains vested in the cooperative corporation. Because they are getting a vested interest in real estate, they consider it to be part of a residential property that is subject to reporting. All right, so a couple of exemptions. This is where the trust exemption comes in. I've highlighted, there's really 8 that are spelled out, but I've highlighted a few in bold. So number 2, a transfer resulting from the death of an individual, whether pursuant to the terms of a will, the terms of a trust, or the operation of law, or by contractual provision. So for example, party A dies, party A's will leaves the property to B and C. The transfer to B and C by operation of law or pursuant to that will is not considered to be a reportable transfer. That would be excluded from the reporting requirements here. Similar, a transfer incident to divorce or dissolution of the marriage or civil union. So, if bless you, by the way. And so if the parties are getting divorced and it requires the husband to quitclaim the property to the wife, that would be exempt under this exemption. 6 is the revocable estate planning trust, a transfer for no consideration made by an individual either alone or with their spouse to a trust of which that individual and that individual's spouse or both are the settlors and the grantors. It's got to satisfy all those requirements to be exempt. And then finally, 7 is a 1031 exchange, like-kind exchange is not subject to the reporting requirements as well. Yeah, if there's a taxable gain at that point, yeah. All right, so just some important notes. There's no value transaction amount threshold to trigger the reporting. So transfers for no consideration, unless it's to a self-settled revocable living trust, would still trigger a reporting requirement. It's a transfer. There's no consideration threshold. So it could be for $1 or $2 and it would still trigger a reporting requirement. For example, you would have to report a conveyance of title from an individual to his or her wholly owned LLC as a transfer entity, even if it was done by quitclaim deed without consideration. It still triggers a reporting requirement. Okay, so what information needs to be filed? And I think this is to Bo's question, is on the real estate report, the person submitting the information must identify themselves, the residential real property being transferred, the transferor, the transferee entity or transferee trust, the individuals representing the transferee entity or transferee trust, and all the beneficial owners of the transferee entity or transferee entity trust. And then for the beneficial owners, it's the same information that is collected into the CTA. So you see there's a little bit of duplication going on here. They might be getting this information directly from the company if they file a BOI report under the CTA, but every time they sell a piece of property, they're gathering it and they're getting that information again. So there is some duplication of efforts there. The reporting person must also report the total consideration paid for the property, along with certain information about any payments made by the transferee entity or the transferee trust. What I want to highlight here is we don't know, because they haven't specified the form or the portal from FinCEN yet, what that looks like and what specific detailed information. This categorical information is coming from the frequently asked questions and the guides that are on FinCEN's website. Again, who is considered to be a beneficial owner? So it has the same definition that we just covered under the CTA, at least 25% ownership interest in the entity or exercise substantial control over the company itself. So the beneficial owner of a transferee trust is any individual who is a trustee or otherwise has authority to dispose of the transferee trust assets, is a beneficiary who is the sole permissible recipient of income and principal from the transferee trust, or has the right to demand a distribution of or to withdraw substantially all of the assets of the transferee trust, is a grantor or settlor of the revocable trust, or is the beneficial owner of any entity or trust that holds one of these aforementioned positions in the trust. So, a lot going on there, but basically, if it's a self-settled revocable living trust, the grantor acts as the trustee during their lifetime. Then they're going to be considered the beneficial owner of the trust. So when do the reports need to be filed? Well, it's generally between 30 and 60 days from the transaction. Again, this goes into effect, if at all, on December 1st of this year. So the report must be filed by the last day of the month following the month in which the closing occurred, or 30 calendar days after closing, whichever is later. So generally speaking, this will be sometime 30 to 60 days after closing. An example would be if someone closes on March 31st, then the report would be due by April 30th. Whereas if somebody closes on, let's say, the beginning of the month, February 1st, the report would be due by the end of March. So you have that sort of 30 to 60 day window where it's going to be portable. And again, we don't know exactly where these will have to be filed. They haven't created the portal. And it said they will publish additional guidance before December 1st, including the form of the reporting and the reporting logistics, but it will be electronic filing under the Paperwork Reduction Act. So we do at least know it's going to be something similar to the BOI filing requirement. Okay, penalties. And I hear everybody's ears perk up. So penalties for noncompliance. As of August 2024, penalty was $1,394 per violation, with a penalty with a $108,489 penalty for a pattern of negligent activity. Okay. Willful violation could result in up to 5 years imprisonment and a fine of $250,000. Civil penalties may also include up to the amount the greater of the amount of the transaction involved, or $69,733. So you can see it's pretty serious. And I think that's why there's going to be some potential challenges to this before it goes into effect. So again, compliance challenges, much of the same things that we see with the ETA or with the CTA, gathering all the necessary information from the parties. There's no exception for filing incomplete reports because you don't have the information from the transferee entity or the transferee trust. The onus is on the closing attorney to get this information or just not proceed with the transaction, right? It does impose a reasonable reliance standard unless the settlement agent is aware of facts that would call into question the reliability of the information. So for example, that's what I told you earlier. If you're being given information by the transferee entity or the transferee trust, but you have information independently that contradicts that, you can't turn a blind eye to the information that contradicts what they're telling you. You have to reconcile that or choose to file it as you see fit. So again, FinCEN allows reporting settlement agent to designate, that should be designated, or choose their own form for collecting the information if you want to, but they're going to publish a form. At least that's what they say on their website as of now. And then record retention, you must maintain a copy of the certification signed by the transferee or the transferee's representative as to the identities of the beneficial owners for 5 years. So you don't have to keep the actual report that you file, but you do have to keep a copy of the certification that's signed by the representative of the transferee entity or transferee trust telling you who the beneficial owners are. Again, there's a 5-year record retention requirement. Okay, that's it. Sorry, that was a lot of information, guys. I know it's a pretty heady topic, but if you have any questions, I'm happy to answer any questions. And I'll provide my contact info if anybody wants to reach out and discuss. Any questions? Okay, awesome. Thank you.
And he was nice enough to fly in for this presentation. I mean, if you want, it's 11:15 though. It's kind of early. Do you think you guys might be hungry if you eat too early? I say that to my dogs all the time because they're always asking for food, want dinner at like 3 o'clock. But we'll go ahead and get started. And then after Jeff's presentation, then I'll have you guys go out, grab lunch, and then we'll just keep going. We'll just truck along. We're lawyers. We can do this. Okay, so I want to introduce Jeff Lanier, and he is head of finance for Stewart Titles Agency and Commercial Businesses, responsible for overseeing the financial planning and analysis analyst organization to drive business growth and profitability, including Stewart's agency financial advisory service and head of Stewart's economic research and reporting. Prior to Stewart, Jeff was a leader in Deloitte insurance and M&A practice, served as head of finance and administration for the National Life and Retirement Retail. Sorry, y'all, I don't have glasses on right now. Distribution, IMO, and served for a decade in a variety of leadership roles at AIG, including global head of health business alliances, vice president and chief of staff to the CEO of AIG Global Life, Health and Annuity Businesses, and Director of Strategy and Financial Planning for AIG Life, Health and Annuity. He has worked with insurance businesses based in the US, Japan, UK, China, Ireland, Israel, South Korea, and Latin America. Have you been to all those places too? Nice. Mr. Lanier has a BA and a BAA from UT Austin and an MBA from Rice University. So introducing Jeff Lanier. Okay.
Played also Liberty Mutual, Mass Mutual, Transamerica. The one thing I learned about big, gigantic corporations is they love to throw money at problems. They love to throw money at problems. So my goal was always just to be the next problem. So I'd get all the money. I am usually a walker, so I'm going to try my best to stand near the podium, but if I mess up, I apologize. I am talking about economics, by the way, so brought toothpicks for your eyelids in the back room if you need those. Has anyone seen Clockwork Orange, the movie Clockwork Orange? Okay, so you know what I'm talking about. There are a couple of other weird people besides me in the room that have seen Clockwork Orange. Oh, okay, excuse me. Not weird. Oh, okay. So I spent most of my time and effort on my cover slide. You can see I did that's the 30-year mortgage rate overlaid on the sky view, and then a pithy title, economics. So we will jump into it. It is mostly going to be all about economics, which is pretty dramatic right now, at least if you're paying attention to it a lot. I am from the title insurance company, underwriter. So just a brief thing about what title agencies are facing right now. Most probably are aware of all of this. Digitization is increasing the costs. It's obviously a huge requirement for title agencies right now as we get further into this world of IT environment. That's really adding a lot of cost. And if you're a small agency, that's a huge burden on your operating expenses. So that's one of the big ones. Wire fraud is now, I see you guys have a session on wire fraud later today. I don't even know if I was going to say if you're a small title agency, but I don't even know if it matters what size you are. If you get hit one of these big wire frauds, it can put you out of business. So that's a major one as well. Both of those, plus the market environment that we have, is obviously creating some issues for title agencies just to struggle and make it through and survive. And so there's going to be some separation. There's going to be some activity. Plus you've got retirement. I don't want to, if I'm looking to retire, I don't want to invest in what I need to in wire fraud and digitization. So I'm looking to exit. So those are all the kind of things that are happening. I'm going to talk mostly about the market today. Which I had to update my slides this morning because big reports on the inflation came out today. So I'll talk a little bit about that. Inflation today was at 2.9%. I don't know if anyone pays attention to all that, but it is increasing, which is the wrong direction. A little bit about where we are, why we are here today. As you know, inflation was up significantly. The Fed started raising their Fed funds rate, and then it started coming down, and that's what you can see here the last several months. What happened was, while inflation was coming down, the more important thing was the unemployment rate started to come into focus for the Fed. The Fed's in charge of two things: in charge of price stability, which is basically inflation, and unemployment. Those are the two things it's in charge of, the only two things. And the Fed funds rate is basically its main tool. So what happened was the unemployment rate, as you can see, went on a multi-month increase. For about 12 months, it was increasing. So they finally had to say, we got to start paying attention to our second mandate. And while inflation was coming down, as you can see, and it did finally cross the 3% mark, the Fed's target rate is always 2%. That's just 2% their target rate. So the rate finally came under 3%. Unemployment was continuing to increase. So they decided to go ahead and make that first rate cut in September. That's kind of what drove that. Not necessarily that inflation was paying. Point of today, it's now ticking back up, which is a bit of a concern. So that's kind of where we are today. You can see kind of the unemployment, 4.3, 4.1, 4.2, up and down. Last week's unemployment rate came in at 4.1, which was down, which is good, except it signaled to the market that maybe the Fed made a mistake. Unemployment's pretty good, economy's pretty good. Maybe they made too large of a rate. The chart on the right is simply the wild ride that we've all been on for the last several years. You can see the gray bar is inflation. That's that huge big spike. The green bar is the 30-year mortgage rate, and the red bar is the Fed funds rate. So you can see there where we are just significantly on basically a roller coaster ride. If you're like me, I put a number up on a slide, let's say 4.2. In fact, in October, there was this unemployment number that came out as like 12,000. We usually add 180,000 jobs a month. Report came out 12,000. The market freaked out. This number went to 4.2 on unemployment. Everyone thought we were in a recession. Lasted for about 4 days, and everybody calmed down. But I thought, well, I wonder what the average unemployment rate has been as far as back as I can look. So found the average unemployment rate is 5.7. So we're not near that right now. And I thought, well, I wonder what the minimum was. Turns out the minimum is 2.5. I thought, well, I wonder when that happened. That happened in 1953. I thought, well, maybe I'll chart a little line, and I thought, well, I wonder what happened in 1953. And next thing I know, I have this slide. So I am a history major, undergraduate. I assume actually there's a room full of lawyers, so I bet all of y'all were history majors as undergraduates. Actually, I don't know that, so I am curious. Raise your hand if you were a history undergrad. Only a few, really. Okay, so the only other things that leading to law school, I was thinking English grad, philosophy, poli-sci. The only four. Oh wow, there it is, poli-sci. That was my fourth guess. Yeah, okay, so I'm a history major. There weren't not as many as I thought. Okay, so you can see 1953. There's the minimum, and 2.5. We're just coming out of the war. A lot of activity. Oh, it was all great, hunky dory. So the unemployment was great. Couple of interesting facts. 1953. A couple other things happened in 1953. 2 people were executed in 1953. Anybody know who they were? And I think we have. Well, I'm going to claim the raffle ticket. Hold on 1 second. I'm going to claim. Can I pass out a raffle ticket? Oh, the leaders aren't it. Oh well, sorry. I don't have it. Yes, exactly right. You get something. You get an extra drink. By the way, I will not be with you at cocktails today, but I promise you I'll get through my deck so that you guys can get cocktails today and lunch. So I'm going to speed through it. So if I go really quickly, that's why. Yes, the Rosenbergs were executed in 1953. Actually, I was wandering around in the lobby. There's a photograph of them in the little museum that they got here. Also in 1953, something was deemed legal to use in interrogation by the CIA. Does anyone know what that was? LSD, truth serum. And then the first Corvette was rolled off the line. Okay, so the thing I really want you to pay attention on this chart is simply the ups and downs. This is a roller coaster ride. The orange line is the, which one's that? The unemployment rate, and the blue line is the Fed funds rate. Those are the two inflation rate. Those are the two things the Fed is in charge of. And if they had their way, it would just be a nice, smooth, straight line. That's their goal. Obviously, it's harder to do than you think, I guess. They do the best job they can. There's only been one quote unquote soft landing. When everyone talks about the soft landing, maybe we'll hit a soft landing. There's only been one soft landing, and that was in 1995 when Greenspan was there. He, saw some signs, so he increased the Fed funds rate and then very quickly decreased it, and he made him a genius, and everybody thought he was fantastic. And that's why he's so famous, because he's really the only one that did the one soft landing. I only mention that because everyone always now is talking about soft landing. Maybe we're there, maybe we're not. I don't know. There's only been one once, so we just need to be cognizant of that. The other thing I'm going to point out is in 2008, after the global financial crisis and at COVID, the Fed started directly impacting the real estate market by buying mortgage-backed securities. I'm going to go into that a little bit more because it's important about how it impacts the mortgage rate. So those are the two things, two periods that they went and bought mortgage-backed securities, which we'll get into in a minute. So the Fed funds rate coming down, they're bringing the Fed funds rate down, but the 30-year mortgage is going up. Why? Who knows? That doesn't make sense. But as soon as they hit the first September rate cut there, you can see 30-year went up, 10-year went up, and the 30-year rate went up. The reason is because the 30-year does not follow the Fed funds rate. 30-year follows the 10-year Treasury. So the Fed can cut the Fed funds rate, and it really indirectly it'll have some impact on the 30-year, but really the 30-year rate is set off the 10-year rate. Okay, and there's a lot of things happening around that's making the 10-year move in a different direction. So chart on the right just shows dramatically, okay, the red line's the Fed funds rate. As it comes down, immediately the 10-year and the mortgage rate went up. The reason is because the Fed is in charge of only the Fed funds rate. They don't do the 30-year mortgage. They don't set the 10-year. The Fed funds rate is a short-term rate. It's basically an overnight rate that banks charge each other to borrow money. It'll impact maybe 1-2 year rates, like credit card rates, right? So as the Fed rate comes down, those 1 and 2 year rates, the credit card rates, those come down. It allows people to start spending money. But the 10-year is a longer duration. It looks out 10 years, and it's saying, okay, what it really is the sentiment. It's more of a feeling instrument. It's kind of sentiment and fact, more sentiment than fact. And it says, how do I feel about the market over the next couple of years? And the biggest thing that impacts the 10-year is inflation concern. Okay, so in this instance, in September, we live in a weird world now. So in September, the Fed cut the rate by 50 basis points rather than 25. So the market immediately thought the Fed was trying to get in front of a recession. And so they panicked. 10-year thought market wasn't doing well, so it started going up. As we get closer to September, October, November, December, as we get a little bit closer to the new administration coming into the White House and certain policies, the market got worried about inflationary policies. So whenever you get worried about inflation, the 10-year is going to go up. So right now, what's causing the 10-year to go up is inflationary concerns, both tariffs, tax policies, tax cuts, immigration, right or wrong. That's what the market is worried about inflation. That's why the 10-year is going up. Now, normally what happens is a mortgage banker is going to take the 10-year, put a couple of points, make some money off of it, and set the 30-year rate. That's usually 1.5, 1.7 spread, what they call the spread, okay? So that's not where we are right now. We're at 2.28 today. Average over the last couple of years, 2.7. You can see the average over a long time is 1.7. So that spread, so not only do we have a high 10-year, we also have that spread between the 10-year and the 30-year, okay? There's several reasons why the spread is higher. We've got a high 10-year, largely just concern in the market. That should come down as concern lessens, but the spread is higher for a couple of reasons. The first reason is technicalities around some Basel bank requirements and fees related to that. So that's going to get passed on. So that's fees on top of the tenure that the mortgage banker is going to put on. The other thing is something called a mortgage-backed security. Now, a mortgage-backed security basically is, as we all pay our mortgages to a bank, the bank takes all those mortgages, packages them up in an instrument, puts them out and sells it into the market. Okay, so if I buy one of those instruments, as mortgage rates go down, I'm going to refinance my house, right? So I'm going to take that mortgage, close it, go get another mortgage from another bank. And all of a sudden, I'm the investor. I bought this mortgage-backed security, and all these people are leaving. So my revenue stream is disappearing. So that's interest rate risk, and nobody wants that. So when the rates are high, nobody really wants to buy those mortgage-backed securities because the rates are eventually going to come down. They have interest rate risk. Nobody wants to buy MBSs. And the biggest buyer of an MBS is the Fed and the Treasury, and they are not buying mortgage-backed securities for interest rate risk purposes. And also, the points that I pointed out in the first chart, the history chart, where they bought a bunch of mortgage-backed securities. This shows you how significant the number of mortgage-backed securities. This is in 2020. That blue line is a spike of them buying mortgage-backed securities. When they buy mortgage-backed securities, the 30-year rate goes down, okay? Now they've got $9 trillion on their balance sheet. They're trying to get rid of it. So they're kind of slowly selling off these mortgage-backed securities, or at least not, or letting them mature on their own. And so as they sell, the mortgage rate's going to go up. So that's what's happening also. The chart on the far right shows the blue line is mortgage-backed securities. The red line is a 30-year. You can see 2020, they bought MBSs. The rate went down. As soon as they started selling, mortgage-backed security went down and the 30-year went up. So you got the 10-year is inflated due to inflationary concerns. You've got the spread between the 10-year and the 30-year impacted by additional fees that are coming in. Nobody's buying mortgage-backed securities in addition to interest rate risk and concerns on inflation. Excuse me. So that's kind of what's happening with the mortgage rate and why it goes up when the Fed rate's going down. From the economy standpoint, looks okay. I mean, it's not gangbusters, but it's not cooling and it's not in a recession. So the CPI came out this morning. It went up 0.4%. Last month was 0.3. For a year basis, 12 period, it's 2.9. And this is all related to this chart on the left, inflation. When we say inflation, that really means CPI, or Consumer Price Index. So that went up 2.9%. The Fed also looks at something called core CPI, which just takes out food and energy, because they like to see that better. That gives them a little bit longer term period. I don't know about you and I, but I only spend money on food and gas. So I'm not taking it out. 2.9 is 2.9%. But the core CPI did come down a little bit. So the market's kind of excited about that. Market's not very smart sometimes. Anyway, if you remember in October of 23, they thought we were going to have 8 rate cuts. Luckily we had 3. I think the December one was close. Anyway, GDP still improving. The arrows indicate the trend from like the last period. So GDP is still going up and went up from last period. Unemployment again coming back down from last period. S&P had a pretty bad December, but overall it's 23% above, and the 2-year period is like 56%. So pretty strong market. I like to put Amazon on here. I call it my milkman index because I don't know about you guys, but Amazon's at my house every morning. And that's a pretty good index of people buying. In fact, my mom sent me an email last week. It said the subject was OMG. My mom's 84 years old. It said OMG, and then the body was, I've learned how to buy things off Amazon. So if my mom, 84-year-old mom, can be buying off Amazon, the economy is doing well. My point is, we should be cautious. And I should also mention, I haven't heard, Fed now thinks only 1, maybe 2 rate cuts this year, whereas 2 months ago it was 6, 7. Now they're saying 1, 2. It might even be 0. And the question is, if inflation keeps going up, would there be a rate increase? So anyway, the point of this slide is the economy is doing fine and doing well. Unemployment's coming down. You have good economy, low employment. I'm not sure why there needs to be a rate cut. But we'll see. You never know. For the next slide, you never know what the Fed's going to do. But I'll give you some facts around the Fed. They always strive for something called the neutral zone, which is when the inflation rate and the Fed funds rate are basically the same. There's no pressure on either one of them. And so the gap between those two is the gap that has to be closed, okay? And they're trying to get to the neutral zone. Today, the neutral zone is the gap is 1.78. So in theory, that's, what is that? 7 or so points, quarter points. But I never really think about that because as you bring down the Fed funds rate, inflation's going to come, so they're going to move together. So that's a lot closer to maybe 2 to 3 rate cut points in my view. And that's kind of what they're indicating. There's also something called the Fed dot plot, which is really just for economic nerds. And it is basically a report that comes out every quarter where each dot represents a Fed president. There's 19 Fed presidents, and they each say, oh, I think we're going to have 2 rate cuts or 6 rate cuts or 1 rate cut. And they chart it. Some analyst just draws pictures on a thing. And there's no math at all involved in this. It's just how they feel. And today it comes out and they take the majority, which is that long line now, which is just 2 rate cuts. So that's when the market says there's going to be 2 rate cuts. This is what they look at. They look at this dot plot and they see what the average is. That's all it is. This dot plot changes constantly. The last one said 6. The one in October said 8. That's why the market says 6 or 8 or whatever. They're just looking at this and it changes constantly. So I wouldn't put any weight into any of this, to be honest with you, because who knows? It literally changed 3 weeks ago. But from a historical standpoint, I think heading towards a neutral zone and the historical average over the long term is 4%. So 2 to 3 rate cuts. And this is over a 2-year period. This isn't like 2 to 3 rate cuts over the next 2 to 2 years seems reasonable, especially in the environment we're in. Economy's doing well, unemployment's low. Any of those changes, who knows? Everything's out of the bag. So we'll take a look at Fannie Mae and MBA, what they think in terms of the residential 30-year mortgage rate. They don't see it anymore. It used to be 2, 3, 4, 5 months ago, this was under 6%. Now it is no longer under 6%, 25 or 26, because of all those things I explained about the gap between the 10-year and the mortgage rate. In my view, you got to get under 6% to get our real estate market really moving again. That's my view. Under 6%, it'll move. And the problem is, you can see the quarters there. Doesn't really matter at this point. They're all kind of the same. It's low 60s. We used to use this chart to see when it dropped under 6, what quarter in finance. The problem is, you've got 76% of people who have a mortgage that's under 4%. I have 2.75. I'm not moving anywhere. I can't move in the same house, same quality, same neighborhood, nothing, same size, nothing. I'm not moving anywhere. And 76% of us in the room, in theory, are in the same boat. So that's why you got to get at least under 6 to be able to move some of this green into the blue and start averaging some of this stuff out. It's improved a little bit. Now there's life events that will, death, divorce, retirement, new home buyers, all those kinds of things will happen. This is called the lock-in effect. Everyone's kind of locked in their mortgages. Those life events, if it's up in the high 6s or 7s, it's just going to take longer to go through. That's all. As the rates come down, working through this lock-in effect will be faster. So it's just a question of duration. And right now, it looks like it's a while. And that's a lot of people. And the reason, I go back, the reason we have this lock-in effect is that red line right there after 2008, after the global financial crisis, the Fed funds rate was at 0 for like 20, what is that, 20 years? 10 years. It was at 0 for 10 years. So everybody went and refinanced. Everyone went and refinanced and now has a mortgage under 5%, 2.75, 3. So we created our own problem, to be honest with you. Ooh, I went the wrong way. But we created our own problem, but it is what it is, and we'll work through it. We just got to get it under 6%, or we just have to wait for all this, life events to kind of work it out. The things that are selling, unfortunately, are for, depending on what bracket you're in, but the things that are selling are the 750 and above, 1 million and above, and a lot of that's just cash buyers. All the other stuff is just not, there's no movement in them at all. So all these last two things creates really a inventory issue, right? So you've got everyone's locked into their own low mortgage rate. Nobody's moving anywhere. Things that are selling are way high price. So there's no inventory. This is at 3.9 months. That's 25% of low target. Low target's in your 4.75, 6%, somewhere in there. This was 4.1 last month, so it got tighter, harder, so less inventory. So that's makes it hard to do anything. The one positive sign actually is November and December year-over-year sales were up. So that's great. It's been down, year-over-year sales have been down every month for the last 38 months till November and December, which is a good sign at least. There's some optimism. Maybe last November and December were really low though, year-over-year marker. So let's take a look. MBA, Fannie Mae MBA also come out with what they think sales will be. This is existing home sales forecast. Fannie Mae MBA, again, take a grain of salt. These things change monthly. But next 4.85% growth in finance. That's what we modeled back in October. We modeled 5% growth in the market. Prices continue to go up. They have been going up for probably the last 36 months. I can't remember my number. 2.4% next year. The prices just keep going up. And I don't see prices coming down because as soon as rates do get somewhere, people are going to jump in. People are just waiting on the sidelines. They're going to jump into the market. You have no inventory. The prices are just going to keep going up. So all that, you got high interest rates for borrowing costs. You've got high prices for home prices themselves. You've got low inventory. All that's creating basically an affordability issue, right? So we have a huge affordability issue. I use the Fed, this is the Fed's chart around affordability. So anything above 100, which is the blue line, is affordable. Anything below the blue line is unaffordable. And that's simply if you have 25% of your monthly income, of the average monthly income should cover the average home price mortgage. So if that's coverage, then that's 100. Anything above that is affordable market. Anything below that is unaffordable market. And you can see where we are right now. I think it's like 67 is the number. The NAR, National Association Realtor, they have a different metric. Theirs is probably at 97, 98. I may have even read it was at 100 now. Probably back down now that the rates are going back up. The Fed looks a little bit broader. It talks about inventory, takes more things into component than the NAR. So that's the one I use, plus all my charts are based on the Fed. But you might see someone talk about 98 or something of that. That's probably the NAR. You can see the chart on the right is the drivers of the unaffordability in the home market there, and the gray is obviously the mortgage rate. So that's the big one. But as you can see, as that came down, the blue, which is prices, starts to become a major factor. So we're in a tough spot, but there is some optimism. This is another history chart. I like history charts. So I said, okay, well, what is all these averages? So the average inflation rate all the way back to I started in 1983 because I got past the Great Inflation. A little outrageous. So since the Great Inflation, the average inflation rate is 2.9, which makes sense because the Fed's target is 2. We're up and down, so that makes sense. By the way, the target for 2% Fed only started in 2010. Europe had a 2% target for several years before that, but we didn't do it until 2010. The average Fed funds rate since then is 3.7. We're at 5-ish, 4.8 right now, so that has obviously room to come down, so that's good. And then the average 30-year mortgage in 1983 is 6.5, which is basically where we are. So what I'm suggesting is we're kind of back to a normal. Like that period between 2010 and 2020 is probably the abnormal period. So, we should kind of expect this market, hopefully that 30-year comes down to under 6, and we get a bit more of a new normal. Or we have a financial global crisis. That's all we need is a global crisis. Then it'll get back to 0. So cross your fingers on that one. From a market standpoint, we always say that 5 million is a long-term average for home sales, and once you hit that, then that's a strong market. I think that's obviously going to be driven by that interest rate. Got to get under 6%. You can see that that's out to 26, 27. Don't hit that 5. We're close, but we don't hit that 5 million yet. So maybe it's 28. So that keeps getting pushed out. That used to be in 2026, used to be 5 million there. That's Fannie Mae and VA's forecast. I don't have a lot of detailed data on Georgia, but I thought I would at least bring in some information to show you how Georgia and some of the larger cities kind of stack up against those metrics that we just looked at. But from a GDP standpoint, Georgia's perfect, dead on national average, even a little bit higher actually. And you can kind of see where they stack up from some of the other states there. There's my state, Texas, from Houston, Texas, 0.8. Georgia is 3.5, so that's great. I did this in Louisiana. They're 3. By the way, I did this in Louisiana last week or last month. It was to a sales organization in New Orleans, and at 8 o'clock in the morning, they served gin and juice. So you've got a long way to go to have a decent event here. I was quite surprised, but everybody did partake, and so it made my presentation phenomenal. From a unemployment standpoint, Georgia's actually doing better than the average there at 3.7, so that's good. Atlanta, you can see 3.5. Augusta, 4.7, so they're a little bit higher. So it's driven more by Atlanta, fairly larger, so the 3.5 is going to have more weight. Gets us to the 3.7. So doing well from an unemployment standpoint, doing well from a GDP standpoint. The economic impact, just from a fact set here, is 117,000, which is pretty good. New Orleans or Louisiana was in the 80,000, so this is a pretty good number. Georgia, I think, probably has a pretty strong, well-priced real estate market, so driving all that. Home prices, 4% lower than the national average. So that means you're the 28th highest in the country or 23rd lowest. I don't know. You're right in the middle. So you can use whichever one you want there. Atlanta's 377. By the home price, I didn't mention that the average home price is 406 there. $406,000 is the average home price it was like, it is doubled in the last, since COVID. The average home price has doubled. It was almost, I think, 280 maybe, something of that nature. Home buyers lost $250,000 in purchasing power just from the interest rate. That's why nobody's moving anywhere. This is really just title. This is title performance, so title companies. This was 2023. 24 doesn't come out till much later in this year, but I do have 2Q in the next one. So 2023, obviously, from a title standpoint, was a terrible year. You can see everybody's negative, but not only negative, but 20s and 30s. Oregon was the lowest at 40, and New Mexico was the best at 10. Georgia's there kind of in the middle, negative 28. And then 2Q, Georgia did much better, 2Q positive 9.2%. You can see the lowest was 20 and the highest was 20, 21, 22 on the other side. So Georgia recovered, doing 10%. So I like to show this just so that if you do have a title company or a part of a title company, you can kind of see how your agency matched up against some of the other markets. I think that's all I have. Put out an economic report every quarter if you want that. And that's about it. We've been around for 130 years. I hope I got you to lunch.
Hey, everyone. We're going to go ahead and get started. Y'all just keep eating. If anyone got to slip out or anything, please do. Appreciate y'all being patient, and we're going to get through this day. So our next speakers are from Crevlin and Horst, right? Sorry, I just met them today, so they're very nice gentlemen. And they're both from Crevlin and Horst. I've got Halsey G. Knapp Jr. and we've got Jacob S. Edwards. And Halsey is a trial lawyer with particular emphasis on real estate transactions, graceful employment departures, representation of lawyers and law firms, and more antagonistic, high-stakes business divorces and business litigation. As a seasoned negotiator, Halsey frequently handles relationship issues with lawyers, clients, suppliers, competitors, owners, operators, and the occasional government prosecutor or regulator. Man, I want to be on the wall in your office. Halsey is part of Crevlin and Horst real estate litigation practice with extensive litigation experience involving development projects, zoning issues, and joint venture disputes. Halsey earned his undergraduate degree from Cornell University in 1977 and his JD from Emory University School of Law in 1980, where he received the Best Brief Award and served as president of the Student Bar Association. He serves as master and former chair of the executive committee of the Cooper Inn of Court and as a master in the Bleckley Inn of Court. And we've got Jake, who's a native Georgian from Forsyth County. Oh, we're neighbors. Who represents plaintiffs and defendants in a variety of civil litigation, including breach of contract, fraud, construction litigation, cyber fraud claims, and other business disputes. He has also briefed or argued appeals in state and federal courts of appeals, including the United States Supreme Court. Before joining the firm, Jake clerked for Judge I know that name though, Jordan of the U.S. Court of Appeals for the 11th Circuit in Miami, Florida, and practiced civil litigation in the Atlanta offices of 2 international law firms. While attending law school at the University of Georgia, Jake represented clients working in the child endangerment and appellate litigation clinics. Jake was named Rising Star by Georgia Super Lawyers in 2023 and One to Watch by Best Lawyers in America 2024. He is also a member of the Atlanta Lawyers Club, was inducted into the National Order of Barristers in 2017 and was selected to serve as a barrister in Atlanta's Clark Carly Inn of Court and the Bleckley Inn of Court. Please welcome Jacob and Halsey. I'm excited about this.
It's a pleasure to be here. Pleasure to be here. I've had a varied career, primarily as a trial lawyer, but I had the privilege of being a designated real estate lawyer for Arnold and Gregory when I was there from about 82 to 94, and among other things, watched the assemblage for the IBM Tower, which was a lot of fun. And then I worked with Joe Foltz and Marshall Martin from 2000, 2014, and put together a litigation section. We started one and had 12 lawyers by the time I left in 2014. So I've had a lot of exposure to real estate disputes. It complements well some of the other business issues that I've had to deal with over my career. And as you might suspect, in recent years, that entails cyber fraud and how to deal with electronic payments and the kind of issues that we all face today. So it's a pleasure to be here and to be able to talk to you today. And it's also a pleasure to have my colleague, Jake. Jake is probably the most outstanding young lawyer in our firm. He's very talented. He's probably the most organized lawyer in our firm. You walk into Jake's office, there's not a paper on the desk. Everything's organized. If you walked into mine, you couldn't even tell where the desk is. So we work together frequently because we complement each other well. Jake, tell them about yourself.
Well, I hope this yell is being recorded because I'm going to need that at some point in the near future. It's great to be here today to speak to you guys. Our firm represents a lot of different industries in litigation surrounding cyber fraud and cyber breaches. One of the things that we have kind of seen throughout our time doing that is that lawyers and law firms are doubly impacted by this particular issue because, one, your clients are targets, and everybody kind of knows that, everybody expects it. But the flank of law firms that they don't really see and understand is that you yourselves are just as much a target for cyber attacks as your clients are. And lawyers tend to look out for the interests of their clients, sometimes without properly looking out for the interests of your own firm. And often enough, the most valuable thing that law firms have is our clients' data and information. So by not protecting yourselves, you end up exposing your clients. So we try to talk to lawyers, and this is a great group because there are things specific to real estate transactions and real estate closings that have cyber criminals just already
They love you.
to target you guys. And there's a bunch of reasons why. We'll get into them, a few of them today, but really the reasons aren't as important as the fact that you guys are targets. You are targeted. A lot of professionals in this space that aren't lawyers that work specifically for detecting and preventing cyber fraud, they've tried to instill the mantra of it's not if anymore, if you are going to be the victim of a cyber attack. We are past that point. The question is when, the question is how much, and the question is what's the damage going to be? Because I'm sure most of the people in this room have been targeted. I'm sure there are several people in this room that are thinking in the back of their heads, remembering the time that their firm was not just targeted, but was actually negatively affected by a cyber attack. And that's not a knock on you or your firm. There are several AmLaw 100 international law firms in the city of Atlanta that have been shut down over the past few recent years, some public, some private, that suffered cyber attacks that negatively impacted their clients and their business. So it's a really important topic to kind of think about, and specifically for you guys in the real estate section. So just a few numbers. I'm going to pick out three of these that are commonly not as well known. A few statistics about, the average costs of a data breach in the millions of dollars. The second one on the left, that 51%, that's the percentage of organizations that are increasing their spending on cyber fraud prevention in the last year. So a lot of people here probably run their firms or have a hand in running their firms. The majority of firms in the United States are increasing year over year their spending on cyber fraud prevention, on things like cyber insurance. And that's something that law firms should continue to do as this threat continues to persist. The bottom left, that 650,000, a lot of people are surprised that the medium ransomware demand, and if you don't know what ransomware is, we're going to get there. It's a really fun topic for everyone except the person being ransomware demanded. $650,000. It's high. It's higher than people expect. A lot of times when companies or firms get hit with a ransomware demand, they get sticker shock. Inflation exists for the cyber criminals too, I guess, because post-COVID, these demands have started to become more and more out of the ballpark. And then the biggest surprising there on the right side, 277 days. That's the average amount of time it takes to identify a breach and contain a cyber fraud breach. That sounds crazy. 277 days. And the reason why it's not what you think that it takes that long to contain a breach. Of that 277 days, 204 days is the average amount of time it takes to identify the breach. 73 is the time to contain and resolve. That means that cyber criminals infiltrate systems and they wait. It's very common for companies that come in once a breach has been discovered to see that the way that the system was compromised could have been months prior. And those cyber criminals with that access were patient. They waited for a particular transaction. They waited for a particular person to go on vacation. They waited for a particular client to have an invoice due. Oftentimes, if you ever change your bank account information, they will take that as a good opportunity to insert new wiring instructions because you are currently going through a change of your business. So it doesn't flag your customers, a merger. A lot of criminals can be incredibly patient and they'll wait for the big fish to come along. And most people think, oh, if we've had a breach, it most likely happened within the last 2 weeks, 3 weeks. And most of the time that's wrong.
Jake, what about that 70% in that column of breaches that are caused by people and process failures?
Yeah. So, I mean, this is somewhat what you would expect, right? Is that a large percentage of cyber intrusion is caused by an identifiable failure of the company to follow best practices, right? Now, the 30% there is actually another interesting story. It's that there are cyber fraud, there are cyber criminals that are successful. There are incidents of cyber breach where really nobody did anything identifiably wrong, as in no one was negligent, a mistake was not made that we can identify, right? And it's because the United States government, city governments, state governments, a lot of governmental institutions, Fortune 100 companies have suffered data breaches. It's almost understood in courts now that in law school, everybody talked about a concept of res ipsa. Basically, the fact that something happened means that someone was negligent. Just the fact that a breach happens means that someone did something wrong. That's not true in the cyberspace. You can do everything right. And sometimes there's going to be some type of a way that a cyber criminal takes advantage of your system and gets in. So 30% of these breaches aren't even due to a mistake.
Let's help these folks. They're all worried now.
We've talked about this kind of in the intro a little bit about large law firms. The one I wanted to note was in 2020, that big cyber fraud number that got thrown out, a $42 million ransomware demand. It's one of the largest ransomware demands on a private company. That was a New York-based law firm. It was very public, celebrity-based law firm, handled a lot of contracts for Hollywood elites. And that information, it was stolen. And instead of being encrypted or anything, they sold parts of that information on the dark web until the firm was demanded $42 million. So that's obviously a large law firm, but that's in the ballpark of demands nowadays. But the section B there that's important is that small firms are a target. Over $4 billion in 2019 were lost due to these ransomware demands, and almost 50% of them were what we would categorize as small businesses. A lot of people think that a small firm, a small business is not going to be targeted for a cyber attack. And there are actually groups of cyber criminals that almost specialize in small companies. They think that it's easier to hit 20 small businesses for $50,000 than to go after a larger business for $1 million, right? Because smaller companies tend to not have the sophistication of cyber protection, and the response tends to be a lot slower. So don't ever think that just because we're a 3-person law firm or something like that, that you're not going to be targeted. Yeah, the specific to this group, one of the most common kind of incidents deals with large electronic payment fraud, right? And a lot of times that comes in with the use of business email. Residential real estate closings are such a huge target for this type of cyber fraud because you have high email traffic. You normally have buyers and sellers or agents that might not be as up to date with, different types of cybersecurity. They might be using personal emails. It's common, in this space to be talking to parties with personal emails that are easier to try to clone or to make emails that look similar to trick one of the other parties. And then you have a large financial transaction, often wired. Statistically, I think we read involving another case was that a residential real estate transaction can be the largest single transaction in a person's life. And obviously that's going to raise an opportunity for a cyber criminal. Also, so if you put the wiring side aside, which everyone's more familiar with, the other thing is firms in the real estate space, they hold a lot of confidential, personally identifiable information of their clients within their firm. And those are kind of the two areas where you see a lot of cyber intrusion. One is a business email compromise, where someone gets into an email thread and using either a fake email, fake wiring instructions, something like that, convinces the purchaser to wire their funds to an incorrect bank account. Another one is someone intruding into your systems in order to try to either take copies of or encrypt your confidential customer information. And in the real estate space, you have the opportunity for both. So we'll talk a little bit more about kind of the ransomware side and the business email compromise side. Business email compromise is just kind of an industry tag word for what the majority of cybercrime is in the US right now. It's currently the most prevalent, highest losses for businesses and individuals. Generally, it's the use of an email that is made to look like it's coming from someone involved in a transaction when in fact it isn't, right? We have 3 examples here, and we've given similar presentations across a lot of industries, and number 3 is in our presentation every single time. And it's a home buyer receives a message from their agent, closing attorney, title company with wiring instructions for a down payment. And
understand, it's not just the wiring instructions of the amount, but the date of the closing
yeah,
or the amount due at closing. All these aspects and elements you need to think about how you're going to protect, because there are people aggregating all this information and watching. And if they do that, they have the ability to fool you, even if you're diligent. So you need to be thinking in terms of how to protect more than simply a wire instruction.
yeah. So that's a phenomenal point. If you kind of think of the thought experiment of if you were trying to trick someone into believing you create a Gmail account is actually coming from Halsey, right? If that was my job, some of the things that would be important would be, how do I get into the email system to see what this email traffic is so that I can respond, make it look like I'm responding to an email he's having with his client. And I can kind of jump in the middle. And if you scroll down, the previous messages with Halsey would be there. The other things that I would need to do is I would need my email to look like his email. I would need my signature block to look like his signature block. If I'm sending documents, I would want my form documents to look like Halsey's. These are all the things that a cyber criminal thinks about when making a fraudulent email. Getting into the conversation is only half the battle. The other half is making it look legitimate enough that the person on the other end, normally an individual or a client that really doesn't have any specialized training or experience in this space, wouldn't raise red flags that they'd pick up the phone and call Halsey, right? So when we think—
And part of the message there is you have to think broader in terms of the information that you're protecting than you might think initially.
Yeah, it is exactly. Like, an example is for wiring instructions. Our firm does a kind of runs the gambit of civil litigation. So we have settlement agreements pretty regularly. We don't send our wiring instructions attached to our settlement agreements. We try not to. It's something we're kind of trying to change. Because if you have unsecured drafts of a settlement agreement going to opposing counsel forwards them to their client, we send them to our client, you have 5, 6, 7 email accounts that if they were compromised, you would have a draft of that settlement agreement, and Exhibit A to that settlement agreement would be our standard wiring instructions. Using a simple PDF tool, they could take our form wiring instructions and replace those wire numbers. It would look like ours. It would have our letterhead. The document title would be right. There's all sorts of that. So instead, something that you can do is put in the settlement agreement. We will securely send you a copy of this via secure mail once the settlement agreement is executed, right? At that point, you don't have 7 drafts of 7 emails going around to 7 different people, because in this space, you're only as safe as the least safe email address that is receiving your correspondence. If you have an email that's being sent to 6 different people and 5 of them have phenomenal cybersecurity and 1 of them is a unsecured Gmail account, the entire thread is just as vulnerable as that 1 Gmail account, right? So yeah, you're absolutely right. People think about the wiring instructions, but they forget about other aspects of form documents, other aspects of what type of information would a cyber criminal need to know in order to trick a home buyer into wiring their funds to a separate place. And we've covered through most of this in that. This is an interesting graph that we've used to kind of describe how this landscape is changing. You can see here, this is basically like the percentage and prevalence of what is being used to lead up to a cyber threat, right? The bottom miscellaneous errors, you can chalk that up to somebody leaving their phone in an Uber or a laptop in the airport, on an airplane or something like that, an unsecured office where someone can physically get into a system. The other 2 is social engineering and system intrusion. And you can see that they kind of ebb and flow as what's the most prevalent tactic that's used to try to infiltrate somebody's computer system. And it's important because those are the threats that people are generally facing. From 2018 to mid-2020, social engineering was a big part of that. And social engineering is generally just the cyber criminal manipulating people into giving them sensitive information like passwords and financial details through deceptive tactics, phishing emails, things like that. So calling and pretending to be a client that needs particular information, and a receptionist hands over some type of private information regarding the firm that's then used to get into a system. The system intrusion is a little bit more of what you would consider like a hacking event, right? It involves directly getting into a computer system with maybe an email attachment, has some malware, something like that. And you'll notice that system intrusion was much more popular in 2022, but social engineering is on the way back up in 2023 and 24. A big part of that is, and we won't get into it too much because I'm sure everybody's sick and tired of CLEs talking about generative AI. But generative AI, ChatGPT, Gronk, all these systems, they can generate emails and they can generate responses to emails that are pretty good. For example, the definition of social engineering I just read out about manipulating, I didn't write that. ChatGPT wrote that. They can read an email thread, and if you have Outlook, Microsoft has a new system that allows you to read an email thread and propose a response. And it's going to be typed well, it's going to have proper grammar, it's going to have a good explanatory phrase, a lot of things that threat actors struggled with previously. So the red flags in emails of bad grammar and those things, that's a 2019 problem. you're going to need to be able to read an email that is perfectly worded and say, the context of this doesn't make sense. I need to pick up the phone and call someone. To talk briefly on phishing, people kind of throw that term around a lot. But phishing is really important to kind of understand because it's probably the most common first step. And it's one of the things that a law firm can do and implement trainings to try to prevent an incident from ever happening. In phishing, a phishing attempt, which is, on the rise, it's currently the most common thing that leads to a business email compromise. It's an introductory email that will include some type of a link or ask for some information where the person's lying about who they are, right? And these can be really complicated or they can be really simple. They can be specific to your firm or they can be blast out to hundreds of thousands of email addresses. But the big thing about phishing is it's trainable. A lot of companies or cyber insurance will ask your companies to train employees about how to spot a phishing email. Our firm sends them out, and sometimes attorneys and partners, and less often associates, but sometimes associates get tricked by these phishing emails.
You mean I can't hit that link?
Yeah, exactly. That's one of the reasons why it's such a big topic it's talked about is because it's somewhat preventable. And two areas where phishing is getting more complicated nowadays, because we're getting better at detecting the phishing emails that ask you to go, we have clients coming in. This is the most common one that I know of. We have clients coming into the office today. Can you stop by store on the way to work and get gift cards? And then when you can't get there in time, read me the numbers on the back of the gift cards, right? Because I want to get these loaded up into our system for a client giveaway. If anybody's ever asking you via email to pick up gift cards, don't do it. Call them in person. But we're getting better at seeing those. So the two kind of second level strategies, one is called vishing, which is a terrible name, and I don't know who came up with it, but it's voice phishing. There's a lot of technology out there that will allow, if you have recordings, will allow you to kind of mimic someone's voice for a period of time, which I guess I hope this isn't being recorded for that sense. But so they're called deep fakes, where people are able to basically make a short conversation so someone feels more comfortable to go get those gift cards. That is coming up, but the more common one is called spear phishing, another phishing analogy, where it's not a broad-based, throw your hook in the water and see what bites. It's targeted towards a particular individual where they'll go through social media accounts, online profiles, LinkedIn accounts. They'll look at your firm bio and they'll try to develop a particular type of request that you would respond to based on something on your bio. I got one not long ago that was asking if I wanted to be involved on a board position for this nonprofit that had somewhat tangential to my thing, and they wanted me to click on a PDF, fill out my information, and return it. I didn't click on the PDF, but if I had or scanned it, it very well would have had some type of malware that could have infected my computer. So they looked on my bio, found out the areas where I have some professional experience, looked at me saying, that's definitely an ego-driven attorney. He wants to be on a board seat somewhere because he wants to tell Halsey so that it can be read out at his next CLE event. So
I'm surprised they didn't talk about the Georgia Bulldogs.
Yeah, exactly. We've got Georgia Bulldog tickets. I would have fallen victim to that trap. So those are the types of things, the strategies that are being implemented now, as opposed to the, let's send this email to 10,000 people and see if anyone responds. And briefly on ransomware, to the extent that a firm gets into a ransom attack, generally that's someone getting into the systems and either encrypting all of that data or stealing a copy and threatening to release it somewhere on the dark web. That's a really sophisticated level attack that almost always requires some high-level technical experience to find out where the intrusion was and to shut it down. In an instance of a ransomware attack, what I would say is the prevailing wisdom is just, if you have cyber insurance, contact your cyber insurance because they'll help you with this. But if you don't, get a professional involved on the technical side as soon as humanly possible. A lot of people think that, oh, the ransom's expensive, I don't want to add the costs of a cyber professional on top of that. But most of the time, that cyber professional is going to be worth their weight in gold, because what the hacker is saying they have might not be what they have, and you might be able to get into your system a little bit easier. But it's a more complicated attack that we could talk about for a couple hours. One hit on the ransomware, that was the Colonial Pipeline attack a few years ago. Everybody remembers the natural gas. That was actually manipulated through a billing issue. It's not like they hacked into the side of a natural gas pipeline or anything crazy. They had old antiquated billing software, and that's what kind of was used to shut down their system for a period of time. Your firm might have a lot of different areas to like protect from this, sending protected or encrypted files.
What is that thing in red there?
Yeah.
In green.
In Outlook, this is actually a screenshot of, I think, my or one of my partners' email Outlook systems. To the extent you aren't sure how to send secure emails, I would get with somebody from your firm, from IT, or talk to whoever kind of provides and helps manage your systems about sending secure emails. It makes it much more difficult for someone who has the ability to get into a part of an email communication to get the entire, to get attachments and things like that. And there are a lot of different ways to help kind of protect yourself from that type of a threat. There's secure sended emails. There's programs like Mimecast where you can send secure messages. We all have document management systems nowadays. A lot of firms do. And if you look through your document management system, there's probably a way to send a secure link, which allows the sender to click, download their own copy after putting in some credentials. So if someone just got a copy of the link and clicked and they didn't have the credentials, they wouldn't be able to access it. And if they were able to access it, you would get a record of someone with probably a spoofed Gmail account accessing your documents.
So Jake, do we need to learn how to use all these things
Yeah.
all the time?
Not all the time. I would say that the goal should just be for your firm to create and develop a strategy moving forward on how you send and what you send securely, and try to be consistent across the board, whether it's a secure link from your document management system or through your email, sending secure emails through Barracuda. There's a lot of systems for it, but the goal should just be to develop a system, develop what should and shouldn't be sent securely, and implement that as consistently as possible.
Okay.
And I know, Halsey, before we run out of time, you've got a couple examples that you wanted to run through.
Yeah. Unfortunately, we've experienced a few things that I want to share with you. This one is fairly common, and this is a relatively recent one where client retains a firm and then asks you to deposit a check, represent them in usually a real estate transaction. And then they ask you to forward to them some share of the proceeds. And of course, then the check turns out to be fake. Let's go to the next slide. You'll notice the name on here is my name. This is one of the ones I got on, what was the date here? May 17th, 2024. In fact, they sent me a check for what, $250,000 or something to that effect. And so what did I do? I immediately went to the head of our commercial real estate department and said, this is bizarre. Why would someone be sending me a check for $250,000 to represent them in a construction company in a matter I've never heard from them before? And so we did not cash the check, but I did send an email and say, who are you and what do you expect us to do? And I still hold that check today, you know, and the scheme was that they wanted us to deposit that check and they were then going to pull the money out and then we were going to be stuck. So you got to watch out for these things. And if anything seems odd, it is. You can't ignore it. You have to take some action to try to protect yourself.
And
Jake?
one thing on the taking action, a lot of times fraudsters will be smart and they'll modify phone numbers or email addresses to respond. So if you ever have an email that you think is not legitimate and you actually have contact with someone at that company, don't call the number in the signature block that is fake. You'd be surprised at how many people respond to the fake email and ask for information to determine if it's fake. And the hackers never say, "You got us, it was fake. Props to you, forward this along to your IT team." No. So the only real way to do it is to outside contact whoever it is you have at that company, and determine it. And we've gotten calls from other people thinking something was coming from our firm and it seemed weird, and we were able to either say it was or it wasn't. I think a lot of people don't want to waste other people's time, and so they don't make that phone call. Make that phone call. It takes 2 minutes to make a phone call, and according to earlier, what was it? It takes 74 days to fix a cyber incident. So it's worth the front end time.
And if you got a chance to read this letter closely, it is so generalized. It doesn't say a location, a transaction amount. It lacks all the essential details that we know are necessary to be able to specify a transaction. And that should jump out at you that, oh, this is a problem and we need to protect ourselves. It can happen in another form. This is another one. I don't know why I'm the target of all these malicious attacks, but they should just seem to keep coming. This is a malicious attack. It looks like it's coming from the U.S. District Court for the Southern District of Georgia, advising me that the ECM system is not operating and that you need to implement a workaround if you've got to get to a docket in the Southern District. And you see right there's that link right there, HTTPS www. And they were trying to get you to come and click on that link, which was supposed to guide you to an example of a malicious email that you would therefore then avoid. Well, you didn't need to do it because it's right there in front of you right now. Let's go to the next slide. It wasn't just the Southern District. I got one from the Northern District too. You see it right next door to it. Having trouble viewing this email, view it as a web page. Right there's that link. Anything that's in blue, avoid. It's easy. Just don't do it. Those are some of the kind of things that people are using to try to inflict some type of malware on your system. There are suits going on over. This is a law firm in Florida that had the unfortunate circumstance of simply allowing information that it had on its clients and employees, social security numbers, birthdays, addresses, the kind of stuff that's really valuable to people who are trying to defraud other people. And the firm did not adequately protect its that information that it had in its files. And it was a fairly large pool of money that they had to pay to try to reimburse these folks. Got another one here. This one's in Georgia in front of Judge Brown. Again, this was a data breach that went on for only 13 days in this summer. And again, this was not one where money was being pulled, but that information, the kind of information that y'all have because you need it for your closings with your clients, was not adequately protected. And then your client or client to be sues you because that information was used against them. So you need to take away from this the notion that you need to meet with your technology consultants and be sure that if there are parts of the information your clients share with you regularly, that you protect it and enhance your protections to stop these kind of actions because they're coming more rapidly and in larger amounts. Do we have another one? Oh, that's it.
Well, because everything comes back to litigation, we'll kind of close with the context of what happens afterward, right? You've had some type of a cyber incident between yourself, an agent, a client, title insurance, someone in a transaction, or often law firms have a lot of vendors, right? Completely separate from the actual work that you provide. You have a vendor that, you're paying an invoice or they're paying an invoice to you, and that payment is stolen by a cyber criminal. And the question of what happens after. Cyber insurance is a big part of it. I think 55% of companies now have some form of cyber insurance. It's really complicated, but cyber insurance generally does not solve a lot of the problems that the insured thinks that it will, because there are a lot of exclusions in cyber insurance. There's a lot of notice period stuff. So that generally doesn't end our cases. You end up in a dispute with the party who either caused the breach, who clicked on the link, or the party who sent the wire without checking. And the way those cases have mostly ironed out is it's not a clear rule of if you're the party who was hacked, you clicked on the link, you're the reason the emails traffic got infiltrated, you're liable for the loss amount. And it's not clear that if you're the party who accidentally sent the money to the wrong place without calling and double checking the wiring instructions, you're the one who's liable. It becomes a kind of general question of negligence. What type of protections did each side have? Who had the last chance to avoid it? Those types of general tort questions we see in tons of other cases. And that means that if you get in a lawsuit, the big question is, what are all the things you're doing right? What are all the things you did wrong? And you don't want to be the party in that lawsuit that wasn't really taking any precautions and made some type of a mistake, either sending the wire or having emails infiltrated. So that's kind of where we've seen it going. And that's where most all of the cases have ended out, and where clients have been kind of in the end.
Let me offer one other tale with an example our firm had several years ago where an email went out with the wiring instructions. And of course, those wiring instructions were altered. And the firm actually made the payment. It was millions of dollars, but it was discovered within 2 hours. Because it was discovered within 2 hours, we were able to receive 1/3 of the money back within a week. And 6 months later, we got the rest of the money back. What's the lesson of that? The lesson of that is if you have to deal with wire transfers, you have to stay on it. If you're expecting it to show up at 3 o'clock and it becomes 3:45, you can't go home that night. You've got to train your people to go and immediately check things out. Because if you do, you've got an opportunity to recover that money. But if it goes 24 hours or 48 hours, you're not going to recover it.
I think there's a stat, it's off the top of my head, so it could be slightly wrong, that something like frauds that are reported within 48 hours have a recovery rate in the 70s. It's really high. And surprisingly, it's the United States Secret Service who actually does this. Weird trivia fact, it dates back to like what the Secret Service did Confederate times, but they still kind of are the handholders with tracking currency is the Secret Service. So there's kind of a triage level of who you report to, the Secret Service, the FBI, when this happens. And they're good, but you have to have it on time, because the way these criminals work is they shoot these wires through what are called mule accounts all around the country. They'll split up the amounts to 2 accounts, and then they come back together in another account, and it becomes untraceable pretty quickly. And then once it gets outside the United States, it's kind of a lost cause.
Questions, comments?
Yeah, I think we have a couple minutes for a question if anybody does have one.
We stunned them into silence, Jake. Oh, we got going all the way back in the left.
I think the question was, are there any signs that someone has infiltrated and are waiting? Is that it? No, I mean, there are types of like scans and things. I think the signs would be if anybody reports to you about a communication that isn't you, or they got a call or something like that. That actually does happen. A lot of times you'll get in and they'll be like, oh, well, we've got this. We had this incident. Oh yeah, that makes me think. A week ago, I got an email from a client asking if we had moved up in your case, if we had moved up the closing and to send, something. I assumed it was like just like a, phishing email and didn't report it. The big thing is a lot of times you need to report those types of things to your IT. If you have a Microsoft 360 sometimes helps. You can report phishing emails to your IT department. That will probably be the best case to try to figure out if you have an intrusion.
But I would assume most of you use paralegals. You want to alert your paralegals that if they get that kind of message that, oh, one of your clients called up and said, oh, I thought we moved the closing date. That's a red flag that immediately needs to get attention. It's not something they should put off or, oh, I'm not worried about that because we know when the real closing is, so there's nothing to be concerned of. You need to treat that as evidence that you're under a frontal attack at that moment. And if you approach it that way, and I hate to be defensive, but we have to be somewhat defensive, you have to alert your staff to be on the lookout for these things. And if you do, your chances of being unscathed improve dramatically.
Yeah, I think that just naturally we think about physical security of all of our property, of our cars, of our law firms' offices, of our houses all the time. And you'll do pretty well if you think about your electronic security with the same level of vigilance that you think about your physical security. You lock your door at night, you turn your alarm system on, you have a badge in and out system at your office so people can't just walk in off the street. You know, if you're as concerned electronically as you are with physical security, you're probably going to be a lot harder mark than the business 2 doors down. And in this place, the goal isn't to be perfect. The goal is to be a really hard mark so that they go somewhere else. Right.
Mm-hmm. Yep. Mm-hmm.
Auto forwarded. Yeah. Yeah, and often they'll read it and delete it. So it's out of the inbox. So if you look back, so you did the right thing. Yeah, no, I mean, that's exactly right.
But you did the right thing too. Get on the phone. I mean, I'm sure that's all your regular practices. You do not send a wire without having a direct contact. I write that into my settlement agreements and all my cases now. Good. Correct.
That's absolutely right. And
Yeah, you just have to do it. Have to do it.
yeah. And one of the points you said about the email, most of the time you can tell if an email is fraudulent by very closely reviewing the email. I have looked at these a bunch of times. Sometimes it is really hard to tell when one letter is different. I'll tell you though, more than 50% of cyber fraud incidents involve a Gmail account. So I don't want to say that all of them are going to be, easy to tell, but the majority of them, it is relatively easy because the hackers don't want to pay for, shockingly, don't want to pay for email hosting. So they use Yahoo and Gmail.
To share your knowledge is helpful.
Yeah. Out of state.
Watch out for Bank of America.
Mm-hmm.
Mm-hmm.
And yeah. And most of the time it's to an out-of-state bank. I think that there's some GAR forms that actually like address out-of-state banks because the majority of times they'll ask you to send, and that's something that
Branch. Right.
yeah, it makes it harder to track, right? And that's something that a customer needs to know, whether it's through your warning system, whether it's you letting them know personally, your customer or whoever's the wiring person needs to know that our bank is here. We bank in our state. You know, some people have offices all over the place, so it's a little bit more difficult, but that's another red flag. If you're ever finding yourself wiring an out-of-state bank from where your vendor or customer is, definite red flag.
All in the back. Can you speak a little louder, please?
I'll relay. Yeah.
Mhm.
Yeah. Yeah, that's right. And for anybody who had trouble hearing, the point was that most of the time, you know, lenders, they're using consistent wiring instructions, especially routing numbers, right? Consistent wiring instructions. So if you see something that is different, that's a red flag. Another point fraudsters commonly will use, they'll say, oh, you know, I've always kind of laughed about this. They'll say, for a customer or a client, we've suffered a cyber attack. So we had to change our banking information,
Mhm.
and here's our new wiring instructions. And generally speaking, anytime wiring instructions change, best practice is to confirm it over the phone. Just that way you can knock it out. You don't need to use your best judgment. You don't need to check your gut. Just a rule to yourself. If you have wiring instructions change from someone, and that happens to be someone you're going to be paying anytime soon, double check them. It's an easy checklist item to move forward with.
I know you don't want to hear this, but use checks. Use checks. The UCC makes one bank or the other have to pay if the money disappears. The problem with cyber fraud is it disappears in the digital system. The law has no way of recapturing because you never knew who the party is. If you use a check, you at least know who's going to be the defendant in the lawsuit. You got a chance to make yourself whole. Think about it.
We'll do check washing as a thing
Next year,
CLE,
we'll talk about check
after you
washing.
guys suffer check washing issues for the next year because of that. No, yeah, the big thing is though, there's not a way. We live in a place where we're sending tens of thousands, hundreds of thousands, millions of dollars through the air at a breakneck pace, right? The cost of that is we have to be, for that convenience, we have to be incredibly careful and we take on a lot of risk. So there's not an easy way to just fix all this.
And be a curmudgeon. Stop sharing information free on the internet. Just don't do it. The convenience of it lulled us into providing millions of bits of data to companies that have now aggregated it and use it against us. Think about that. If you have an option between doing something digitally or doing something live or in a letter, go live or a letter. Stop thinking that convenience is the only question you have to ask when you decide to use a digital system. And I know I sound like a curmudgeon, but like my wife gets on me all the time. Don't you know what we've been spending money on today? I will not access our bank account on the internet. I've been involved in election litigation, and I know all about efforts to attack election systems all over this country. After doing that, I will not do a transaction from a bank on the internet. Now, that makes me ancient, I know. I understand, but you really need to think seriously and deeply about these issues because they're real.
Yes. Y- Well, the first one would be Secret Service, and that IC3 is the FBI. They're the best. There are a lot of places you can go after that, but filing an IC3 report and going to the Secret Service are kind of the one and two. The catching cyber criminals, it's a jurisdiction problem. Not all, a little bit over 50% of them are like fully determined to be outside the United States, and most of which in countries like Russia that we just really have no hope. They're getting better at tracing funds, and that's really the only way we're going to catch them. So it's going to take time. But the other thing is you have to think, we've really only been even investigating and trying to prosecute these types of cases for a really limited period of time. And the criminals are always going to have an advantage in like new and emerging areas. So I think as we get better on the chasing the money in the financial side and requiring banks to do things like have 10-day waiting periods for new accounts, governments have started to really take notice about these. There's thoughts about making ransomware payments illegal, which would drastically change the landscape. So, I think in time we'll get better at that, but we're not good at it now. I think we're up on our time, and I know you guys are already kind of running late. Yeah, go ahead.
No, no. My kids think I'm a dinosaur.
I Venmoed someone this morning.
Get out of here.
So like,
Never.
there are multiple
Don't
ways to do this.
it.
Yeah.
Yeah, certified ID.
Yeah, it's
Have you read the policy as to what it covers and doesn't cover? Are there limits? I mean, you need to take it to the next step.
and also that's specific for wiring instructions. So if you had anything that happened pre-wire, post-wire, a lot of times people can think, oh, we have this system, so all good. You got to still be prepared. But yeah, it's great for that service though, for sure.
Next year, we'll be back with happy news. How's that?
Thanks.
Hey, good afternoon, good morning. It's tough to follow that last presentation. That's a lot of good information. A lot of the seller fraud is really important. I teach it as well and stay on top of it. There is no surefire way, but I'm here to talk to you about something really interesting, legal ethics. All right, I was hoping to catch you after lunch so you could nap out afterwards, but here we go. I'm CJ Spraggins. I'm an attorney here in the state of Georgia. I'm from Beaufort originally. I practice both in New York and Georgia. Here it's strictly real estate, residential, commercial closings, title curative work, everything across the board. And yeah, I enjoy it a lot. So what I like to do really is in talking about legal ethics, hopefully this is going to be a conversation back and forth. We can share some insight on experiences we've had. Certainly I'll go over some of the stuff that I've had. But, let's take a look at it. We've got an outline. Let me see how the clicker works. That's not it. That's it. So program outline. We're going to talk about attorney fees and engagement agreements. We're going to look at preventing fiduciary liability, really just like limiting who you represent and what you're doing, candor negotiations, conflicts of interest, joint representation, and individual versus business client. Now, I'm just curious, I wasn't here for the morning session. How many people will handle residential closings? All right, cool. Commercial closings, a bit of a different bag. Other stuff related to real estate, right? Contracts, right? So some of the stuff leads off. So this is where it's the nuances, everything's really gonna come in comparing the practices amongst themselves. Because if you've done residential closings, the rules are pretty set forward. Commercial closings, less rules, more attorneys, less paperwork, a little more clear. Then it starts blending into other things. It becomes a little unclear. So if I speak too quickly or you have a question, stop me, throw something at me, right? Let's get it ironed out. Again, I want to have a conversation. So if you have anything to share, just please, just blurt it out. All right. So let's see. So what we're looking at is the preamble to the Georgia Rules of Professional Conduct. And I've itemized everything out there. And on the side, I've kind of given you, my impression of what it means. So we're looking at, you represent clients, you're an officer of the court, you're a citizen of justice. Awesome. You're an advisor, an advocate, and an evaluator. And I like to think of this, I put all the side, informed consent, right? Because we're agents at the end of the day. We don't have any authority to do anything our clients don't allow us to do, right? So we can't make a decision ever without getting our clients informed consent. Negotiator and an intermediary. Honesty and integrity. I mean, that's seems obvious, but you have to think about that really when you're getting into the commercial closings, when you're getting into negotiating contracts, who you represent, business versus the individuals that part of the business. It can get a little murky too with seller finance transactions in residential real estate. Competence, confidence, communication. I think best interest of the client. Again, we're agents. We don't operate outside of the client. We put our best foot forward. Sometimes that's better than the clients, and that's what they want. This is more for those of you who, I guess, litigate. I do a little bit here. You have a duty to challenge an official action or to uphold the legal process, right? You've ever done crim law or you have friends that do crim law, what do they say when they defend it? Well, I'm defending the process. Well, that's what you do, right? You know the process. You challenge it when it's not right. Where can that come into? Tax appeals, real property, tax assessment, things of that nature. Cultivate knowledge and refine skill. I think this is pretty relevant to what the last speaker was talking about. We're talking about wire fraud to some degree, right? You have a duty to keep abreast of all the technology, all the advances, all the ways people are using the law, the rules, and the technology to take advantage of others, right? That's a duty to stay informed. Foster the public interest. Do the right thing. Every lawyer is responsible for observance of the Georgia Rules of Professional Conduct, right? So let's get into the attorney's fees and engagement agreements. All right. So I ask about residential closings, commercial closings. How many people in here who conduct residential real estate closings have their clients sign an engagement agreement? How about for the commercial? Right. For the other stuff, is there a bar? I mean, does everybody here, do you wait for a monetary limit before you put something in writing, an agreement? Or do you always do it? I'm just curious. I have a money limit. It's 3,000, right? If something's below 3,000, I don't make them sign an official letter of engagement, right? It's smaller. I'm just curious. The engagements, the scope of representation, and allocation of authority between the client and the lawyer, right? It's always important to itemize what you're doing. But over the course of my career, I litigate in New York. What I found the most important thing is to itemize what you're not doing. Right? It's fine. It's easy to tell people what you're doing, but we have specialized knowledge that the clients don't. Not all of them. Some do. Right? You have to let them know. So if you're handling a case, for example, the client engages you, does that include the appeals if you need to make appeals? Right? Most clients would probably agree, yeah, that includes appeals. Most lawyers would say, no, it doesn't, right? But it's really important, not only itemize what you're going to do, what the client's going to do, what you're not going to do, right? So a lawyer shall abide by the client's decisions concerning the scope and objectives of the representation, right? They tell you what they want to do, you tell them what you can do. Tell them what they can't do. Consult with the client as a means of pursuing the objectives, right? Think strategy versus tactics. Abide by the client's decision regarding settlement. This is informed consent. Again, if you get a settlement offer, you're obligated to actually show it to your client. You can only settle on your client's consent. In a criminal matter, abide by the client's decision after consultation as to a plea, jury waiver, or testifying. That's just a part of the rule, so I'm throwing it in there. Right? Not everything's applicable to what we do, but it could be. Okay. I've got to sketch out what you shall do, what you may do, what you cannot do. So under this rule, a lawyer may take such action on behalf of the client as is implied, right? File the paper, take the phone call, respond to an email. The lawyer may limit the scope and objectives of the representation as reasonable, and if the client gives informed consent. Now, I don't know how it works down in Georgia. I don't litigate here often. New York, clients would piecemeal litigation, right? An attempt to limit fees, to encourage settlement. I'm not really sure why, but as long as it was limited to making an appearance, filing a motion, everybody was okay. Discuss the legal consequences of any proposed course of conduct. And then counsel will assist the client to make a good faith effort to determine the validity, scope, meaning, or application of law, right? Nobody does perfect work. We're not the exception, right? So as long as you explain everything out as best you can, that's all you can do. The client has to know and they have to be informed. Okay, no matter how sophisticated you may think the client is, no matter how much you think the client may know, you have to do it. Tell them what you're going to tell them, and tell them what you just said. Now, a lawyer shall not counsel a client to knowingly engage in criminal or fraudulent conduct or assist a client in criminal or fraudulent conduct. Maximum penalty for this violation is disbarment. I'm sure none of you do that, right? But it does happen. Just keep that in mind, right? And this is really CYA for everybody. Something goes down, nobody's got your back. All the fingers are going to point at you. So CYA. So I've just kind of summed it up. What does it mean? Communicate with everyone, right? Your client, potential client, your current client. Informed consent and get it in writing. Email's fine, right? If you want to string together some text, I guess that's okay. Makes it more difficult. There's a problem and more costly down the line. But CYA, put it in writing, right? However you can. If you're conducting a business only online, you can do that in the state of Georgia with everybody's consent. Actually doing it is consent. So get in an email, that's fine. And if you can only get in a text message, why not? Make it clear. Again, for the engagements, the scope and limitation must be reasonable. And when you're working with your clients, analyze, do not recommend criminal or fraudulent activity. If you see it, actually tell them not to do it. That's CYA. And if you have to do that, because I've had to do it many times, call your secretary or somebody else into the room so you have a witness. Because I assure you, when you give that information out, they're not going to sign a disclaimer saying they understand. Do not draft or deliver documents that are known to be fraudulent. Don't suggest how to hide or conceal the truth. And don't continue assisting your clients if you discover they're engaged in criminal activity. I don't know how often that's going to happen in real estate closings, maybe more so in commercial. I can think of at least one example in a residential closing where everybody goes through and says, hey, you're explaining to the borrower everything in your loan application was true and accurate, right? What happens if they say no? Oh, listen, I had a guy, I stopped asking the question and I started making the statement because I asked a guy one day in a closing, is everything on your application true and accurate? And he stopped and started thinking about it. No. Well, I make the statement, have them sign it, but this is an example where they say no, but not everything is truthful. You got to stop it, right? They're not your client. Obviously, if you do residential closings, the lender is your client. But you can't deliver those documents to your client. You can't allow that party to do it. Truthfulness in statements to others, right? Well, again, we're just going to rehash this. It's not rocket science. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless prohibited. Anybody could think of an example? Let's say in a residential real estate closing, Let's imagine the situation because it never happens. There are no agents on the contract. I heard a sigh of relief. Right? Yeah, no, I know. No attorneys, that'd be great too. All right, so imagine this. You're, and let's say it's in all cash. You represent the buyer. Right? What do you say to the seller about disclosures? No agents on the job, right? Represent the all cash buyer. It's your job to get those disclosures. You have to ask for them. What if you represent the seller in that case? What do you tell them? Say you know about water flooding and they don't want to put it on the seller disclosure, right? Because that never happens either. Right? It's just a situation in what we do where you're going to be faced with these questions. And what do you do? Yes, ma'am. Yeah. Well, yeah, and that has to be on the HUD or the settlement statement. It's presumed fraudulent if it's not. Yeah. Yeah. Well, no, I mean, that even comes up with a similar situation where, you have an ABBC, whatever, and one of the parties, there's an undisclosed, unrecorded security deed because they kept it off the original HUD, right? Well, if you look at the law, I've had this situation. I mean, the law presumes fraud on the face of that document because it's not listed on the HUD, right? Yeah, I see that. So you just have to, these are situations that are going to come up, right? Everybody's going to try to, I guess more so with the investors, you might see that. I'm not naming any names, but all right, about fees, awesome. A lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount of an expense. I don't think, I think we all agree in here that we probably don't even earn a reasonable fee for what we do, right? A lot of work, we work hard, but does everybody disclose their fees? Yeah, at which point? Put it on your website, give it out to your clients, email, stuff like that. They usually don't complain about the fees. But yeah, post your fees. Really, when it comes to fees, I mean, if it's ever challenged, there's a lodestar method to challenge it in court. That's a long, boring method that analyzes everything that's not important. I think the important thing to remember is just have everybody agree to it, whatever the fees are, right? If you're doing title curative work for sellers and you're going to charge a fee for that, let them know, right? CYA, get an email. It's okay to go forward. Probably even in the GAR form contract that they pay for it anyway, but CYA for that. And yeah, for your own fees, however you disclose them, just disclose them, right? Have everybody, they want to challenge, they want to talk, negotiate, fine, no problem, but they're disclosed. Right? And this is it. This is the long itemized way a court of law is gonna treat any kind of fee contest. I don't imagine any of us will ever be there for the closings. Okay. Because as long as people leave the closing table, they're usually happy, usually. Right? But they're going to look at all this. So at the end of the day, I think it comes down to what we do is what's customary in the field is going to be reasonable. That makes sense, right? Because everybody's about in the same place, at least from what I've seen. We're just looking at, I like to look at, I like to talk a little bit about the rules that are in effect. I like to look at the formal opinions. There is some case law as well that I like to look at. So we can kind of get a broader idea of not only what the rules are, but how they've been applied, right? How they're interpreted. And I can tell you this, narrowly, always restrictive on what we do. So this is a formal advisory opinion from 2001. It's really talking about billable hours. Again, I don't know how many people engage in that practice or if you send out bills, but this is really more about billable hours. You can charge for standard units of time so long as it does not result in a fee that's unreasonable, right? And at the foundation of that, what's your hourly fee? But certainly it's not unreasonable to take that hourly fee and divide it by every 6 minutes, if that's how you bill. And just the opinion, to ensure a clear understanding between the attorney and the client, always provide the client with an explanation in writing of the basis of the fee, right? If you're sending out bills, because that's what you do, itemize it, right? Look at it too. Seriously, look at it. Does it look reasonable to you, right? 5 hours for an email, probably not, right? Look at it before you send it out and you'll know if somebody's going to challenge it. It just makes sense. Not everybody's like that. Everybody challenges things, but just take a look at it before you send it out. Yeah. So this is from 1991, a little bit further back. Lawyer's duties as to fees are as follows. This is from the formal advisory opinion. To have a clear understanding, the client needs to know the details, verbally in writing. You have to return to the client any money you've taken that's unearned. Okay. If the client fires you, you cannot condition the return of their file on payment of your fee. Really a penalty, right? And I'd say this, what I think there's a case that I've cited in here regarding closings is really the first litigation that came out in the state about returning fees was a closing where some of the pennies weren't spent in the account and the lawyer wasn't returning them. I thought it was a kind of a strange case because it was ultimately like $100 that caused the downfall of this attorney. I would have given it back. Yeah, it was recording fees that weren't used and it was just an accumulation of them. It wasn't much, but over time it was enough. And one person complained about it and the lawyer refused to return it. $20 maybe. And that was the end of that, right? So just if you have unearned fees in your account, give them back. Where does that come up? I guess not necessarily unearned fees. What about tax time? I mean, people, you send out the tax payments, right? There's a race to cash the check. There's a lender's check, get cash first before yours, right? Money comes back. Who's it belong to? Send it out. Same thing. All right. We're talking about engagement letters. This is kind of just the scope of mine. When I have to do an engagement letter, it's 2 pages. I don't want to read a contract more than 2 pages. I don't want to make somebody else read one. Really, it needs to be simple, right? When it's complex and there are issues and then other lawyers get called in and we're lawyers. We don't like working with lawyers, right? All right. This is kind of what I've got here for the engagements. This is an outline of my own engagement letter. Identify the parties. And this is real particular too, because I've had this come up a lot is, business versus the shareholder or the manager or the member who's retaining you. It's always very important for me to explain to them up front, hey, I don't represent you. It causes problems always, but you have to have it. So a recital of consideration, because that's what's required to bind a contract in the state of Georgia. Identify the matter and the information provided by the client. This is huge for me. I started doing this in New York. The client has given me any information over the phone that I deem as relevant, which is a lot of it. I put it back into my engagement letters and I say, hey, this is what you've told me. Based on this is what we're going to do, right? Why? They sign it. They can't ever go back and say, I didn't say that, because it happens a lot, right? What we're talking about is covering our own A's, right? That's it. Define and limit the scope of work. What are you doing? But most importantly, what are you not doing, right? If you work in this industry, you've broken it down into parts, right? You know what a residential closing looks like. You know what title curative work looks like. It's all different. So what are you not doing? It's really important. How much you're charging? When is it due? If there's any upfront, right? What's the client responsible for? The cost and cooperation. I put that in there because in litigation, clients, they're always fighting with you. And I need to weigh out when that happens. I try not to get out if I can stay in, but you need to weigh out. That's your way out. Cooperation. Agreement to electronic means and e-signatures. That's always in there. It's so much easier, right? And that's what's required in the state of Georgia. Consent and it can be done by performance, but remember, CYA, right? How it terminates and when, always in there. Have your exit strategy, always. I disclose any conflicts of interest if I have any. And just a recital of authority to sign and bind. If you're dealing with the corporation, they're just confirming they have the authority, right? That's it. I sign it, send it off, e-signature. It's easy. We talked about this, just provide your fee sheet at the outset if you're doing litigation. You know what you're worth, you know how long something's gonna take. And if you don't, get a retainer, right? But if you can flat fee it, you can do that, make it reasonable. I find flat fees are pretty easy. Right? And then so I know the big question, what do you do when clients complain? I give them some money back and I get more money the next time I work with them, right? I don't send them on their way and say, I'm not taking that. We're all in a business, right? No, they're willing to pay me some money, but not all of it. And I get more business from them. How can I negotiate on their behalf if I can't do it on my own, right? Yeah, so that's it. Escrow, I love this. Okay, so if you do residential real estate, we all signed the GAR F511, right? Yeah, that's your escrow agreement. How many people have an additional escrow agreement signed by the parties beyond that? Okay. It's fine. There's nothing wrong with the F511. I just like to have my own. And if you're doing commercial, how many people have everybody sign an escrow agreement? Right, because that generally does not come with an F511. And if you're not doing it, do it, right? Because it depends on your role in commercial. Are you a buyer's attorney? Are you a seller's attorney? Are you a settlement agent? This makes a difference, right? All your duties are different. Yeah, so we talked about that. Have the party sign your own escrow agreement. And at the very end, you have them sign a disengagement letter. For the commercial stuff, residential, it ends. And I always have the parties re-sign the escrow agreement in commercial closings at the very end. I have my own escrow agreement signed by the residentials at the very end. All right, now I really like talking about the trust account. I saw in New York, lawyers can do a lot of things and get away with it. If they don't return a penny out of their trust account, they're branded, they're banished, it's over. So I spent a lot of time looking at this. You know, in New York, I do commercial litigation, but I also handle, we'll call it lawyer ethic issues, right? All right, so this is rule 1.15, 1, 2, and 3, the safekeeping of property, right? You notice it doesn't say the safekeeping of client property because your obligations extend beyond clients when it comes to the trust account, right? The lawyer has the duty to safeguard entrusted funds and other property of clients or third parties in an attorney escrow account, right? Now, talk to me about what do you think? Who's this third party that you might accept money from in a residential real estate transaction? First off, let's say it's finance. Who's your client? The lender, right? Is a buyer client? No. Okay. So you got to treat them and their money as if they were once the money's in the escrow account, right? Without exception, you're now obligated to this third party who's not your client to safeguard their money, right? This ties in pretty well with the seller fraud and the wire outs that we were talking that were being discussed earlier. So just keep this in mind. You have a duty now. Once you take that money into your escrow account from the buyer, from anybody else beyond your client, you have a duty to safeguard it. Okay. Maximum penalty for a violation of this rule is disbarment. That's surprising, right? Let's see. So this is a formal advisory opinion, 2014. You receive funds in connection with a real estate closing, you must deposit it and disperse it from the trust account, right? And this maybe just correlates really with your example as well. They wanted 80 to go in outside of closing, 80 to come in through closing. No, you already know about the 80. You can't mix it up like that. And it should always come through your account. Right? And this is just another formal advisory opinion that just sums up what I just said, is that any money you get from your transaction has to be kept in the escrow account. Every money pushed out of your transaction has to come out of the escrow account. Those records. And how many, I'm just curious, how many audit at least once a month or reconcile? Ooh, there we go. I mean, do it once a year. I mean, everybody that said one, you don't have to re-raise your hand, but is anybody who doesn't do it at least once a month? Yeah, no, but reconciling the escrow account. Yeah, anybody do it who doesn't do it a month? It's okay. Anyway, do it once a month, right? Eye on the escrow account. Okay, so authority to disperse. So again, we're dealing with escrow accounts. We're dealing with our obligations, right? I have everybody at the end of the transaction sign something that says I have the authority to disperse the funds in accordance with the settlement statement. Again, this is CYA. You don't have to do it, but if something goes wrong and they come back and say there's a mistake, well, I've got this. They've looked over the settlement statement. It works, right? And disperse it as it's spelled out on the settlement statement. I guess here's an example. Maybe you've closed something where there was an executor or an estate involved, right? Has anybody ever had that executor say, hey, can you just wire it to my account? Exactly. Right? No, of course. Oh, my favorite is I don't have a bank account. Okay. No, figure it out. No, but so I mean, all right. So I have people to tell me how to disperse it, and it's got to be in accordance with the settlement statement. And again, that's a CYA for us, not for them. Okay. And in return, what is not earned, this is the one, pennies on the dollar. And this case is out there. 15 minutes of fame. Any amounts collected during a residential real estate closing in excess must be refunded to the client who paid them. Okay. Okay, yeah. So what happens if, wow. What happens if you've got all these, I don't know, does everybody else have like 3 cent and 2 cent like anomalies like sprinkled throughout every year of your, awesome. What do you do with those? Because I can't get anybody to cash those checks. And I don't charge a wire fee, but the banks all charge more than the amounts going back. So what do you do? Well, so I guess after diligent efforts to return that 3 cents, after so long, you can put it back into the lawyer fund. I don't know that I'm ever going to do that. I'm really hoping people are going to get on board with this, but they're all over the place. And we talked about disengagement letters. If you have an engagement letter, you should have a disengagement letter. It can be as simple as this, right? Thank you. We've worked, always have them countersign it. I sign it. Everybody's happy. It usually happens after everybody's made an agreement on the money that's due or not due. Yeah, and this is just a reaffirmation. You can't condition return to the client files on some kind of payment or penalty. This is, you can't condition it on the execution of a release or general release, which I don't know how many people do that, but I've seen that play out in court. They don't really protect you. Any questions about any of that stuff? It's not rocket science. I hope I'm making it interesting for you. Yeah. I've hand delivered some of these and they've said, I'm going to cash that. What do you do? I mean, I think if you just try, just document it. Like, don't say I made 15 phone calls, show a couple of letters. I mean, you show 4 letters, that's at least what, $1 effort into it plus the paper? I mean, I don't know, because I hope I never have to do it, but if I did, I'd look once a year, I go through everything. I'm like, oh, I still have this. Letter out, email out, call out. I'm telling you, half the people were like, hey, it's good to talk to you. I'm ready to do it. That's exactly, yeah. No, it's rough. I even have a couple, listen, I had one in December. I had like $3,000 in December, and I called her up. I got this. She's like, great. It's the second time I sent it to her. She's like, I'll cash it. It's December, end of the year. Anyway, maybe she's okay. Yeah, so that's it. What's reasonable? Listen, that's the question. That's why we exist as lawyers. Maybe, perhaps, probably. Just do your best. No perfect work. Oh, so this is really interesting. Preventing fiduciary liability. I love this. All right, so I'm gonna use closing attorneys as the example, and let's say residential, all right, because it's easy. We work with a lot of different people, right? Agents, brokers, buyers, sellers, lenders, everyone, right? We collect information from the sellers and the buyers to run title, check, right? We work with the lender to review and clear title. Sometimes we work with a broker, and maybe sometimes there's a 1031 agent, right? Just to spice it up a little bit. That's a lot of people. And let's be frank. We're giving everybody legal advice, right? Anybody here think that's not true? It makes me nervous, right? So who do we represent? It's all cash. Everybody knows the answer, right? Represent the buyer. The finance transaction, we represent the lender. But we still do the same job. Still do everything with the same people, right? Does everybody else get agents calling you, asking you legal advice that then your client reverts back to you and you're like, well, that's not what I really said, right? Of course. So how about this? Let's look at the common law, because we talk a lot, right? I mean, it's residential. We don't really, you've got an engagement letter, right? Sometimes I have one, but not all the time, right? So things can get muddled. The agents certainly know better. The lawyers know better. The clients don't. It's their money. So just look under the common law, the case law. How's a relationship established? It can be expressly through a written contract, CYA. In that outcome, you control it all to the best of your ability. About through performance, right? You're talking, somebody thinks, they see you on that YouTube ad or that video, that reel, and they're like, that's my lawyer. Not yet, right? But look, implicitly is all that's required is a reasonable belief on the part of the would-be client. There's an attorney-client relationship, right? Now, I like the next one from 2006. Client just can't say, well, I thought you were my lawyer. There's got to be something more, right? Showing they relied on it. So how do you get around that in residential real estate closings? Yeah, I love this. Have the seller and buyer sign a disclaimer of representation or acknowledgement of representation. Does everybody do that? Yeah. Hey, you should. Listen, there's really good, there are a lot of good formal opinions in North Carolina about this topic. It's very, very interesting. Have them sign a buyer, a disclaimer of representation. I go beyond that. On my information sheets, it says who I represent and who I don't, right? In my last emails, it says, hey, I don't represent you. And I have them sign it at the very end. And they always ask, well, I thought, I don't know how. So look, Wright versus Cook, Georgia Court of Appeals, 2001, summary judgment in favor of Attorney Cook. It was reversed because there was an issue of fact as to whether he gratuitously represented someone. He did not have a signed disclaimer of representation. They actually noted there was no disclaimer of representation in there, right? But look at the next one. They had a signed disclaimer of representation, so dismissed. You really just have to have your client sign saying, yes, they know I'm an all cash buyer for my attorney, or I know you represent the lender. That's all. And this is really what I put on the bottom. At the very bottom of this is what I put on my information sheets. So it's there if you want it. If you think it needs to be improved, let me know. Commercial transactions, generally all parties are represented by counsel and a commercial real estate agent and or a broker, right? In all cash, the buyer's attorney can also act as a settlement agent. And we hold the money, prepare the documents. I mean, that's what we do in that situation. Whenever I'm acting solely as settlement agent, I mean, in all situations, I have people sign a disclaimer, but when I'm acting as solely as a settlement agent, because that means we're preparing the documents, I have everybody sign a disclaimer stating they understand I'm just a settlement agent, that they're represented by attorney. I have them all state that they have attorneys, right? Any questions so far? Right. Okay, this is long. It's really just about what do you do if you're in-house, right? Who do you represent? We're going to get into the business versus individual, but it's really about not allowing the customers, if you're legal counsel, in-house counsel, not allowing the business clients and customers to believe that you represent them. Right? That's really easy. You just start by saying, I represent the business and not you. It's important to make that clear. All right. So we're looking at candor negotiations. Truthfulness in statements to others. In the course of representing a client, a lawyer should not knowingly make a false statement or disclose a material fact. Right? So a lot of the stuff we do in residential real estate closings, you've kind of got everybody's consent already, right? When you have your information sheets filled out, then buyers and sellers give you consent to move information around. A lender does as well with their closing instructions. Really about at that point, you're really just managing the transaction till it closes. So if you find about something's going criminal or fraudulent, then yeah, you disclose it. So you're required to be truthful when dealing with others on a client's behalf. You cannot misrepresent facts, but you have no duty to inform an opposing party. Right? Can't lie, but you don't have to educate them. Misrepresentation can occur only if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. All right, so I have a really weird, I've had a closing where this came up, and I just want to know if anybody else has had this. I had an agent, it was an all cash, and it was a weird property. It was on two different, cross counties, right? So there's an option when that happens. You can go to one of the counties and say, hey, I want to buy out your interest, right? But it's not guaranteed, right? You make an application like anything else. So to try to push it forward, the agent got me on the phone with the client and said, can definitely get this done. Right. I said, no, it's not a definite, it's an application. This was just a situation where this actually came up. I don't know, has anybody had that situation before where agents have got you on the phone and tried to get you to move something and you know? Okay, yeah, you have. There we go, thank you. Yeah, I know. No, but I mean, the first time it happened, I was like, is this really happening? And yeah, it did. So misrepresentation can also occur by failure to act. And I would actually maybe lump that one in there, right? If you know something's not correct, you have to stand up and you have to say it. And at the end of the day, the client was all cash, so it was my client. Statement of fact. Well, it depends on the circumstances, right? Puffing does not violate the rule. What's puffing? Yeah, right. Fraud violates the rule. What's the difference? What's required for fraud? Intent. Yeah, you have to have intent always, right? So it's important to know the difference. I don't imagine we're seeing a lot of that in residential real estate closings, but if you branch off into other things, definitely. All right. A lawyer who is representing a client in a matter shall not communicate about the subject of the representation with the person who knows that the lawyer knows to be represented by counsel, right? Not so much in residential real estate, but if you handle commercial real estate, there's always an attorney. I've had a few where the parties knew each other, so they would communicate with either one attorney or the other, but freely. And every time that happens, I have to reply with the other attorney on copy. So just make sure you don't do that. It's probably pretty easy to do in the closings. But look, at the end of the day, if everybody walks away happy, there's no problem most of the time. So dealing with unrepresented persons, you can't imply or state that the lawyer's disinterested. Meaning if you represent somebody who has an interest counter to that person, you can't say, hey, I'm just a neutral party, right? Probably easiest to do when you're trying to negotiate a settlement. Just make it clear. And yeah, give advice other than to secure counsel. I've had to do that several times. And if you do that, do it on the phone, follow it up with an email, say, get an attorney, have them call me. And let me think when that happened. I had an all cash closing that turned to seller finance. We represent in that situation. It started out as all cash, and the parties renegotiated to make it seller financed. Huh? Well, that's right, but you already came in working for the buyer. You already know stuff about the buyer that the lender now doesn't. So what happens? Yeah, exactly. That's what I had to do in one. They got really far into it. I learned a lot of stuff about the buyer that the seller didn't need to know. Not bad stuff, but financial stuff is none of their business, right? So yeah, I had to get somebody else involved. I had to tell the guy, and it was a really awkward closing, but I had to say, go get somebody else because I'm about to prepare these documents and I need your counsel to look at them, right? Anyway, in that case, it was secure counsel right away, right? That's where it's tricky sometimes because, I think as long as you CYA, you're okay, right? I mean, we do our best to try to work it out. Again, if people leave the closing table and they're happy, or they leave your office and they're happy, awesome. And a conflict of interest. And I think in looking at all these words and sentences that what this is going to come out to in our practice is the individual versus the business. Who do you represent? That, a lot of us probably work with investors who have incorporated and use those corporations to engage us for our services. Who we represent. Because we know the investors a lot of times are looking for creative ways to resolve real estate problems. So I think this is when it comes up, and I think you should really keep an ear open to it, especially if you're dealing with an investor who has partners. Now you have multiple owners or members of the LLC or the corporation. And who do you represent, right? So always I revert back to when I think there's a problem, I put it in writing. I tell whoever I think has the problem to get a lawyer. The unfortunate thing about that is if you're already representing the corporation, you see how a lot of the investors operate their corporations like they're just alter egos. It can be challenging, but work it out. You get informed consent always. I'm just curious, just by a show of hands, because we're going to get in joint representation soon. Who thinks, what's the best way to put this? How possible is it to jointly represent two parties in a transaction? How feasible is it? That's a better word. Has anybody ever tried to do it and it backfired? Just curious. So, regarding informed consent, client informed consent is not permissible if the representation is prohibited by law. If it includes an assertion of a claim by one client against another client or a former client. Right? And involves circumstances rendering it reasonably unlikely that the lawyer will be able to provide adequate representation to one or more of the affected clients. The violation is disbarment. This is a tricky one. You really have to pay attention to this one too when you're dealing with the corporations and the members working in real estate, because they all have partners. You're going to be on the phone with all of them. In my experience, never at the same time, right? And you have to correct a lot of he said, she said often. It's exhausting. And I think that's when it's really important to let everybody know who it is that you're representing. So it's kind of my summary. I'll read it so you don't have to read it. It's, loyalty to a client and independent judgment are essential elements to the lawyer's relationship with your client. How many people have like a conflict check that they run everything through in their file? I mean, if you litigate, then you're used to this. If you don't litigate, then you're not. So yeah, listen, if you know you have a conflict, investigate it and disclose it, right? If this is an impermissible conflict, then bow out. Again, I don't know how many of you litigate heavily. It might not really come up. So as a general proposition, loyalty to a client prohibits undertaking representation directly adverse to that client without the client's informed consent. And with everybody, again, it doesn't really work in your favor if you get informed consent from one party and not all of them. So get it from everybody, get it in writing. And I like this one at the very end. A lawyer may not allow related business interests to affect representation, for example, by referring clients to an enterprise in which the lawyer has an undisclosed interest. And I guess some of that falls a little bit under RESPA as well, the affiliated business disclosures that you may or may not have to make depending on your business. Oh, wow. I forgot to put it in there. So yeah, in RESPA, under RESPA, you have to disclose any business affiliations, and the client should really sign off on it, or the parties in general. You've probably seen a lot of these or more of these in the past year if you handle residential. You've seen like Berkshire Hathaway or others. They're putting these out there with the initial contracts. Any questions so far? All right. What am I doing on time? I can't see the clock. We've only got 7 minutes left. Oh, wow. All right. All right. Conflict of interest, former client. Yeah. So this should seem pretty obvious. If you represented, if somebody comes to hire you as an attorney to, let's say, bring a case against a former client, you can't do it. You just know too much. And that's it. The same thing. This is just a rehash of it with the former client. It can't be materially substantially related. Can't have material interest in the outcome. And really, it's about what information that you've obtained from a former client that could put them in a bad or sticky situation. Can't uncrack an egg. And the maximum penalty for this violation is disbarment. Summed it up, a lawyer, you have a continuing duty of confidentiality and conflicts of interest. All that can only be waived by the client in writing. Yeah, and we're talking about what constitutes what kind of work. I think it's obvious for all of us, if you just do a client consultation for 1 hour, it's a lot different than working with a client on a matter. So if you have to analyze it, think of it like that. How much do you know? How much of that could be beneficial or hurtful to your former client? Substantially related if they involve the same transaction or legal dispute, or if there's a substantial risk that confidential information could or would be used. Right? And for everyone moving between firms, you can't undertake representation if the lawyer has actual knowledge of information protected by Rule 1.61. A firm can conflict you out or waive you out or take you off the matter. You carry everything with you, regardless if you're solo, if you're partners, if you're working for a firm. Moves forward in time. Yeah, and so it goes without saying, I think this was also pretty obvious. While everybody's associated in a firm, none of them can take on a client. Any one of them would be prohibited by it, because the firm itself is one entity. The lawyer is another. Right? But again, a lot of the larger firms have conflict checks. So a firm is broadly defined to include that a firm of lawyers is essentially one lawyer for the purposes of the rules governing loyalty to the client. The rule varies depending on the nature of the move. Are you moving private to private or private to public? Right? Okay. We're moving into joint representation. Let's see. Okay, I think we can do it. And again, the key aspects for the joint representation are informed consent. Everybody has to be informed about everything. And when there's joint representation, just remember you owe each of the parties a duty of confidentiality. This is where it gets tricky. Right? You can have them sign anything that you want, but it's the information that you obtain from each one of them that is going to bring about the rise or downfall of the relationship. So you have to keep everybody informed about everything. What happens if you've got joint representation and you find out one party is trying to defraud somebody else and it's going to affect both clients? I mean, what do you do? Because you're bound by confidentiality to keep that quiet. But you're also not allowed to let your client move forward. It's going to be a crime, right? So what do? I don't jointly represent people, right? It's the best way. You can do it, but it's very particular. Just advise everyone at the outset, the common representation is a part of the process. Get everybody to sign informed consent in writing. You have to let everybody know information will be shared. They have to understand that. They have to consent to it. I want them to sign something that says they understand that. And they have to know that if you find out something that puts you in conflict with anybody else, you have to withdraw. And really, the real reason I don't like this at the very end is that once I withdraw, there's a problem with the transaction and people start pointing fingers. Well, they're going to point at everybody, even if I didn't have control over the outcome. Right? So this is just a formal advisory opinion that just outlines what I said, that the duty of confidentiality exists between all jointly represented clients, right? So in that case, if one of the clients in the joint representation says, hey, keep this quiet, you're bound by it and you actually should withdraw according to the state bar. Yeah. I like this. This just says at the very end, just sums it up. A prudent lawyer will inform everybody and get their informed consent in writing, right? And in addition to that, when an issue comes up, a prudent lawyer will move to withdraw. All right. I think we're at, you said what, we're about maybe 3 minutes out? What are we looking at? Is that about right? All right, 3 minutes. All right, we're at the end, guys. It's awesome. It's been a pleasure, by the way. You guys are a lot of fun. Thanks for engaging. So individual versus business client. We see this a lot, really. I had to think a lot about this when putting the material together because you just see a lot in what we do. A lot of personalities, a lot of individuals, a lot of businesses, right? So who's your client? I mean, this is a really tough one. So a lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. Okay. We've all closed something with where the buyer was a corporation or the seller was a corporation. We'll take the seller example, right? You have to get if it's an LLC, you have to get the corporate resolution always for the corporation to act. Right? That should be a stockpile. It should be a document that's in every file where you're dealing with a corporate client like that. And yeah, I get on the phone right away and I tell whoever I'm talking to through the corporation. I mean, you understand at the end of the day, I represent the corporation. Now, we're all on the same team. We're all working for the same goal. But at the end of the day, this is who I represent because I have had situations where a member of the client asked questions that made me pay attention, right? So, so that's it. What do you do when that happens? Does that happen to anybody else? Yes. Yes. Right, what do? Well, run it up the flagpole, run it up you have to inform your client. Your client's the corporation. It's a lot more difficult when there's one LLC member or two managing members to run it up. But if you're dealing with an actual corporation with bureaucracy, right, and you find out that somebody that's working for them is engaging in criminal activity or fraud, run it up the flagpole. That's all. Remember, you represent the corporation. Define and make known who you represent, corporation or constituent. So again, that's in the letter of engagement if you're doing commercial stuff. So duty of confidentiality, it covers the corporation plus conversations with the constituents. Right? Constituents being, we'll say members. The word used is constituents to keep it open. And you have a duty to protect corporate client from substantial injury. Run it up the flagpole. If you find out that one of the members is doing something wrong, let everybody know. Do it in writing, CYA. All right, so look, I got 2 questions, then I'm gonna leave you. John Smith comes into your office to discuss a corporate contract for the LLC that he owns as a sole managing member. Who's your client? Should be easy. Yes, it's the LLC. Now, I just bring this up. It happened. The borrower tells you at a closing that they made some misrepresentations in their loan application. What do? Shut it down, tell the lender. Whatever the lender decides to do is what you're going to do. But that's it. So that's legal ethics. Did we meet the whole hour? Because you guys need a whole hour. All right, cool. Thanks, guys. It was a pleasure. If you need anything, my contact information is right there. Please reach out. Thanks, guys.
Talk, but she said she's getting older, so she doesn't want to talk in front of people anymore. So I'm just going to quick plug for SLTA, Southeast Land Title Association. We also work with other states. So we're in Mississippi and Alabama as well. So 3 states, we all partner together and discuss issues. We have seminars. We're doing a mid-year in March, and then we've got our annual in September. We'd love for y'all to come join us. If you have any questions about SLTA, definitely come see me. Oh, yeah, that's true.
All right, everyone, we'll go ahead and get started with our last presenter of the day. Last but not least is Lachey Calloway with Calloway Law Group. Lachey went to Spelman College for undergraduate and University of Georgia Law School. She now has her own firm, Calloway Law Group, and she practices real estate, estate planning, probate, and private equity. So very qualified to talk about transfer on death deeds.
Thank you for the introduction. Hello, good afternoon, everyone. We made it, right, to this last part. And I know you guys have a lot of questions. I heard that you were giving the underwriters a little bit of a hard time about things. And I don't know that I'll be able to answer all the questions that you had, but we'll definitely have a discussion, okay? So this is going to be a little non-conventional when it comes to talking about this statute because 1, it's very new, and 2, as most of you know, we're actually in the process of working with the original filers to get this amended. So I'm going to go through the actual sections, the actual code section first. So hold questions because when you hear some of the things, it's going to sound crazy, as you know. And then I will go through just some very brief benefits to remind us why they actually put this in place. And then we'll get to all the slides on the pitfalls and issues that were not addressed or resolved with the statute. And then after that, you guys, I'm going to open the floor for you to tell me any additional things that I don't have on this list or all of these slides. So that way I can incorporate them and present it to the original filers, because I have the pleasure of giving them a preliminary list of all of our grievances tomorrow. Okay. So this was very timely that we were doing this today. And I'm glad, thank you for everyone that actually responded on the listserv. And I don't know how many people are here from the elder law section and the fiduciary law section, but I reached out to them as well, because as you guys heard, this transfer on death deed statute is actually like the intersection of all of my practice areas. So I had to actually pay attention and figure out what this meant and how this impacts what I do on a daily basis in every aspect of it. So we'll go ahead and jump in. All right. So this is the outline. We're going to, like I said, go over the actual statute, the code section, brief benefits, open issues, pitfalls, precautions. And that's if after this presentation, you still choose to move forward and do a transfer on death deed before it's amended. These are some precautions that you should definitely take into account before doing it. And then, you know, the lively and spirited questions and discussion that I'm sure we'll have. All right, so what is it and what it's not? So what it is, effective July 1st, 2024, Georgia now allows property owners to execute a deed that will transfer their interest to a certain person or people upon their death. This property will pass to the intended recipient upon their death and outside of probate, allegedly, as long as certain requirements are met. Okay, that's what the statute purports to do, right? What this is not, I know a lot of us are familiar with ladybird deeds. This is not one of those. This is not a life estate. Grantor retains full interest until they die. Ladybird's transfer is, how this is different is transfer is not automatic upon death, and it is revocable. Most ladybird deeds are irrevocable. Must be claimed with proper steps, our transfer on death deed. So minors, this is not a great tool to transfer real estate to minors, because minors do not have legal capacity to sign affidavits or transfer title to real estate. You will have to go through the process to appoint a guardian to redeem the property, and all of that must be done within the 9 months after the grantor's death. So it's not ideal if someone asks you, you know, or says they want to put a minor on there. This is not the instrument for that. And then again, this is not automatic. All right, so our code section review. So I did a summary, and you guys are going to have access to all of these slides, including the, you know, slides full of pitfalls and things to be worried about. So these are summaries of which each code section said. I also have included with the materials the actual code sections in one PDF, so you can just scroll through them. And if we need to have, if there are any specific questions about that, I can pull them up as well. So the summary, so 44-17-1 actually provides the definitions and confirms that this is referring to real estate and defines joint owner for the purposes of this statute. 44-17-2 provides the elements needed to effectively create TOD, that's what I call it, clarifies that a beneficiary does not have to affirmatively accept this before the record owner dies for it to be valid, provides the steps beneficiary must make to claim the real estate provided in the TOD, and provides the 9-month deadline to claim the property. 44-17-3 provides a template of the language TOD needs to contain. When you read the actual document, and I'm sure most of you already realize this, language in this template confirms that it must be a limited warranty deed and cannot be a quitclaim deed or a warranty deed based on the warranties that it provides in this actual deed, in the template. Very importantly, it also clarifies that this deed must be recorded before the death of the record owner, so before the death of the grantor. So I know we're used to, if, you know, you can record a deed at any time, regardless of whether the person has died or not. This is not, this won't be effective if you do that. The next code section is 44-17-4, which is the revocation or amendment of the section, so, or of this deed. So Part A provides how the record owner can revoke a TOD anytime before their death. Pitfalls: the need for 2 unofficial witnesses, and 2, the revocation doesn't have to be an actual TOD saying that it's revoking another one. The revocation can merely mention in another deed, and it doesn't clarify what kind of deed, security deed, warranty deed, who knows, that it is revoking the TOD that's already filed. And in order for a revocation to be valid, you have to have 2 unofficial witnesses. But if you have, in addition, 2 unofficial witnesses. But if you have a security deed or any other warranty deed, you only need 1 witness. So is that revocation even really valid if they mention it in another deed? So the fun begins. 44-17-5, beneficiary rights, beneficiary predeceasing grantor. A provides the elements needed to effectively create the TOD. B clarifies that a beneficiary does not have to affirmatively accept this before the record owner or grantor dies for it to be valid. C provides the steps the beneficiary must take to claim the real estate provided in TOD. And D provides the 9-month deadline to claim the property. And I'm sorry, I just couldn't read it that far away from me. So that's why you guys see me reading this on my phone. We are on 44-17-6. So we're almost through the code section. When there's a joint owner, and explains that a joint owner can file a TOD, but the beneficiary will only get the property if the joint owner that filed the deed dies last. Yep. So it's the battle of who lives the longest. This also clarifies that a TOD executed by a joint owner will not sever a joint tenancy. So that's one thing that they were very clear about, which, you know, we'll say that that was good. 44-17-7, limitations, provides the elements needed to effectively create the TOD in Section A. B clarifies that a beneficiary does not have to affirmatively accept this before the record owner dies for it to be valid. Oh, I read this part. And then C, the steps that they must take to establish it, and D, provide the 9-month deadline to claim the property. So we are now to the brief slide on benefits. 4 bullet points. So this passes, allegedly, it passes, or I should say, the intent is that it passes outside of probate if it's done correctly. So that's good for what they were trying to accomplish here. Transferring this way preserves the step up in basis as opposed to adding someone to title. So that's a benefit. That's, you know, pretty good. It's great for very simple estates where you have the pay on death beneficiary with the bank. We're just going to transfer the vehicle with the title to the vehicle, and now there's a way for them to transfer their property the same way. Very simple. You don't have to do a lot of things. You really wouldn't have to do probate based on that. So I think that was ultimately the intent here, to why they put this in place, to help those particular clients or that part of the population. Obviously, there are other people that want to use this in different ways, but that helps when you have a pay on death beneficiary bank account, a beneficiary with your 401k, and then now you have a way to do it for your house. And then also, even when there would be contention, this is great for a grantor that wants a specific property or a specific person or people to get the house without anyone being able to contest it in probate. Now, obviously, that's if they redeem it properly, but when we all know the families that have a little more contention than the others, and this is a good tool for them to use to make sure it goes to whomever they want to. The way it's currently written, I would have it as a backup to make it ironclad. I would not use this by itself in order to do it though. So, all right, open issues, pitfalls. All right, so the current Todd statutes expose drafters, meaning us mainly, to malpractice risk because they will rarely work as intended. And there's a high probability of, I'm sorry. There's a high probability of placing grantors and beneficiaries in costly, complex situations rather than the simple and affordable solution that was intended, right? Here's a high-level list of items that need to be resolved before the TODs should be used generally instead of rarely in extremely limited circumstances. So unofficial witness. We already went over this part in the statute. One unofficial witness and a notary is needed to create the TOD. However, two unofficial witnesses and a notary are needed to revoke the TOD. Proposed solution, make this consistent. So what I'm going to put in the list is we should only need one to revoke it as well, one unofficial witness, and that makes it consistent with all other deeds and when you created this particular deed. Anybody have any qualms with that? No? Okay. All right, revocation. Revocation of the TOD can be merely mentioned with any other deed and it's considered revoked, but this other deed still needs two unofficial witnesses and a notary to effectively revoke the TOD though. Will that really happen? This is part of the statute that will cause an extreme amount of confusion. So proposed solution, remove the ability to revoke this in the context of another deed. Okay. Correct. Yeah, just keep it clean. Yeah. Petition for years support and Medicare liens. Does the statute take precedence over petitions for year support and Medicare liens? Proposed solution. The statute needs to definitively state this one way or the other. Right now, we can only infer when it comes to the petitions for year support because this is supposed, if the property is redeemed within the 9 months, the property never made it into the probate estate, which means the family members that are filing it wouldn't be entitled to this, right? But it's something that we can infer. I'm sure litigators are loving that it's inferred and not definitive. And we just want to make sure that we know what it's supposed to be before we actually let people go out here and start. Right. So in the code section, I'm glad you asked this question. So technically, funeral expenses and expenses of the estate are not expenses of the person because they are dead. So they can't incur any more expenses. So the statute says that they are supposed to, all of the debts of the person are still attaching to the property. Correct. Or any liens that are on the house before they die, that's fine. Anything after they die, that's a part of the estate that doesn't attach to the house. Allegedly, what we can infer from how they wrote the statute. But this is what we need them to confirm, right? But that's the distinction between funeral expenses and now Medicare liens is also very interesting because technically the way that Georgia's Medicare liens are set up, they are supposed to be able to attach the lien before the person passes away. But I had another attorney, Patricia, she informed me or us that Georgia doesn't do that though. So that's another gray area. Even though they have the authority and ability to do it, they very, very rarely ever do that. And that's, yeah. So that's where, that's what we need to know. and how that's supposed to work. Yes. Uh-huh. No. Do it within the 5-year period, right? The look back period. So again, that's why we need more information on what the filers actually intended. And then Medicare, Medicaid, they're probably going to have to say something as well about whether they're going to consider this an avoidance. Right, and we don't know yet, right? So, because it's a very good question, we don't know if this is a way, a legal way to still do it within the look back period. Mm-hmm. 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 Right, but that's again, something that the filers are going to have to explain or, put in the statute so we can answer that question going forward. And like I said, it's probably going to have to be the state or the federal, people to get involved and say how this actually impacts what they are going to do and how they view it, because we as practitioners can't really answer that question, right? And we can't advise, this is yet another thing, we can't advise clients right now because we really don't know how this is going to play out, because we need more information, unfortunately. So, any other questions about that before we go to the next one? Yes. So you can only give, like, once they pass away is when this deed is effective, right? So if you don't own it when you pass away, it can't be effective. It's kind of null and void on its face, right? No, the other way around. Yeah, because if you can't yet, you don't own it anymore. So it's right. It's only effective once the person dies. So if you own it when you die, then it goes to that person. If you don't own it when you die, it doesn't go to that person. Same way when it said joint tenants with rights of survivorship, the last one who dies wins. Same principle. Whoever owns it at death. And so if you pass away before your husband, you won't own it at death. Your husband does. Yes, ma'am. It's actually, that's one of the things here, because that is not answered. So it's something that needs to be, and I mean, I have quite a few questions about that. Like, so let's go to, we're on unofficial witness exemption. All right, so PT 61s, fun topic. We all know these are being handled inconsistently across the state. As of right now, we don't even know how the tax office will know that to transfer ownership of the property to the intended beneficiary when the affidavit is filed, since you don't file PT 61s with affidavits. So, proposed solution, statute should state that PT 61s are not filed with the original deed, not with the TOD, and are required to be filed with the affidavit. This will eliminate the confusion, because I don't know how many of you have experienced this, but I actually heard of a situation where a first-time home buyer was rejected by the mortgage company as a first-time home buyer because the tax assessor's office said that they were the owner of this property from a transfer on death deed and the grantor was still alive. So obviously they have to work through that to get that, show them that they don't own this property. It's not theirs yet, but like, these are the the law of unintended consequences, right? This is what's happening when because the statute isn't clear, right? I think I saw a hand, somebody have a hand? Okay. Mm. So you're saying the PT 61 should still show the same, whoever the grantor and whoever the beneficiary is? Yes, but so what you're saying is the PT 61 should say from the grantor to the grantor, not the actual beneficiary. Whether they will do that correctly, because when they look at the deed, because I talked to a few tax assessors and they explained the process. So when so this is why I'm really confused on why there's so much inconsistency across the state, because the alleged practice is supposed to be there's a report whenever there's change to title that goes to the tax assessor's office, and it's like change of ownership. And the tax assessor's office, within their department, they're supposed to review that report and review the actual deed to see if there really was a change of ownership, so they can update the name and address on the report, on the tax bill. They can, change homestead exemptions, all of those things. So that's the process that's supposed to happen, but it sounds like there are quite a few tax assessors' offices that are not familiar with the transfer on death deed to know that it doesn't actually transfer ownership yet. And that's something that's supposed to happen later. So I say, even if there was a PT 61, doing it your way, grantor, grantor, grantor and the grantor becomes the grantee as well, just so they can have notice. It seems like that's still going to leave it with the same issue, because they're just going to update it and say, oh, the PT 61 was done wrong, and this is supposed to be the new grantee. But if they're right, but we could leave it the same way it is right now for that way. Yeah. Mm-hmm. Is a deed. Yeah. Which is different than the affidavit that you have to do for this. Right. Like the affidavit of descent is actually a disease. It should, but are we doing that? I mean, right. Correct, because that instruction needs to be in there. And obviously the Department of Revenue needs to include the drop-down menu for transfer on death, because that might actually help the tax assessor's office categorize it correctly too. So I think out of everyone in this room and the legislators that we're going to talk with, the legislators probably have a little more pull than we do with the Department of Revenue, and maybe they can get that done quicker or sooner rather than later. But how many people feel like, because I don't want to say this and it's not how everyone or a majority of people feel about it. So in this room, would we prefer that the PT 61s are not filed with Todd, like the actual deed, or that they are filed with the Todd? What are show of hands for the people that want it filed with the Todd? No, so the affidavit in the beginning, how many people want it filed in the beginning? Okay, and then the people that want it filed only when it's being redeemed. Okay, so I'm going to discuss it with the legislators and see which one, like they'll put it in the statute because I see that it's kind of split down the middle about which way people want to do it. So I won't say that this is a thing that we should do. I'll just say these are the options. And then, they can actually get with the Department of Revenue and make it work. Yes, ma'am. Mm-hmm. And not change it. Yeah. Yeah. He had his hand up first and then I'll come right back to you. Yes. It's coming up in the next slide. I know where you're going. It's coming up in the next slide. I already know where you're going. Yes, sir. Right. I know. It's not just in the rural areas, trust me. Yep. Right. So that's one of the reasons why you're pro only when the affidavit to redeem is there. Yeah, no, I think that it causes way more problems to do it for both or, in the beginning. But like I said, I understand by the show of hands, it was kind of split. So I will just say these are the pros and cons of each way and see what, we'll let them decide at the end of the day. All right. So, so that was PT 61's notice. So there's no notice required in this statute at all for anything at any time in anyone's life, right? But clearly we need something somewhere for this to even work, especially if the intended beneficiary is someone who's not close to the family, but may have been close to the grantor. And so there's currently no notice requirement for Todd, but how is the intended beneficiary supposed to know that? One, they are a beneficiary. Two, the grantor has died. And three, they have a time limit to file the necessary information to redeem the property, and among a whole bunch of other things. So proposed solution is the statute needs to include a notice provision. Now, any ideas or suggestions on what kind of notice you guys think you would like to see? Yes. When the person dies? The grantee would, yeah, they're not. But it's still like, how are they going to know when the person dies? And that their time period. So yes, especially if you're doing this now, even though it's not required, you probably want to impress upon the grantor that the beneficiary needs to know and that they are a beneficiary, period, full stop. And then let them, figure out how to make sure that they are going to receive notice. So, I'm saying that there needs to be a notice provision. If there is an estate, a personal representative set up, then maybe they are charged with providing notice to anyone, like they have to run title, which is a couple $100s. And if this transfer on death deed shows up, they have to let the intended beneficiaries know. That's one way. But we'll come back to the fiduciaries, things. But so I don't know how filing a PT 61 will give notice that the person has died or give notice to the beneficiary, and that they have a time limit. Were there any ideas or suggestions on what we could tell the legislators to include? Yes, ma'am. So when you say the grantor, when you said filing the affidavit, you mean filing the deed when when? Mm-hmm, mm-hmm. Mm-hmm. That's beneficiary, mm-hmm. Okay. How does everyone feel about that? Yes, ma'am. That's another way to put it on the grantor. Yes, ma'am. You had your hand up and then I'll come to you. Yes, yeah, you had your hand up. Right. Right. Yeah, depending on how many years. Right. Go ahead. Yes. Yes, agreed. And that's why the notice is a thing. Yeah, yeah. So then I think because I know there were a couple of, quite a few people voiced concerns about the 9 months. And, there are two reasons why that matters. And I think it's coming up in another slide, so we can come back to that one. But so the notice, the 9 months, it comes down to the foreclosure statute. The foreclosure statute is 3 months. And if someone isn't paying for the house or the mortgage payments, then they need, or I should say, if someone is making those mortgage payments to prevent the house from going into foreclosure, because you have 9 months to redeem it, but there's only 3 months before they start the foreclosure process, should whomever is paying the mortgage have that burden forever until that, like, it expires so that they can actually get the house and put it into the estate? So I think that's part of the reason why we still have, there is a 9 months, because I did look at Texas, their Todd statute, very comprehensive. I included it in the material so you guys can see what other states are doing and how comprehensive and all of the things that it addresses. And even practitioners in Texas are still like, and this still has room, to have work done, but theirs is way extremely robust and comprehensive. So but in Texas, they have 2 years to claw back something. Correct, right, which of course we don't do that here, but I think that's why there is a time period, because it's keeping in mind that it does lapse to the estate at some point, and you want to put a time limit on how long that should be. So I think that's why there's a time period. I thought I saw one more hand. Yeah. I I don't know the answer to that question. I'm sure someone's going to try it and we'll find out soon enough, but I don't know the answer to that question. Like if that, like, I understand what your argument is and, what the requirements are for, a will or a testamentary type of document. So it's arguable. I'll definitely say that. Yes, ma'am. I can't hear you. I don't think there's a independent, overt notification to the grantee. Typically when the grantee is, they know what's happening. So like it was a closing or something like that. So, or, someone signed a deed over to them. So, mhm, as the owner of, right, because they're the grantee. Exactly. And that's why, one of the reasons why I said personal representative, that's one reason. Two, that is like, if we're talking about, the indigent part of the population who, even though they can file a pauper's affidavit to go through probate, do they even know that? Right. So are they going to probate? So it's still will they actually probate anything? And yeah, there's still that gray area. If this is the intended audience, target audience, how do we make this work for them? Because there probably won't be a personal representative for the estate. So that still is, kind of the same question. Yes. Do it. Someone died. Right. Or the grantor. So in the beginning, the notice requirement is that, and we add that language to the deed saying it has a 9-month requirement to redeem. These are the steps that you have to do to redeem, because you might as well include that. And then in addition, the beneficiary has to sign an affidavit saying that they understand that they are the beneficiary and these are the steps that they have to do. And it's their responsibility to know when the grantor has passed away. Yeah. Um, But it's just one of, I think what the suggestion is if you're going to sign this affidavit saying that you agree you're going to be this beneficiary, you then take on that responsibility regardless of where you live in the world. And if you do become incapacitated, you have, like, this is out here where you're not incapacitated. So you need to include that in your documents or your conversations with loved ones or whomever you're appointing over your affairs, that this is something that we need to keep up with. So that's on here. So like I said, we have plenty of slides. Yes. Yes. No. So, because you can revoke them. So like, it's just like anything else. Is there, right? You can revoke as many wills as you want, right? I don't think. Okay, so I actually don't think that you can do it like that, but I think that that's something that's not specifically defined in the statute. So we should add that. That's a good point. Like, that has, like, right. Yeah, yeah. No, I understand. Yeah, I think it's a good question. So I think that's something that I'll add to this slide. So that's good. And I like the suggestions on where we put the onus of the notice. I like it. It's gonna go in there. So anything else before we move to the next death certificates? Next topic of death certificates? Okay, so right now, there are some attorneys that are apprehensive about drafting this if the intended beneficiary is not a family member, like a direct family member, because it's hard to get death certificates unless you can prove that you are a legal representative or a family member. So the proposed solution is that the statute needs to state that beneficiaries under Todd are designated as interested persons who have a direct and tangible interest, so they can receive a copy of the death certificate and file it with the affidavit. Does anyone have any issues with that or see any pitfalls with that? Okay, so I know you guys want to get to personal represent. Oh wait, okay, yes. The Todd. Right. It's a good question. Yeah, so probably a title search confirming that you're still the owner. So the Todd and the title search. So no, like right now, like if they have the Todd, yes, it would only give them access to the death certificate, but the way that they have it set up, they don't want anyone that's not an interested person or has a direct interest in the death certificate to receive a copy of it. And if the Todd was revoked, then they wouldn't qualify for that, right? Because we don't know, people are crazy. We don't know what they're doing with death certificates, fraud and, all of those things. So, well, I think when you're an interested person and not a legal representative or a family member, they're going to not give you the social security number. That's already going to be blocked out, which you don't need that to file the Todd. But so adding a recent title search within a certain amount of days as well to present the Todd in the statute should address that. So, okay. All right. I like it. All right. So Um, let's see. So personal representatives, yes. In order to get the death certificate. So then it's going into, I mean, yes, probably like that'll make it easier for if someone is signed, like that'll make it easier on the Department of Vital Statistics or, whomever is looking at it. There's a Todd, here's an affidavit signed by an attorney. It's just, yeah, I think that could work, but yes. The fees. I know, that's actually, no, that's, right, that's actually, when she said it, that's what I was thinking of. I was like, the fees to pay for the title search, to do a title search, a couple $100s, but then for the attorney, will the attorney actually just draft it with what they were paid for the title search? Definitive answers. We have definitive answers. So yeah, so are there any other suggestions? Yes. Okay, but who is it? Who executes it? Mhm. Right. It cuts. Right. So I think, like, I definitely understand that. And that's something that is certainly going to be an uphill battle for this conversation with the legislators, because obviously the intended target audience and, just adding all of these additional costs. But if you have someone who didn't know that it was, because like if they sign a statutory affidavit, that's fine. But should they still be required to have a title search done in order, like in that affidavit, it says I had a title search done and I can certifying that I am still the owner of this, the intended beneficiary. Yeah. And that's a valid, that's a valid argument, a valid point, but we need to put something in there so that they can get a death certificate. And we don't want, because someone can revoke it and, depending on what the answer is about how many of these Todds people can, like Oprah, you get a car, you get a Todd, you get a Todd, you get a Todd. We might need something a little more, with a little more teeth, to make sure that when you go to get this death certificate and file your affidavit, like we had that check there, that at least that it was done. Yes. So currently they can't get a death certificate. Someone who's not a family member and someone who's not an attorney can't get a death certificate. It says interested person, but how are they going to prove that they're an interested person without the Todd? I think that if they don't address it in the statute, that the people at the Department of Vital Statistics aren't going to know what a Todd is, and they're not going to recognize them as an interested person. And then what happens if someone has revoked that TOD and the beneficiary doesn't know. I think, yeah, but the deed, if you're saying they don't have to do a title search, who is going to do the deed search? But then the 9 months, like, so they've redeemed it, the 9 months have elapsed, and the potential estate that could have had it, because the correct beneficiary didn't redeem it, didn't get it. Yeah, so I'm wondering, maybe this is to piggyback on a suggestion that we already are going to incorporate when we say that the grantor and the beneficiary has to sign this, affidavit, say the grantor saying that they have informed the beneficiary says that they are informed. The grantor, and especially if they're revoking, they have to include that they informed the prior beneficiary. So we just include that into the revocation part of the statute. Okay, then all they have to do is show up with a TOD because they would have received notice. And yeah, so maybe that's what it is. And then the next potential or the next person who was a beneficiary should actually have received notice and they know that another one was revoked. So then there will be two people that's enough notice to both beneficiaries. So where one of them can say mine is, later in time and yours was revoked because they'll have that new one that, with the context of the revocation. Okay, all right, yes. Yes. So we always redact things in their deed records because there are people that have stolen information from the ones that were not redacted. So that's why that law changed. So that's why you don't want people that shouldn't have access to the death certificates to give access to the death certificates because there is pertinent information that has to be redacted in order for it to be for it to be recorded. Yes. Okay. I will definitely offer that as a suggestion. I know that we're getting short on time and I know we carved out, for the happy hour and everything. And the ones on this power of attorney, so incapacitation and personal representatives, I know this was something that people wanted to discuss. So let's go ahead and jump into this. So personal representatives, who is responsible for the mortgage if the property is not redeemed right away? It's technically not a part of the probate estate yet. Does the PR let the personal representative let it go into foreclosure? The foreclosure statute of 3 months and the redemption period of 9 months leave personal representatives exposed to liability for a breach of fiduciary duty. Like if ultimately the property does go to the estate and then it went into foreclosure, then the beneficiaries of the estate or the heirs of the estate are going to argue that they should have preserved this, but knowing that this could have been a possibility. So proposed solution, statute needs to provide instructions on, let me see. Statute needs to provide instructions that estate is responsible for mortgage payments, property taxes, and any repairs that renders the house in imminent danger of being destroyed until property is redeemed. Estate is entitled to repayment of expenses incurred until the property is redeemed, and estate receives a priority lien against the property for any amount that is not refunded within a certain period of time. That's a proposed solution. What are your thoughts? Because we don't want people paying all of this stuff, you know, and then they never get reimbursed for it. Like the person comes in at 8 months and 28 days and redeems, and they're not responsible for that. And then it's how do they get repaid for it? Yes, ma'am. It does. Right, I understand. And so this is, we can make that clear, you know, to the extent that there is money in the estate to pay for the mortgage. Because if there isn't, the house was going to go into foreclosure anyway. Or, you know, but when the house is going to go into foreclosure anyway, that's when they typically sell so that they can get money into the estate. So then it's a question of, you know, if someone hasn't redeemed within the 3 months before the, you know, foreclosure statute kicks in. No, I actually said that they were gonna sell it. So like they were gonna like, so yeah, they were gonna sell it so they don't lose it. And so that way they can actually get the money to the heirs at law. Right, okay, so two separate things. You asked a question about what if they don't have enough money to pay for the mortgage? So we're only talking about that right now. So, and then I said, you know, if they don't have money to pay for the mortgage, it was going to go into foreclosure anyway. And then I said, but typically they won't let it go into foreclosure. They will sell it so that way the money can go into the estate. And then we said, so what we'll probably say is there's up to 3 months, if no one has redeemed it and there's not anyone, the estate isn't able to pay for it, then it needs to be sold. And then maybe the money is held in escrow until the 9 months, well, the additional 6 months expire. And then if it doesn't, no one ever redeemed it or came forward, then that's when the money goes to the estate. That's probably the better way for the people that aren't able to afford for the mortgage. So putting in both of those, like if they can pay the mortgage, this is what they're entitled to. If they're not able to pay the mortgage, this is how this works. That's why we said the escrow amount. The escrow accounts for that 6-month window. Like if we have to sell the property because it's about to go into foreclosure and no one could afford to pay it. Right, well, yes, so we're going, instead of everyone losing everything, we are going to go ahead and get it sold, pay off the mortgage, and whatever's left goes to, you know, is going to be held in escrow. And that either goes to the intended beneficiary as long as they redeem it or come forward with it, because I guess they can't redeem it anymore, but they come forward within that 6-month window that they have left. And if they don't, then it goes to the estate. That's how we're accounting for that. Yes. That's why it would have to be in the statute to say that they do. That's why we're saying, so we're going to put it, yes, like, so we're going to say for when you have this situation, the personal, like you have 2 options. If the estate can afford to pay for it, this is how they will get reimbursed until that 9 months expires. To the extent they aren't able to afford it and it's about to go in foreclosure, this is what happens. And if it's in the statute, then they do have, that should, you know, we'd have to work with the probate courts and the judges and get them on board about what this statute means for the probate estate and having the authority to actually sell in this limited instance, right? Yes, ma'am. Mm-hmm. Are they sending a notice to the beneficiary, intended beneficiary? Right. What is everyone's thoughts about that? Because what are everyone's thoughts? Okay. Uh-huh. I know, yeah, right, there's always that competing, yeah, yeah. Yeah. Oh, yeah, that was the first part. Yes, if they're, that's what's in the slide. If they do pay anything, they are reimbursed and it gives them a lien, right to put a lien against the property for anything that isn't fully refunded. Okay. The next one is powers of attorney. The statute is silent on whether a POA can execute a TOD on behalf of the grantor and whether a POA can redeem the property on behalf of the beneficiary. So statute should indicate whether either of these things can happen. What are everyone's thoughts on whether we want to allow? I'm getting a lot of thumbs down. Whether we want to even say that we want them to have the ability to do it with a POA, to redeem or create. So, Tamara. Okay, so that's one argument for just for the redemption part, not the actual. Okay, yes, ma'am. Mhm. 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 Right. The form allows it. Obviously, this wasn't in existence when the form was created. So that's where the argument, people are wondering, does that statutory form really apply to TODs? And so but I understand you're saying even if that shouldn't be revoked. But you're arguing that on behalf of the grantor, right? Or just. Mhm. Mhm. Right. No, Tamara just said that one for the beneficiary. Mhm. Yeah. Mhm. 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 Right. I understood that you were mentioned that about the beneficiary. I was asking, do you feel the same way about the grantor as well? Okay. Yeah. All right. So yeah. So this is for the people that are in the country, like, the rural parts of the state, CUVA exemption. I was not very familiar with this, but I did have a conversation about it, and I understand that's pretty important and that it could be triggered, or they could lose that exemption with the TOD, with this doing a TOD. So I added this as well to kind of cover those people so they don't have to worry about losing that. And so I just said that the statute should state that the transfers made via TOD do not exclude parties from the CUVA exemption. Yes. Okay. So if by all means, you can email me and give me like a better way to explain that, because that isn't really in my wheelhouse. So I'm not familiar about the ins and outs of it. So I want to make sure that I communicate it and convey it correctly for what you guys actually need. I just wanted to put it up here so you saw that it was something that I was aware of, and that I want to make sure that it does address for you guys, because I understand it's a pretty big deal. Okay. All right, so those were all of the, well, all of them, the quick list of pitfalls that I had. Oh, nope, sorry. Death of a beneficiary during the redemption period. The statute is silent. What happens to it, right? So right now, I say the statute needs to provide guidance on all of these issues. And so I said, if the beneficiary dies during the redemption period, does the beneficiary's interest lapse, or can it be inherited per stirpes? Is the beneficiary's interest assignable? Can a beneficiary leave their interest in the property that they're going to receive to someone else through a testamentary instrument? And we don't know any of these answers. So these are things that we need to understand. So we, especially for the estate planning and fiduciary side, like what are we advising and how are we advising the clients with these interests? Capacity of the grantor. So we already talked about, it sounds like most people do not want the grantor to have the ability to draft this deed via a POA. But there's the argument that the current POA already gives them that authority. So, and that shouldn't be revoked. So I just said that the statute needs to provide definitive answers on which standard applies with this particular deed, because this goes back to whether we were gonna say that, can you record this as a will at a later time? But what is the capacity of the grantor when they draft it? Do they only need to have the capacity that they would need to make a will? Or do they need the capacity that they would need to make a contract? Obviously, all of our other deeds are based on contract law. But for this particular deed, is there an argument that is a lesser standard? And, we probably don't want that. And so if we don't want that generally, we need to make it clear that this is the standard that you need in order to draft this, this particular transfer on death deed. And then trust as a beneficiary. Can a trust be listed as a beneficiary? And so the statute needs to definitively answer that question as well. Yes. Good point. Mhm. That is actually in the statute, that their interest lapse, and it doesn't, it's not per stirpes. That's in there. Yeah, keep it consistent, but they need to explain that that's what happens. Yeah. Okay. So precautions, if you still choose to do this. Like you need to have, like, the short of it is, let me see, hold on. You still choose to do this. I tried to be nice because I'm actually going to send this entire presentation to the legislators so they can see, all of the things. I'm going to add the stuff that we talked about today as well, to it as well. But so precautions, this is new and updates are desperately needed for this to be as effective as intended. I would only use this in very limited instances until the statute is amended. 2, the short of it is, have the best CYA letter you've ever written or drafted in your life. You have everything, like maybe make check boxes for them to check with the statement saying that you went over every single thing. And make sure you follow all of the steps that are listed, because obviously missing any one of these steps can render the entire thing invalid. And there's already enough issues with this without missing the steps. And just remember that this is not automatic transfer at death. I would not use this if they're with anyone that is possible. It could go to a minor. Like, that's just, I don't think that's even an option with this particular deed, regardless of how it's written. And then we made it to the actual questions and discussion. So, what do you have? Any other things that you guys want me to include? Yes. Yeah. No, that was it. Yeah, but that's enough for the people that just have the pay on death for their bank account. They do the affidavit and they get the vehicle. Yeah. Bo, did you have a question? No. Yes. You're welcome. Thank you.